Well, good morning, everyone, and welcome to One Civil Law. Hope you're having a great day. We are tuning in to watch Mr. Proctor, if you please. Mr. Proctor appeal his dismissal from the police force for so many reasons that they did, and also the many reasons they didn't tell anyone about. But, you know, he got fired technically for an instance of driving drunk in his police car, or driving intoxicated at least, or driving after having drunk. And then he got fired for the text messages related to Karen Reed. And I think there was some other stuff in Karen Reed. He got fired for what, like it was 3 or 4 technical reasons. And like 2 or 3 of them related to Karen Reed, and one of them was technically unrelated. And he would like his job back. And not so much, probably no. I don't have a lot of high hopes for him on this, but you know, good luck. Long story short, the basic principle here is that because he has a government job, well, not necessarily because, but he is entitled to due process because his job is property. So he has a property interest in his job. And so for the government to fire him, they need to provide him due process. Now, what due process looks like is, of course, different than a criminal trial because he's not being put in jail, right? They're firing him. So it's not up to the same evidentiary standards or the same rules of evidence as a criminal trial. He is entitled to a process involving hearing and his ability to offer evidence and, you know, have other people provide evidence on his behalf. He can't compel witnesses, but he can have them provide. And he had all those opportunities. And the commandant, the head of the department, said, you know, well, not so much. I'm terminating your employment now. And at least on paper, you know, it looks correct to my eye. So maybe there's some sort of T they didn't cross or I they didn't dot, but I doubt it. It was pretty high profile, so I would imagine the police force took its time. And he is apparently still within the administrative aspects of his job termination, because we're not in a court, I don't think. Where it looks like we're still in some sort of hearing. So he is currently in the process, I guess, of exhausting his administrative reviews, which, you know, given that it's the commandant who fired him, yeah, good luck. And then I suppose after that, he could go to court and also good luck. Because the courts are not going to second guess the administrative decision unless they, like, fucked it up. Right? As long as they followed the process, the courts are not going to second guess the conclusion, right? He's entitled to basically, as I sort of said already, he's entitled to due process as that is prescribed for what he did. And assuming they did all those things, which I'm going to assume that they did, the courts are not going to second guess the process because, you know, burden of proof or some other reason. So I don't have a lot of high hopes for him, but, you know, go forth, my friend, and make more of an ass of yourself, I guess. I'll let you know if it gets any better. I'll let you know if it gets any better. Somehow he has some sort of argument that is not obvious, or he makes some sort of clever. Maybe this boils down to some sort of really precise technical argument. But if it's hyper technical, not so much, right? If it's like, oh, you know, they were supposed to do A before B and they did B before A. Probably not. So if they skipped a step, or the step was illusory, right? They didn't really do the step. They just pretended to do the step. That maybe. If it's like they skipped if they skipped a sub step, or they did things in a different order, probably not. So if they have a technical argument, okay. If it's hyper technical, probably not. Basically, in order for him to win this, they would have had to fuck it up pretty hard. Which, you know, to be fair, it is the state police of Massachusetts. And apparently the Massachusetts State Police fuck a lot of things up pretty hard. So I suppose we shouldn't be that incredulous. I suppose I need to revise basically everything I've said up to this point, because it's like, oh yeah, wait a second, no. I'm talking about the Massachusetts State Police. And basically my argument so far has been one of incredulity. That's basically been my argument so far. Can you believe the arrogance on this guy? I mean, the only way he wins is if the Massachusetts State Police fucked up. And then I'm like, oh wait. Oh no, wait, no. That definitely could have happened. So we'll see. We'll see who fucked up and how hard. Maybe he has a better argument than I'm giving it credit for. Yeah, because my entire argument basically has been anchored down to surely the Massachusetts police didn't fuck it up because it was such a high profile case. Like Karen Reed. Oh wait, no. They totally fucked that up. Oh, yeah, right. No, never mind. Never mind. Okay, maybe he's got a decent chance after all. All right, we'll see how it goes. Yeah. Exactly. Yeah. No, Brad, you've caught me. You've caught me. My argument was based on competence and assuming that the state police in a high profile matter would actually, you know, like follow procedure and stuff. These assumptions were not predicated on anything. My axioms over here are not really that great. Yeah, sure. Anything can happen. Who knows? Okay, great. It's likely they fucked up. You know, that's fair. That is fair. Yeah, no, you're making pretty good arguments. Yeah, my argument was they didn't fuck up, and your argument is they probably did. And I'm like, oh yeah, no, that's yeah, okay, yep. That's a pretty good counter. I was like, my argument was not and you're like, and I'm like, yeah, no, that totally could have happened. All right, fair enough. That's where we are. Oh, Lord. He was driving drunk in his patrol car. I am aware. I'm aware of the allegation. I'm aware of the reasons they fired him. Yeah. Well, not necessarily drunk. I don't remember if it was driving drunk, but driving after having drinking in his patrol car was one of them. And then the text messages, and then the leaking information to someone who like is a civilian. And I think there was one other thing that I can't remember. But yeah, those are the technical reasons they fired him. And then there's like other things that they didn't put in the report, I'm sure. Do we have audio? Or no? Do we believe in audio or no? What are we doing?
My name is Angela C. M. C.
Okay, I don't have audio, but there's audio.
I am a commissioner for the Massachusetts
Let's see if we can fix it.
Service and the General Counsel of the Commission. The time is approximately 9:30 a.m. on August 26, 2025. This first day of hearing is being held in person at the offices of the Civil Service Commission at 100 Cambridge Street in Boston, Massachusetts. Additional days of hearing are scheduled for tomorrow, August 27, 2025, and later this year on October 21st, 22nd, and 23rd. I am the hearing officer.
We're dragging this thing out into October? Why?
For today's appeal, filed with the Civil Service Commission on March 27, 2025, and docketed as case number D1-25085. The appellant in this matter is Michael D. Proctor, OCTOR. At this time, I ask that co-counsel for Mr. Proctor please stay seated and introduce yourselves and spell your names for the record.
Good morning, Madam Commissioner. Daniel Moynihan, Attorney Daniel Moynihan on behalf of Michael Proctor.
Thank you, Mr. Moynihan.
Good morning, Commissioner. Mark Russell, M-A-R-K-R-U-S-S-E-L-L, on behalf of Michael Proctor.
Thank you very much, Mr. Russell. The respondent in this matter is the Massachusetts Department of State Police. At this time, I again ask that counsel for the department stay seated, introduce yourselves, and spell your names for the record.
Good morning, Commissioner. My name is Stephen Carley on behalf of the respondent, Massachusetts Department of State Police, S-T-E-P-H-E-N-C-A-R-L-E-Y.
Who is with you today, Mr. Carley?
This is my associate, Pamela Rottenberg.
Can you spell your last name for the record?
This is already not off to a great start. I'm not going to make it. I'm not going to make it. There's no way. I can already see it coming. I'm going to rage quit this hearing out of combination of boredom and stupidity. I'm not going to make it. All right. At this point, I feel like the mods need to start an over/under poll on how long I'm going to make it before I rage quit this thing. I wouldn't give me high odds, man. Holy shit. Okay, fine.
Record?
It's R-A-U-T-E-N-B-E-R-G.
Thank you, Ms. Rottenberg. Thank you, Mr. Carley.
Madam Commissioner, may I also introduce my associate,
Yes.
Zachary Green,
Thank
from our
you.
office.
And spell your last name, Mr. Green.
G-R-E-E-N.
Thank you very much, Mr. Green. This appeal was filed by the appellant pursuant to the provisions of
Wow, the appeal was filed by the appellant? Wow, tell me a different story. Fuck me.
Section 13 of Chapter 222, Chapter 22C, which
Christ.
applies to the state police disciplinary matters, and Sections 41 through 45 of Chapter 31, known as the Civil Service Law. The appellant is contesting the department's decision to terminate his employment as a state trooper. Under the applicable law, the burden is on the Department of State Police to show, by a preponderance of the evidence, that the appellant engaged in misconduct that warrants discipline. If the state police meets that burden, then the burden shifts to the appellant to show why termination, as opposed to a lesser penalty, the appropriate level of discipline. This hearing is conducted in accordance with the standard adjournment.
Not for nothing, but to what burden of proof? See, the hearing officer just said, right, in the first instance, the police had the burden to preponderance of the evidence to show why he was being fired, and then said the burden flips to him to show why sanction was too much. To what burden of proof? Is it also preponderance? She didn't say. That's not important information in any way. Kill me.
Derogatory rules of practice and procedure, 801 CMR, formal rules, with provisions of Chapter 31 taking precedence over any conflicting rules. Excuse me.
Now we're okay. This is great.
Please give me a few minutes. I'm going to ask you to please stop, Mr. Cameraman.
I think you should maybe stop this recording on WebEx and then
They're having problem with WebEx?
I'm so sorry that it wasn't transmitted to the
Dude, this hearing is cursed. What are we into this? 5 minutes? This hearing is cursed. Unbelievable. We're into this hearing 5 minutes, and this hearing is cursed. It's already slow. It's already slow, annoying, and like the judge is not the judge or hearing officer, really. The hearing officer is not exactly wowing me with confidence. I'm not feeling wowed. Also, what room are we in? This room sucks.
Ma'am, you're back on the record now. So I'll begin again.
Okay, so you want me to take everything off?
Yes.
Are you seriously going to start the hearing over? Are you seriously going to start the hearing over? I want to die.
We'll just begin
Start
again.
right from here.
Yes.
Okay.
Thank you very much. All right. Good morning again. My name is Angela C. McConney.
Oh, fuck me.
O-N-N-E.
Fuck me.
I am a commissioner for the Massachusetts
No.
Commission.
No.
Rob Quinnen, Q-U.
No.
Counsel for the commission. Good morning. The time is approximately 9:39 a.m. on August 26, 2025.
No.
The first hearing being held in person at the offices of the Civil Service Commission at 100 Cambridge Street in Boston, Massachusetts. Additional days of hearing are scheduled for tomorrow, August 27th, 2025, and later this year on October 21st, 22nd, and 23rd. I am the hearing officer for today's appeal, filed with the Civil Service Commission on March 27, 2025, and docketed as case number D1-25-085. The appellant in this matter is Michael D. Proctor, Proctor. At this time, I ask that co-counsel for Mr. Proctor please stay seated, introduce yourselves, and spell your names for the record.
Good morning, Madam Commissioner. Attorney Daniel Moynihan, Moynihan, on behalf of Michael Proctor.
Good morning, Attorney Mark Russell, RUSSELL, on behalf of Michael Proctor.
And my name is Zachary Green, Associate for Attorney Moynihan, on behalf of Michael Proctor.
Thank you very much, Mr. Moynihan, Mr. Russell, and Mr. Green. The respondent in this matter is the Massachusetts Department of State Police. At this time, I ask that counsel for the department again, please stay seated, introduce yourselves, and spell your name for the record.
Good morning, Commissioner McConney, Attorney Quinnen. My name is Stephen Carley on behalf of the respondent, Department of Massachusetts State Police. It's spelled STEPHENCARLEY. With me is my associate.
Is there a particular reason the camera guy wants to zoom in on Proctor's potbelly? Is that important information?
Carly and Ms. Rottenberg. This appeal was filed by the appellant pursuant to the provisions of Section 13 of Chapter 22C, which applies to state police disciplinary matters, and Sections 41 through 45 of Chapter 31, known as the Civil Service Law. The appellant is contesting the department's decision to terminate his employment as a state trooper. Under the applicable law, the burden is on the Department of State Police to show by a preponderance of the evidence that the appellant engaged in misconduct that warrants discipline. If the state police meets that burden, then the burden shifts to the appellant to show why termination, as opposed to a lesser penalty, was not the appropriate level of discipline. This hearing is conducted in accordance with the standard adjudicatory rules of practice and procedure, 801 CMR 1.01, formal rules, with provisions of Chapter 31 taking precedence over any conflicting rules. To ensure clarity, this is not a jury trial. This is an administrative hearing being conducted by a hearing officer.
Thanks for clarifying
It
that.
is my responsibility to make rulings on the admissibility of evidence and then determine what weight, if any, that evidence deserves, and to make credibility assessments as necessary regarding the witnesses that appear before me. Pursuant to Section 43 of Chapter 31, the Commission has deemed this a public hearing, while reserving the right to close portions of the hearing if warranted. Members of the public are present in the courtroom today, as well as an adjacent overflow room where the hearing can be viewed live. The media has been permitted to set up a pool camera for audio, video, broadcasting, and recording. Prior to the hearing, the media and public have been provided with a summary of hearing room protocols that must be adhered to at all times. This hearing is also being audio and video recorded by the Commission via the WebEx platform. A court reporter is also present to transcribe the hearings, and that transcription will be the official record of this hearing. At the conclusion of this proceeding later this year, the parties will be given the opportunity to submit post-hearing briefs, at which time the record will close. Any final decision issued by the Commission regarding this appeal will be sent to the parties via email only.
Really?
The Commission's decision will also be published on the Commission's public website at mass.gov/CSC. All final adjudicatory decisions of the Commission are subject to judicial appeal under Chapter 30A of the General Laws. Before we begin, a few housekeeping matters. First, in a final ruling sent to the parties yesterday, and after considering the objections of both parties, I have entered into evidence 36 exhibits from the Department of State Police and 58 exhibits from the appellant. As those exhibits have already been entered into evidence, there is no need to request that they be entered prior to referencing them at today's hearing. Second, I accepted the department's participant list, indicating that the department at this time has only one witness, and we will hear from him shortly. The department has committed to completing direct examination of this witness today. It is the Commission's expectation that the appellant will complete cross-examination tomorrow, with the option of recalling this witness in October if necessary.
No.
I urge counsel for both parties to use your time wisely and make adjustments accordingly as the day goes on to ensure conformance with these time allocations. Third, I hereby order the sequestration of witnesses. Any individual who is a potential witness in this matter may not attend or view any part of this proceeding until the conclusion of their testimony. Fourth, counsel for both parties have been allotted 15 minutes for opening statements. Since the audio is being captured by the table microphones, I'm asking counsel as well as witnesses to please stay seated while speaking, to speak loudly and clearly, and avoid any crosstalk. Please allow questions to be completed before objecting. At this time, I ask that counsel for the Department of State Police proceed with an opening statement, to be followed by an opening statement by counsel for the appellant. I will ask Mr. Quinnen to please keep the time.
Commissioner McConaughey, may I just make a statement for the record regarding the procedure?
Is this something separate from the motions that I allowed yesterday?
No. Yes, it is. Yes.
Is wait until after the openings?
It can. It concerns the sequestration order.
If anyone is going to testify, or you think they will, they shouldn't be in this room.
No, the difficulty is the fact that we're here at the request of the commission to start this process today, despite the fact that we're awaiting discovery from the department, as you know.
That, sir.
And we
If
don't
you
know
have
who
anybody
we don't know who all our
One
witnesses.
at a time, please.
Yes, if I'm speaking, don't speak.
Sorry.
That's quite simple. First of all, for decorum. If you have anyone who is a potential witness, they should not be in this room. That's all I can say.
And because we don't have our discovery, we don't know at this point who all of our
Sir,
witnesses
I
are.
can't advise you how
other
to
than-
conduct your case.
I'm sorry?
I can't advise you how to conduct your case. Mr. Carley, can you please proceed?
Thank you, Commissioner McConney and Attorney Quinnen. Distasteful, unprofessional, inappropriate, in poor taste, juvenile, sexist, disgusting, dehumanizing. This selection of words does not come from a public comment section on a website, an op-ed column,
Woo!
or a protester outside the Norfolk County Courthouse. No, indeed, one would be forgiven for not immediately recognizing that these words are Michael Proctor's accounting of his own conduct in this case. Conduct in which Michael Proctor, tasked with the immense responsibility of acting as case officer for the investigation into the death of John O'Keefe, consumed alcohol and then operated his cruiser while on duty, released confidential information to individuals outside of law enforcement, and called suspect and eventual defendant Karen Reed a babe, a nutbag, retarded, a whack job.
Yeah.
She's got a leaky balloon knot,
Yep.
leaks
Yep.
poo,
Yeah.
a woman who shits herself with no ass. She's fucked. A cunt.
Wow. I mean, not that he shouldn't, but he really said that C word with that full force, man. Woof. This is great. We're off to a great start here. Wow. Let's go, baby. Woof.
As a result, the department brought forward 4 separate specifications within 2 types of charges for internal discipline.
Uh-huh.
And in March, Colonel Noble terminated Michael Proctor's employment. In support of the just cause for doing so, beginning today, the department presents for your consideration its evidence of the appellant's guilt under the charges and specifications described as follows. Charge 1, Specification 1, unsatisfactory performance, sending derogatory, defamatory, disparaging, and inappropriate text messages about a suspect. Charge 1, Specification 2, unsatisfactory performance, provision of sensitive and confidential information about a homicide victim,
Yep.
potential witnesses,
Yep.
and potential investigative steps to non-law enforcement personnel.
Yeah, that's not great.
Charge 1, Specification 3, unsatisfactory performance, through unprofessional and inappropriate conduct, created an image that he was biased and brought himself and Massachusetts State Police into disrepute.
Yeah, I did that a little bit.
And finally, Charge 2, Specification 1, consumption of alcoholic beverages while eating dinner on duty and then operating his department-issued cruiser. The department's defense of the just cause of the adverse employment action against Michael Proctor will be based entirely upon the evidence of his conduct, his violations of those specifications under our Article 5. To prove this case here in this de novo proceeding, the department will call OPIA Detective Lieutenant Kevin Dwyer, who was assigned an investigation initiated by DIS Commander Lieutenant Colonel Brian Connors. In addition to the testimony of Detective Lieutenant Dwyer, the department has submitted and has been entered into evidence for your review and consideration those 36 exhibits, demonstrating by a preponderance of the evidence that Colonel Noble had just cause to terminate Michael Proctor's employment.
Yep.
You will hear of Detective Lieutenant Dwyer's collection and assessment of the records of the appellant's misconduct, first brought to light in excruciating detail during 2 days of his public testimony at the homicide trial in Norfolk Superior Court on June 10th and 12th of 2024. You will have the opportunity to hear the appellant read in his own voice his vile, misogynistic statements against the woman accused of and tried for the death of Officer O'Keefe. You will have the opportunity to hear his revelations to high school friends and members of his family of the identity of the victim, his views on and details of the crime, the manner of the victim's death, the witnesses to be interviewed, and the direction of that investigation, some made under 24 hours of the discovery of Officer O'Keefe's body.
Mm-hmm.
You will hear his own characterizations of his conduct that I quoted to you before. And you will hear his admissions under Charge 2 that while he was on duty, he consumed 1 to 2 beers with an officer from Canton Police and then drove the 2 of them home. You will be given, in addition to the video recordings of that public testimony, transcripts of the appellant's own words for your review and reference, a summary of Detective Lieutenant Dwyer of his misconduct, of Michael Proctor's misconduct as revealed during the trial, pay station, administrative duty roster, and AVL data collected by Detective Lieutenant Dwyer, corroborating the appellant's account of his alcohol consumption while on duty, the statements and admissions by the appellant at his OPIA interview, and Detective Lieutenant Dwyer's conclusions therefrom, as well as the criminal trial exhibits themselves containing the appellant's messages. You will also have available for your consideration the findings and resulting recommendation of the department's internal trial board, as well as the limited selection of public reaction to the revelations of the appellant's behavior. Relevant portions of an interview he gave to ABC News following his termination, and an order from the Norfolk County District Attorney's Office for him to turn over as discoverable statements in a criminal prosecution under Rule 14 the content of his communications from his personal cell phone. The department expects that much by way of distraction will also be on offer in the days to come, in the form of dubious and flimsy comparisons, whataboutisms reflecting the choices of others, spurious emotional appeals to the absolutely real difficulties experienced by members assigned to a homicide investigation, and insinuations that written statements by a case officer regarding his own investigation are somehow private or out of bounds. In short, the department expects an appeal not based on the truth, but on evading accountability. The department respectfully asks that this commission, while receiving those distractions or attempts at same, keep in mind the evidence and the facts that are the basis for the department's case. It respectfully asks you to bear in mind that no one committed the acts for which he was terminated other than Michael Proctor alone. No one authorized his communications of sensitive and confidential case information about an active homicide investigation to others outside of law enforcement. No one forced or cajoled or even requested him to engage in such gratuitous behavior. And that Michael Proctor himself has admitted, as evidently he must, that his conduct was unprofessional, inappropriate, juvenile, sexist, disgusting, and dehumanizing. And that he has admitted that he in fact committed the acts exactly as described in the charges brought against him. Accordingly, at the conclusion of this hearing, the department expects to meet its burden, showing just cause and will therefore ask this commission to uphold the termination of Michael Proctor. Thank you.
Thank you very much.
Yep. Simple to the point. I like that opening a lot. Just, well, I could have probably done without the theatrics of the, one word at a time thing, but, okay, it worked out for its own benefit. But, that might be one of the best openings I've ever heard of, just simply because it was short. Great. Fantastic. Just keep it simple, stupid. Why make your life more complicated than it needs to be? Fantastic. 10 out of 10. Well, 9 out of 10. Not bad. All right, great. All right, Proctor, what you got? This should be good.
Thank you, ma'am. Good morning, Commissioner McCartney, Mr. Queen. We're here today to hear evidence presented by the Department of State Police, which it believes amounts to just cause for the termination of Michael Proctor. Due to the fact that we continue to await discovery from the department, you will not hear a presentation of evidence by Michael Proctor today or tomorrow. You won't hear about his presentation of our evidence until October. Nevertheless, we will, through cross-examination, get to the truth behind this case. And the truth is that as of February 1st, 2024, Michael Proctor was an exemplary member of the Mass State Police. He had served in that capacity for 12 solid years without any discipline. He had risen to the level of the ranks of detective for the Norfolk County DA's office as a young trooper and served in the role as detective and was a very well-respected member of that unit. As of January 29th of 22, Michael Proctor, a fairly new detective in the DA's office, was asked to become the case officer on the Karen Reed case. You will hear what his duties were as case officer, and you will hear all that he was not responsible for as case officer in this case. Now,
this idea that they don't have discovery is kind of rich, because they kind of do. Because, of course, Proctor has access to the entire file from the disciplinary hearing itself. Because, of course, he does. It's like, oh, you don't have discovery. I'm like, pretty sure they do. Okay. But sure, let's complain about the fact that we don't have discovery. Okay, that's right, whatever. Sure. It's this mysterious discovery. Also, you're having trouble getting discovery? Isn't that unfortunate? You're having trouble getting discovery? Yeah, Karen Reed had trouble getting discovery too. That's unfortunate. That's too bad. Carry on.
as we all know, Karen Reed was arrested. She was indicted by a grand jury, and she was tried twice by the Norfolk County DA's office.
She was.
2022 through 2024.
Yep.
In the early part of late 2023 or early 24, the defense in the Karen Reed case convinced the U.S. Attorney's Office to open an investigation into a theory of a grand conspiracy against Ms. Reed on the part of law enforcement and others.
What? Karen Reed and her attorneys convinced the U.S. attorney to open what? Facts not in evidence. Very much. What the fuck?
You will hear that Michael Proctor was asked to testify in the federal grand jury proceeding as a witness only on February 1st.
And even if they did, so the fuck what? First of all, no. Second of all, even if they did, who the fuck cares? The U.S. attorney or the FBI can start an investigation for any whim that passes through their mind. They can start an investigation because they woke up that day and they had a dream. What the fuck? What the fuck are you talking about?
2024. And when he appeared, he was shocked to discover that the U.S. attorney had somehow infiltrated his personal cell phone and obtained
Somehow.
surreptitiously obtained personal text messages on his
Somehow.
personal cell phone.
Wow, that's a mystery. How did they ever?
Personal cell phones?
Wow.
We all
That's a mystery. Wow. How? Okay, yeah, that's a real head scratcher. That's a real head scratcher, guys. However, did the U.S. attorney obtain the text messages from the cell phone? I'm gonna go with subpoena to the cell phone company. Wow, solve that one right away. Glad I could clear that one up. What the fuck?
expectations of privacy on those personal cell phones. On February 1st of 24, Michael Proctor suddenly found in his mind that his privacy was violated. Since the disclosure of these text messages, the world has changed. Law enforcement officers and people in all walks of life now shudder at the thought that a federal agency could infiltrate their personal phone and look at text messages, personal text messages on a personal phone to family members and friends. Michael Proctor has reacted to this unlike many other people would. Michael Proctor has never denied the authenticity of these text messages. He's never denied that they are inappropriate, unprofessional, derogatory, sexist, misogynistic. Despite the fact that he's never, to this day, received the full text threads numbering hundreds of thousands of dollars that the U.S. Attorney's Office obtained. And despite the fact that he still doesn't know why his personal cell phone was infiltrated.
Yeah, the FBI doesn't usually tell you that. Right. The FBI doesn't, I know this is a shocker because I can't believe I have to explain this, but apparently I do. Oh my God. Okay. You see, the FBI, like most police forces, you see, when they're doing an investigation, they don't talk about the investigation. They also are not usually in the habit of telling their potential suspect or target about the investigation. You see, because they kind of keep that information private on kind of a need-to-know basis. Okay, great. Moving on.
Michael has repeatedly apologized for making crude remarks, unprofessional remarks, juvenile remarks. We could come up with many other adjectives that Michael has admitted to. He has never backed away from apologizing for these outright unprofessional and I'll call them stupid text messages on his personal cell phone spoken to his buddies from childhood. Instead of backing away, what did Michael Proctor do? Well, the next day, he self-reported this information to his bosses at the Mass State Police. He reported the full context of these text messages to the Mass State Police.
So he confessed?
Despite the fact that there's no existing Mass State policy concerning a trooper's personal text messages or personal private conversations on a personal cell phone. He reported it immediately.
You keep saying the word personal, but see, the thing is that they're not personal. That's the thing, you're making a mistake. They're not really personal. They're business. See, that's the problem. That's exactly the problem. You dead idiot. It's just that the messages aren't personal. They're business to people who aren't supposed to know. That's the problem. What part of this are you not getting? I hate it.
From that point, you'll hear evidence of what happened next and what didn't happen next in the ensuing 5 months and up to March of 25 when Michael was terminated by the department. You'll hear of a meeting which was initiated by Michael and his then counsel on February 1st of 24, February 8th of 24, I'm sorry, wherein the content of these text messages was disclosed to the legal staff of the Mass State Police, as well as high-ranking members of the Mass State Police. You will hear that the Mass State Police assured Michael Proctor that not much would come of this, and that he may
Okay.
receive a letter of counseling as a result, or a written reprimand. And that the colonel and the command staff expressed appreciation for him immediately reporting these text messages to them. You'll hear of a separate investigation done by the department in April of '24, wherein the nature of Michael's relationships, alleged relationships with witnesses was investigated. And the issue of bias was investigated. And their findings were negative. You will hear that Michael Proctor remained on full duty from February 2nd, when he first disclosed, until July 1st, which is coincidentally the date of the Karen Reed mistrial.
Yes, he did remain on
You'll
full
hear that
duty. That's
after
true.
that mistrial, that unfortunate date for Mike Proctor, July 1st of '24, the witch hunt for Michael Proctor began.
The witch hunt.
He was released
The
to duty
witch
from
hunt.
hours after that mistrial. You'll hear a press release from the colonel at the time who stated, quote, "Upon learning today's result, Michael Proctor was relieved of duty." You'll hear of intense political scrutiny, intense media pressure to fire Michael Proctor.
Uh-huh.
You'll hear that this termination was not based on actual facts and evidence.
Uh-huh.
Instead, it was a decision made to appease politicians and to appease some vocal members of the public and the media.
Uh-huh.
You'll hear of the so-called internal trial board process of the Mass State Police and how flawed that process is and how unfair it is and lacking in due process. You'll hear that despite the flawed process of that internal trial board, this decision to fire Mike Proctor was made on July 1st of '24, within hours after that mistrial. Most important, you'll hear evidence from the trial board in this hearing that Michael Proctor's personal feelings did not influence the evidence in the Reed case. Michael Proctor did not act with the intent to affect the outcome of this investigation. You'll hear that there's no evidence to show that the integrity of the investigation in the Reed case was compromised. In other words, the personal cell phone text did not affect his performance of his police duties. And that the Mass State Police investigation into Michael was solely about personal cell phone messages and not about his job performance in the investigation. And that the charge of unsatisfactory performance of his duties is a misplaced charge. It's a charge that was designed as a Class A offense simply to appease the masses and fire Mike Proctor. In summary, Mike Proctor was a very good trooper, an exemplary trooper, a detective who has been made to be a scapegoat as a result of the Mass State Police caving in to public pressure. Michael Proctor did not commit a crime. Michael Proctor did not violate any specific policy prohibiting personal conduct on a personal phone, because there is no specific policy. Those are two very important facts to remember in this case.
He didn't violate, there was no policy on personal conduct on a personal phone. Well, I suppose there's not, but it's not personal. See, it's once again, it's business, because he's sharing business information relating to an ongoing investigation. I'm pretty sure there's a rule against that. The clown show is real, man. Damn. Shit, man. I'm not sure whether to be entertained, horrified, intrigued. I don't know what's going on. This is okay. Fuck me.
Does his unprofessional conduct on his personal phone possibly warrant some discipline? Probably. Unbecoming conduct, possibly. In October, we will demonstrate, when we have our discovery, that the termination of Mike Proctor, the firing of Michael Proctor after 12 examinations.
If there's any discovery in here, if they find something in discovery that is going to help their case, I will be amazed. Also, are they seriously about to talk about his 12 years of otherwise, like, good service? You know, are they seriously going to try to sell us on that? What is that old saying? You know, what is that old saying? You know, If you build 10,000 bridges, you're a bridge builder. But if you even fuck one goat, that's basically what's happening right now. Moving on.
Years does not comport with previous standards of discipline for the Mass State Police, and that is disproportionate with discipline meted out by the state police over the years. Michael Proctor should not be subject to the whims of politics or the whims of the media. He should obtain a fair hearing on the merits, and we expect to obtain that fair hearing through this process. No one should be unjustifiably pushed aside from his job simply because an organization wants to satisfy an agenda. And that's what happened here, folks. Thank you.
Thank you very much, Mr. Whitehead. I'd like to issue a supplementary ruling on your earlier request about the sequestration order. I understand it's a long time from now to October 21st. I would be asking each witness in October if they have previously observed any part of this proceeding. If they're answering the affirmative, reserve the right to take that into account in my fact finding. Also, any individual, however, who anticipates being called as a witness should not be watching today's proceedings.
May I?
Yes.
My only concern, Commissioner McCartney, is that many of the witnesses on our pre-hearing list are not under our control. They're state police employees, number one. So we don't have authority to tell them not to watch this proceeding. Number two, after we obtain discovery in mid-September, we may have additional witnesses who we just don't know about yet.
Right. Like I said, as I just stated, I will ask each person before they testify. Right.
Thank you.
And again, I'll take that into account.
Thank you.
Thank you so much.
This carpet in this room sucks. These walls suck.
Did you call your first witness?
Thank you, Commissioner. The respondent calls Kevin Dwyer.
Right hand, sir. Do you swear or affirm the testimony you are about to give to the Civil Service Commission is the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. I would just like to impart some information to you. First of all, that your testimony is being recorded, and both parties will receive a copy of the recorded testimony. Your testimony included the decision issued by the Civil Service Commission in this matter, which will be posted on the Commission's website. I may make credibility assessments about your testimony, which may also be included in the Commission decision.
Why does she need to tell the witness this information? Why does she need to tell the witness, I'm going to assess her credibility? How's this helpful or required information? This is dumb. I hate it.
Please listen to the questions carefully and answer only the questions that are asked of you. If you cannot hear the question, you may ask for it to be repeated. If you do not know the answer to a question, you should state that. It is important.
What is this fucking preamble?
Slowly, clearly.
Who does this?
So that your testimony can be captured on the recording. Please avoid any crosstalk by waiting for the question to be asked before you answer.
Also, I need to advise you that at Dunkin' Donuts right now, they have a special. If you buy 5 donuts, you get 1 free. Also, I need to advise you that the sparrow flies at midnight. What the fuck?
And if there are any objections, please wait for my ruling before answering the questions. And again, if you turn your body away, you miss the recorder, so please face forward and speak into the microphone at all times. Thank you very much. Mr. Carlin?
Thank you again, Commissioner. Good morning, sir.
Good morning.
In a loud, clear voice, could you please state your full name and spell your last?
Detective Lieutenant Kevin Dwyer, D-W-Y-E-R.
You're employed by the department?
I am.
How long have you worked with the state police, sir?
Over 20 years.
And what is your, well, you mentioned your rank. What is your current?
All right, chat. This is the part where you, the chat, get to participate. I'd like you to pitch your additional suggestions for advisements we need to advise this witness of. These are super critical advisements, of course. Only the most critical advisements. Please pitch me your suggestions for other advisements we've just absolutely need to tell this witness about. Holy shit.
Assignment, sir.
I'm assigned to the Office of Professional Integrity and Accountability.
And could you please briefly describe to the commission your duties and responsibilities in your current assignment?
My current responsibilities are as an internal affairs investigator.
All right. And do you have training and experience specifically with respect to OPIA investigations?
I do.
Can you summarize any training or experience you have in that regard, sir?
Yes, I've attended multiple trainings on internal affairs investigations, plus my experience in the unit for almost 5 years.
I'd like to draw your attention, sir, to the time frame of March of 2024. Did you have occasion to receive an order to open an investigation into alleged misconduct by Michael Proctor?
I did.
What specifically was your role in that investigation, sir?
As the primary investigator.
All right. And how did you specifically come to be assigned to that particular investigation?
I was summoned to a meeting where I was told the allegations.
And coming out of that meeting, was the investigation into, or the investigation that you ultimately conducted, was it assigned a number by the Office of Professional Integrity? And
Yes, it was.
What was the number, sir?
It was IAS 2024-0014.
And how was it formally initiated? How was the investigation formally brought into existence?
There was a request for investigation that was authored by Lieutenant Colonel Connors.
All right, sir. And if you could turn in your binder, please, to Respondent's Exhibit 1.
That's a pretty serious binder. Who took the
one
okay
before you, sir? Is that the personnel investigation or the order to initiate the personnel investigation from Lieutenant Colonel Connors that you just referenced?
It is.
All right. And did you ultimately have occasion to organize, author, and submit a report and several exhibits documenting your findings in this investigation?
I did.
And as part of those exhibits, did you include a copy of Lieutenant Colonel Connors' request for investigation dated March 4th as your Exhibit 1 to your report?
I did.
Now, following up on Exhibit 1, in the body of the document, Lieutenant Colonel Connors references a criminal investigation. Is that correct, sir?
He did.
Would that be the criminal homicide prosecution of Karen Reed into the death of Boston police officer John O'Keefe?
Yes, it was.
Fair to say that Officer O'Keefe's body was located on January 29th,
Thank you
2022 at a
for
residence in
Bluefish for the
Yes.
20 gift memberships.
And
Very,
as
very
specified by
appreciated.
federal laws,
Thank you.
The Norfolk County District Attorney's Office, and specifically the department members who are assigned there, they're assigned to lead that investigation.
And thank you, Bluefish, for 24 months of membership. Thank you, JD, for becoming an uncivilian. Jules for $2.
Now, at a certain
Said they
point
missed
during that
something. Don't worry about it.
investigation,
And Alan Parker gifted 20 gift memberships. Always generous, Alan. Thank you so much.
How do
We love you.
describe that in your report, sir?
Your continued support is appreciated.
Notified by the Norfolk County District Attorney's Office that they were advised by the U.S. Attorney's Office that there was a federal invest that involved Trooper Proctor.
Okay. And how did the notification that came to the department that you just described, the notification from the Norfolk County District Attorney's Office, how did that notification take place?
It was a verbal notification.
All right. And at the time the verbal notification was made, was there any documentation provided by either Norfolk County or by the U.S. Attorney's Office regarding that investigation?
None that I'm aware of.
Okay. And did Norfolk County provide any other details about that federal investigation at that time, sir?
None that I'm aware of.
All right. At some point, was it disclosed that Michael Proctor had his personal cell phone examined, and that there were text messages of a derogatory and defamatory nature about Ms. Reed on that cell phone found?
Yes.
What, if any, effort did the department make around that time to learn more about those text messages?
To my understanding, there were multiple conversations amongst the department and the federal authorities to get more information. I don't believe they were very successful.
All right. And that was a decision made, as far as you're aware, by the federal authorities?
Correct.
Did the federal authorities place any conditions on the department with regard to this investigation?
Yes.
What conditions, sir?
Anyone that was advised of the existence of the text messages had to sign a non-disclosure agreement.
As far as you're aware, were there any exceptions to that requirement to sign the non-disclosure agreement set by the federal authorities?
No.
What, if any, official actions did the department take with respect to Michael Proctor as a result of verbal notification from Norfolk County?
Personal invest was started.
In effect, the oral or verbal disclosure from Norfolk County is what triggered the request for investigation.
It is.
Is
Yes.
that accurate, sir?
Yes.
As part of the standard practice and required by department procedure and the collective bargaining agreement, was a subject notification letter issued to Michael Proctor?
Yes, it was.
Who first issued that and when, sir?
Detective Lieutenant John Goslin on March 4th. It was Detective Lieutenant John Goslin, and that was sent on March 4th, 2024.
Was Lieutenant Colonel Connor's request for investigation attached to that subject notification letter?
It was.
And initially, among other copy recipients, was that notification also sent to Trooper David Stewart as the spam representative?
Yes.
And did you ultimately attach a copy of that notification dated March 4th to your report in this case?
I did.
And did you attach it as Exhibit 2 to your report?
Yes.
Could you turn to Exhibit 2 for the respondent's exhibits in this proceeding, please? Sir, do you have Exhibit 2 in front of you?
I do.
Is this the Exhibit 2, the same Exhibit 2 that you attached to your report?
Yes.
The subject notification letter and the request for investigation or request to initiate an investigation that you made your Exhibit 2?
Yes.
All right. And Detective Lieutenant, was there a typographical or stenographic error in that exhibit when it was first issued?
Yes, there was.
What was the error, sir?
It incorrectly named who wrote the request for invest.
And did the department issue an amended notification letter?
Yes.
What was the date of the amended notification?
March 19th, 2024.
All right. And did you ultimately attach that as Exhibit 3 to your report?
I did.
Did you turn to Exhibit 3 for today's proceedings? Do you recognize Exhibits 3, sir?
Yes,
And is that the same Exhibit 3 that you attached to your report in this case?
it is.
All right, sir. This amended notification, it correctly identified the author of the request for the investigation as Lieutenant Colonel Connors?
Yes, sir.
And was it provided to, this particular one, provided to, among others, Michael Proctor's spam representative, Sergeant Christopher Johnson?
Yes.
Okay. Now, sir, in addition to the information provided from Norfolk County about these alleged improper text messages from Michael Proctor, were there also additional concerns raised with respect to him and witnesses in the O'Keefe investigation?
Yes, there was.
Could you just generally describe, sir, for context and the Commission's benefit, what were the concerns that you were made aware of?
There was concern that Trooper Proctor had a relationship with some of the potential witnesses in the investigation.
All right, sir. Did those concerns constitute any portion of your investigation into Michael Proctor's misconduct, meaning specifically OPI OPIA case 2024-0014?
It did not.
Okay. What, if anything, to your knowledge, did the department do regarding those concerns?
There was a separate inquiry done to determine the nature of Trooper Proctor's possible relationships.
And was that documented separately by separate investigators within the department?
Yes.
And was that given internal personnel investigation number 2024-DIS-4?
Yes, it was.
All right, sir. In your ultimate report in this case, IAS 2024-0014, did you ultimately note in general what you learned about that separate investigation?
Yes.
Okay, can you summarize what you conveyed in your report, please, for the commission, sir?
So it was learned, while Trooper Proctor may have known some of the witnesses, the relationships were not substantial, and they were consistent with how he had represented them.
All right, sir. Given what you understood about that investigation, and given the consistency that you mentioned with regard to his statements about those relationships and them being not substantial in nature, did any suggestion of misconduct on that matter have any impact on your findings, investigation, or recommendations in IAS 2024-0014?
No.
Detective Lieutenant Dwyer, I'd now like to ask you about your review of evidence regarding Michael Proctor and the text messages in particular. To begin, when did you first learn of or have made available to you the substance of the messages that were the focus of your investigation?
When Trooper Proctor testified in the criminal trial.
All right, sir. And on what day or days did he testify in the trial that you just mentioned?
June 10th and June 12th, 2024.
Up to that point, the department did not have any documentation nor admissions from Michael Proctor regarding the content of the disclosure of his, the content of his personal cell phone.
Correct.
All right. And how did you personally observe the open proceedings in the Reed prosecution?
I watched a live stream of the trial.
All right. And did that trial begin on or about April 29th of 2024 in Norfolk Superior Court?
Yes.
All right. And the live stream that you viewed, what live stream did you view, sir?
It was the Court TV live stream.
Was there any testimony, you mentioned June 10th and June 12th of 2024, was there any testimony on June 11th?
No, there was not.
All right. And as part of your investigation, were you able to obtain copies of the video broadcast from both June 10th and June 12th for inclusion in your ultimate report?
I did.
And were those copies of the video recordings ultimately made exhibits 4 and 6 respectively to your report?
Yes.
All right. I'll note for the record that exhibits 4 and 6 to the witness's report are reproduced as exhibits 4 and 6 in the respondent's exhibits here today. In addition to the previous exhibits that I just mentioned of the video broadcast footage, did you also have occasion to obtain any transcripts of those same 2 days of trial testimony?
Yes.
And specifically the testimony of Michael Proctor, the transcripts focusing on his testimony?
I did.
Okay. And did those ultimately become exhibits 5 and 7 respectively to your report?
They did.
All right. I'll note for the record that those exhibits are attached as 5 and 7 to the exhibits here today. Thank you. Detective Lieutenant Dwyer, did you also personally take notes during your viewing of trial footage in conjunction with the transcripts of the video? Did you also take notes on the content of Michael Proctor's testimony?
I did.
All right, sir. And did you include the substance of those notes as part of your report in this case?
I did.
And did you ultimately attach those notes to your report as Exhibit 8?
Yes, I did.
All right, sir. Could you carefully, and it's a number of pages, but could you go to Exhibit 8, please, sir? You have Exhibit 8 in front of you, sir?
I do.
All right, sir. The Exhibit 8 that's in front of you, these are your notes from reviewing Michael Proctor's live testimony in the first Karen Reed trial.
They are.
And they are the same as the Exhibit 8 that's in front of you as part of the respondent's set of exhibits.
Yes.
All right, sir. Now, I'm jumping around a little bit, but please bear with me. I'd like to ask you about Exhibit 18 to today's proceedings. All right, sir. You've had a chance to take a look at what's before you in the printout copy of Exhibit 18 from today.
Yes, sir.
Is that a copy of the ultimate report that you authored and submitted in this case as the conclusions of your investigations, the findings and conclusions of your investigations in IAS 2024-0014?
It is.
All right. All right, I'd like to ask you now a series of questions about categories of allegations. Do you have a portion of your report that sets out the allegations into separate categories or organized by letter?
I do.
Okay. And would that be categories A through K, allegations A through K?
Yes, they would.
All right, sir. Please turn to bait stamp respondent 504. That would be the 14th page of Exhibit 18. You have 504?
I do. Yes.
Before I ask you about this in detail, sir, is it fair to say that on the beginning of this page, that is Respondents 504, and continuing on to the last, the 15th page of your report, Respondents 505, you specify here, a series of categories of different but related allegations, the A through K that I mentioned.
Correct.
And in fact, those 11 set of allegations, did you personally review and assess each allegation of misconduct and issue a separate recommendation as to each?
I did.
And the separate recommendations that you ultimately issued were either sustained, not sustained, or exonerated based on the evidence as you found it?
Correct.
The allegation you assigned to letter A, sir, that concerned the claim that between January 29th, 2022 and February 1st of 2022, Michael Proctor provided information about a homicide victim to non-law enforcement personnel?
Yes.
What was your recommendation as to allegation A based on your investigation?
Sustained.
The allegation you assigned letter B, sir, that concerned the claim that between January 29th, 2022 and February 1st of 2022, Michael Proctor provided information about potential witnesses in a homicide investigation to non-law enforcement personnel?
I did, yes.
And what was your ultimate recommendation as to allegation B, sir?
Sustained.
The allegation you assigned letter C, did that concern the claim between January 29th, 2022 and June 9th, 2022, Michael Proctor provided information about potential investigative steps and police actions related to a homicide investigation to non-law enforcement personnel?
It did.
What was your what was your recommendation as to allegation C, sir?
Sustained.
Allegation you assigned letter D, did that concern the claim that between January 29th, 2022 and June 9th, 2022, Michael Proctor sent derogatory, defamatory, and/or disparaging text messages to non-law enforcement personnel about a suspect in a homicide investigation?
It did.
What was your recommendation as to allegation D?
Sustained.
Allegation you assigned letter E, sir, did that concern the claim that on February 1st, 2022, Michael Proctor engaged in behavior to accept a reward, gift, or gratuity on account of his official services?
It did.
What was your recommendation as to allegation E?
Not sustained.
The allegation you assigned letter F, sir, did that concern the claim that on dates between June 9th, 2022 and August 17th, 2022, Michael Proctor sent derogatory, defamatory, and disparaging text messages about a suspect in a homicide investigation to other law enforcement personnel?
Yes.
What was your recommendation as to allegation F?
Sustained.
As to assignment, allegation assigned letter G, sir, did that concern the claim that on August 17, 2022, Michael Proctor looked for nude photographs of a suspect in the homicide investigation?
It did.
What was your recommendation as to allegation G?
Not sustained.
Just a few more, sir. Allegation you assigned letter H. Did that concern the claim that on July 19, 2022, Michael Proctor consumed alcohol while on duty?
Yes.
What was your recommendation as to allegation H?
Sustained.
Allegation assigned letter I. Did that concern the claim that on July 19, 2022, Michael Proctor consumed alcohol and then operated his department-issued cruiser?
It did.
What was your recommendation as to allegation I?
Sustained.
Allegation assigned letter J, sir. Did that concern the claim that on July 19, 2022, Michael Proctor received overtime pay while not engaging in official duties?
Yes.
What was your recommendation as to allegation J?
Exonerated.
Finally, sir, the allegation assigned by you, letter K, did that concern the claim that on dates between January 29, 2022 and August 17, 2022, Michael Proctor engaged in behavior that brought himself and the department into disrepute?
I did, yes.
And what was your recommendation as to allegation K?
Sustained.
For the benefit of the commission, Madam Commissioner, may I just note for the record that I'll be shortly, in a few moments, referring to clip number 1 from our exhibit number 4.
Yes.
So if I could just notify the commission of that.
Thank you very much.
Thank you. Detective Lieutenant Dwyer, I'm now going to ask you a series of questions about each of the allegations that you assigned those different letters. Is it fair to say that as to allegation categories A, B, and C, Michael Proctor's communications to others took place on several different text message chains that you previously mentioned, one with a group of friends and another with his sister?
Yes.
All right. And it's also fair to say that from your review of the evidence and the messages from Michael Proctor under categories A, B, and C, his testimony about that began, my apologies, I'll restart that question. Is it fair to say from your review of the evidence that the messages pertaining to allegation categories A, B, and C, those messages began by Michael Proctor on the day that Officer O'Keefe's body was discovered, January 29, 2022?
Yes.
And is it fair to say that his testimony at the Karen Reed trial as to categories A, B, and C, chronologically speaking, his testimony began on June 10th, 2024, under direct examination from the prosecutor?
Yes.
Now, I'm going to direct your attention to the video. Madam Commissioner, may we have clip number 1, please?
Yes.
Thank you.
And again, I'll advise everyone, please do not speak while the video is being shared.
Madam Commissioner, could you pause, please? Just for the record, I wanted to note, for the record, this clip begins as part of Respondent's Exhibit 4, the video from June 10th of 2024, at approximately 5 hours, 24 minutes, and 21 seconds into that video.
Can you please repeat the timing again?
Yes, my apologies, Madam Commissioner. 5 hours, 24 minutes, and 21 seconds approximately is the beginning of this particular clip. Detective Lieutenant Dwyer, before I ask the clip be played, is it fair to say that this is the start of his testimony regarding the text message chain with friends in which he reveals the identity and other details of the reported homicide victim, Officer John O'Keefe?
Yes, I believe so.
With the Commission's permission, I'd ask now to please play this beginning, again, at that the timestamp I previously referenced. For council's reference, the corresponding transcript pages begin Exhibit 5, Respondents, page 95.
So let me just click from the beginning.
Yes,
So
please. Thank you,
Back
Madam
to the
Chair.
correct time. Thank you very much.
Thank you, ma'am.
Where I'm showing you the document, do you recognize that?
Yes.
And what do you recognize it to be?
It's a text message thread labeled Proctor Friends.
Now, over the course of your investigation, over the course of this case, you're aware that there were iCloud data that was obtained from your personal cell phone.
Yes.
And different text strings from that iCloud data from your personal cell phone, correct?
Correct.
And with respect to what has just been placed before you, is that an excerpt or piece from those particular messages?
It is.
And from the front page of that, can you tell the jury who are sort of the participants in this particular text communication?
There's several numbers that aren't identified. The three that are under kind of nicknames me and my buddies have for each other.
And generally speaking, just as far as the participants in this text communication, who are these people to you, and how do you know them? How long have you known them? Who are they?
The members on this text thread, they're close friends from junior high, first grade even.
So people you've known for years, is that correct?
Correct.
And do each of them live, or do any of them live within the general area at this time?
Some of them do, yes.
And so when some of them do, some of them do not, is that correct?
Correct.
And the ones that do not, how far away do they live?
As far as away as Tennessee.
Now, with reference,
Sorry, there's a technical issue.
Thank you, Madam.
Technical issue. If they start this hearing over, I'm no. Absolutely not. If they start this over, I'm quitting. I'm just telling you, I'm definitely quitting if they start this over. I don't know if my poor heart can take it. I don't know, man. Put your little hand in mine. There ain't no river, mountain we can't climb. Beep, boop, 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 boop. I got you. Beep, boop, 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 boop. Kill me.
to this, there's an indication as far as the first message sent or last message sent from this particular text chain, correct?
Mr. Carlin, I'm so sorry for that interruption, and also Lieutenant Warren. Do you want me to begin again in the beginning, or are you comfortable?
I'm comfortable proceeding
Okay.
if the commission's.
Thank you.
Thank you.
I'm sorry, repeat the question, please.
Sort of towards the middle of the first page. I'll direct your attention to that area. Is there any indication as far as the first message sent and the last message sent with respect to this text chain?
On the first page, yes.
And what is indicated as far as the first message and the last message?
The first message is, I need to brandish a gun more often. The last is Chip, name of that BPD cop.
No, I'm sorry, sir. If I could direct your attention to the first page of this packet, page 2527, you see conversation details. Sorry, may I go?
Yes.
If I could direct your attention to the right.
Okay,
You see what I was talking about now?
I do, sir.
And from that area labeled conversation details, there's a first message sent, date and time, and the last message sent, date and time, correct?
Yes.
What is the first message sent, date and time?
It's 10/18 of 2021 at 8:48 a.m. The last message sent is 8/31/2022 at 11:19 p.m.
And is there also within that conversation details an indication as far as the number of messages over that time frame within this communication?
There is.
And what does it list for number of messages?
It's 38,707.
It's fair to say the packet that you have before you does not contain all 38,707 messages, correct?
That's correct.
The first message that you had, I believe, alluded to in reference to the first one listed within this communication. What date and time is that?
That was January 29th, 2022 at 10:36 p.m.
And who is that message from?
My friend who lives in Tennessee.
And what, if anything, did he send to the group?
I need to brandish a gun more often.
And if you know, what is that in reference to?
He just recently moved to Tennessee, and he was kind of, I think, making a joke as kind of the lifestyle down there becomes more prominent or more common to be carried around there. So I interpreted that as a joke in that nature.
And the next message, sir, from that same page, 2527.
The next one is, it's bold.
And is there a name associated with that number that's in these?
No,
Do you know who that person is?
I don't.
And the next message, sir, from 10:52 p.m.
Chip, name of that BPD cop.
And Chip, who is that referring to, sir?
That is one of my nicknames I've had since maybe high school.
So a nickname that would be familiar amongst these group of friends in particular?
Yes.
And this time period when these text messages begin, sometime after 10:30 or 10:50 p.m. on January 29th, where are you and what are you doing in reference around that time period?
At this point in time, on the 29th, I'm home.
And that last text message, do you respond to that at approximately 10:53 p.m.?
Yes.
And what was your response?
John O'Keefe.
And the next message down from there, also at 10:53 p.m.?
Yes. He took custody of his sister's kids.
That's your response. There's another response above that, is that correct?
Yes.
And what does that say?
How old?
And you respond as far as he took custody of his sister's kids, correct?
Correct.
Skipping down a couple, you see an entry at 10:53:49 p.m.
Yes.
And that's from a 617 number, is that correct?
Correct.
And what is the response there?
Oh man, that's rough.
And following that, do you respond to the earlier query as far as age?
I do.
And what did you say?
Mid-40s.
Thank you, Madam Commissioner.
Please.
For the record,
Sir.
I apologize. Yes, ma'am.
Sorry, it takes a while to bring it up.
Thank you, Madam Commissioner. Understood completely. For the record, that was played, that portion of Exhibit 4, the video from June 10th, 2024, was played until approximately 5 hours, 30 minutes, and 50 seconds. Madam Commissioner, may I have clip 2, please, from Exhibit 4? And for the record, for council's benefit, this begins at the transcript for Exhibit 5, date stamp, respondents 1 and 3.
Again, counsel, while I'm playing with this, if you're speaking, it's going to get picked up on the recording. If you're speaking during the recording.
Okay.
So you wouldn't want to it'll be recorded.
And top of the page, sir, if you could read through that page as far as who's texting and what are they saying?
Again, for my friend from Tennessee and myself, I hope not, but I can't see it. I responded with, she waffled him. I looked at his body at the hospital. He,
So I'm going to have to begin at it. I don't see it sharing on my screen. Sorry about that.
This hearing is going to kill me from technical issues alone.
And top of the page, sir, if you could read through that page as far as who's texting and what are they saying?
again, for my friend from Tennessee and myself, I hope not, but I can't see it. I responded with, she waffled him. I looked at his body at the hospital. He was pinned up.
Now, as far as the next text from a 781 number, what does that say?
Did he get beat up?
And you responded to that, is that correct?
I did.
The objection is sustained as to
What, if any, response did you provide to that?
No.
Objection. Objection to the former question and answer.
I'll strike it.
Now, turning your attention to 2534. And from this page, sir, if you could again just read through as far as indicating to the jury who's speaking and what is being said.
From the start of the first text, so the owner of the house?
Yes.
So the owner of the house was a woman cop that beat him? That's what I initially thought after talking to a Can paramedic, that I saw the guy.
And those last two are your responses, is that correct?
Yes.
Now, the following text messages are from your friends, is that correct?
Yes.
What do they say?
Yeah, let's focus. What does she waffle to mean? What's the story? I responded, she hit him with her car.
And the she that you're referring to there, who is that?
Miss Reed.
Please proceed, Mr. Coleman.
Thank you. For the record, the video clip 2 that was just played was from Exhibit 4, beginning at approximately 5 hours, 53 minutes, and 18 seconds, until approximately 5 hours, 55 minutes, and 21 seconds. Detective Lieutenant Dwyer, fair to say that concluded Michael Proctor's testimony as to allegations A, B, and C with regard to June 10th, his testimony on June 10th, and he did not testify on those subjects again until June 12th.
Correct.
May I please have clip 3, Madam Commissioner?
Trooper Proctor, I'm going to ask you if you wouldn't mind to turn to tab 2 in the binder in front of you. Can you take a look at the face page of what's under tab 2 and tell me if you recognize that?
Yes, sir. It's a private text thread with high school friends.
And this includes 9 participants, 9 chat participants that you engaged with?
That's correct.
Those participants include people by the name of Bird, Whitey, and Doc, correct?
Correct.
And then there's some other folks in there that are identified by at least the last 4 digits of their phone number, correct?
Yes.
So this is a group text or a group chat with you and 8 of your high school friends about this investigation, correct?
Yes.
Trooper Proctor, you never thought when you were engaged with these other 8 individuals that this particular set of chats would ever become public, did you?
No, I did not.
I want to take a look at page 2527, if you could turn, that's on the bottom right of the document in tab 2. Do you recognize, I'm sorry, do you have that page in front of you?
Yes, sir.
You recognize that this group chat was taking place on January 29th at about 10:52 p.m., correct?
Correct.
And the person that I'll identify as 5051, that's the last 4 digits of that phone number, indicates Chip, name of that BPD cop, correct?
Correct.
First of all, you indicated on Monday that you're Chip, is that right?
Yes, sir.
You responded at 10:53 p.m., John O'Keefe, is that right?
Yes, sir.
So you were willing to tell, just a few hours into an investigation of the death of a Boston police officer, you were willing to tell a bunch of high school buddies details about the investigation, including the name of the victim, correct?
At this point, it was 16 hours later, sir. Not a few.
16 is a few hours, correct? I'm not talking about days later.
It was about 16 hours later, sir.
Correct. And you identified John O'Keefe as the fallen, who is fallen in the yard at 34 Fairview, correct?
Correct.
You also informed, if you will skip to page 2529.
Thank you, Madam Commissioner. For the record, clip 3 begins from our Exhibit 6, the video from June 12th of 2024, at about 0 hours, 38 minutes, and 20 seconds. And for the record, that was paused at approximately 2 minutes and 30 seconds into this particular clip. Madam Clerk, or excuse me, I apologize. Madam Commissioner, I apologize. Could you please, and my timestamps are based on the full exhibit, so I'll have to approximate. Would it be possible to add, from 2 minutes and 33 seconds, would it be possible to add just under 10 minutes, 9 minutes and 53 seconds, so if we could go forward to 12 minutes and 26 seconds, if I'm doing my math correctly.
Wait, but Mr. Green or somebody close by out there assist me. He said 12 minutes to...
A lawyer just tried to do math. Oh, God, help us all. You like my commentary on the decor of this room? My only question is this room's decor like trying to make you have a wish to die? That's what I want to know. Is this like the Dementor paint color scheme
I'll speak.
to suck all the joy out of your soul?
So I'm sorry, what number is that now?
Because if so, whoever designed this room is doing a pretty decent job.
That's correct.
Close enough. Thank you, Madam Commissioner.
Correct?
Not that I was aware of.
Not a single bruise below the neck, right?
Not that I observed.
Looks a lot like a physical altercation, doesn't it?
Objection.
Sustained.
Bird writes, Bear, let's focus, correct?
Yes,
Who's Bear?
that's another nickname I have.
Bear?
0095 writes,
Someone called you Bear? Press X to doubt.
what does she waffled him mean? And then Bird writes, what's the story, correct?
Correct.
And you wrote, she hit him with her car. Is that right?
Yes.
We even need that clip anymore, Mr. Carlin.
No, ma'am. Thank you.
All right, please resume your question.
Is this the worst? Ladies, I guess this is the worst possible version of would you rather be in a forest alone with a man or a bear? Oh.
Before it began at approximately 0 hours, 38 minutes, and 20 seconds. It was played for approximately 2.5 minutes, then skipped ahead just under 10 minutes and played to the end of that particular clip, which would have been at about 0 hours, 55 minutes, and 12 seconds from our Exhibit 6. All right, sir. You just saw the 3 clips that were played, is that correct?
Yes.
The first 2 being Michael Proctor's sworn testimony under direct examination from Prosecutor Adam Lally, and the third under cross-examination by Defense Attorney Alan Jackson.
Yes.
Is it fair to say that as to allegation categories A, B, and C, Michael Proctor's communications with other individuals on those text message chains continued with a series of messages he exchanged with his sister? Is that correct, sir?
It is.
If I may just have 1 moment, please.
Of course.
Yes, if we could have clip 4, please, Madam Commissioner.
I'm showing you another document, so ask if you recognize that.
Yes, I do.
What do you recognize that to be, sir?
Text communications between my sister and I.
That's your sister Courtney, is that correct?
That's correct.
And similar to what I asked you about the prior packet, as far as the first message sent, date and time, last message sent, date and time, what is indicated on this first?
First message sent, date, time, December 10th, 2021 at 9:33 p.m. Last message sent, 8:30, 2022 at 8:48 p.m.
At 8:30, that's August 30th, is that correct?
I'm sorry, yes, August 30th, 2022.
And similar to the other messages, is there an indication as far as how many number of messages were sent between yourself and your sister over that time period?
2,865.
And fair to say that the documents in front of you do not contain 2,865 messages?
Correct.
Now, just in reference to the first message on page 2662, the first page in this packet, do you see that from December 10th of 2021 at approximately 9:33 p.m.?
Yes.
And what does that indicate?
The text message from my sister.
And what does it say?
I called earlier, Dolph earlier, and Mom was puking in the background.
And do you recall what that was in regard to?
From the sounds of my mother, had a stomach bug.
Uh-huh.
Sir, if I could direct your attention to page 2667. And these are text messages from January 29th, 2022, between yourself and your sister Courtney.
Correct.
And if you could read from the top of the page through the end, and please indicate to the jury as far as who's talking and who's saying what.
So I texted my sister at work, what's up? She responds, what? Why? I respond, I just found it frozen to death on a front lawn in Canton this morning. Actually just interviewed Jen McCabe, said she knows you.
And the knows you, who are you referring to?
My sister.
And how did your sister respond to that?
Cut the shit. I responded you. It was a typo correction with my response to you. She responded, yeah, she knows Jack very well. She's really good friends with Julie. My sister continues on. Her sister is married to Brian Albert. My sister asks, you still working, question mark. I said, yeah, gonna be out for a while, homicide.
As far as your answers to those questions, or as far as your communications that you had with your sister at this time, on the afternoon of January 29th, what were those in regard to, or why were you communicating that to your sister?
At that time, it was just kind of in the news. I was just kind of letting her know I was out working. She didn't share anything specific. I wouldn't share anything specific on cases with my family or anyone. It was just kind of an overall innocent conversation.
Turning your attention to the next page, 2669. Again, if you could read from that page as far as who is talking and what the content is.
I know this is asking probably for too much. It's probably asking for too much. But do you think at any point Michael Proctor has ever looked at himself in the mirror and asked himself the question, am I the baddie? Do you think he's capable of that level of self-reflection to even posit the possibility? Or is he in full no, it's the children who are wrong mode?
My sister starts off, the Canton thing is a homicide. I respond, this is at 3 in the afternoon on the 29th. Don't say a word to anyone. She said, of course not. I respond, and at the very least it's suspicious. She responds, this is your livelihood. And then I would never miss with that. 3:07, I respond, Julie and Chris were at the bar with the victim and girlfriend. Got to interview them.
Press with Rancor points out a fair point, is that the people that might be attracted to this job might also be the people who lack self-reflection. That is a very distinct possibility. Yeah. Yeah, that's a potentially fair observation. Noted.
Thank you. For the record, that was clip 4, extracted from Exhibit 4, the video from June 10th of 2024, beginning at 6 hours, 5 minutes, and 48 seconds approximately, and played till approximately 6 hours, 10 minutes, and 42 seconds. Detective Lieutenant Dwyer, did Michael Proctor's testimony about the messages he sent with his sister relevant to allegations A, B, and C, did that testimony continue under cross-examination on June 12th of 2024?
It did.
May I have clip 5, please, Madam Commissioner? And for the Commission and Council.
We've established that you're very close with your sister, Courtney, correct?
Apologies.
Sorry, please go ahead.
Apologies. Just for reference, I'll be asking the Commission to pause the video. There's a break in the testimony so that we can skip ahead. I'll be asking from this particular clip, the Commission to pause the video at 3 minutes and 57 seconds, and then skipping ahead approximately 2.5 minutes.
So please repeat, I'm sorry, you want me to play it to 3 minutes?
And 57 seconds.
And then advance it to?
And advancing it 2 minutes and 29 seconds, so approximately 2.5 minutes.
I know, to what number?
To about 6
minutes.
6 minutes and 20 seconds.
Yes.
Thank you.
Thank you for the quick conversion, Attorney Quinn.
We've established that you're very close with your sister, Courtney, correct?
Correct.
You provided your sister with updates on important advancements during the course of your investigation into this case. Did you not periodically?
I made her aware of newsworthy stuff.
That started as early as January 29th, 2022. Is that right?
Don't have the exact date or content.
Well, the day of the incident, you began letting her know that you were involved, that you had been assigned, what the status was,
Yes.
the nature of the case.
Correct.
It was a homicide, correct?
Yes.
Matter of fact, you discussed who the players were, who the people were that were involved. Isn't that right?
I just mentioned Julie and Chris were earlier in the evening.
So you mentioned the Alberts, correct?
Julie and Chris, yes.
You also mentioned the McCabe's too, didn't you? At some point.
Yes.
Yeah. At 2668, Your Honor, that's the page that I'm referring to. Okay. This one. You write homicide, correct?
So I said 2668?
Correct. I have my page number correct.
You're on the right page, Mr. Johnson.
Thank you.
Okay, go ahead, sir.
You wrote the word homicide. Is that right?
Yes.
You were describing to your sister the nature of the case that you are now assigned. Is that right?
Correct.
She wrote the Canton thing is a homicide, and you wrote don't say a word to anyone. Correct?
Correct.
And then she wrote of course not. Is that right?
Yes.
And then you wrote what?
At the very least, it's suspicious.
In the very least, it's suspicious. Correct?
Correct.
So at that time, at least at the time that you wrote that text on the 29th, at 3:05 in the afternoon, you believed that the case was suspicious, right?
It was before we found significant pieces of evidence.
So you believed that it was suspicious that it may involve the Alberts, right?
Absolutely not.
She then writes, this is your livelihood, didn't she?
She did.
Meaning, this kind of case could make or it could break your career, right?
Objection.
Existing.
She then wrote, I would never mess with that. Is that right?
Yes.
Your sister, Trooper Proctor, was warning you that you shouldn't be investigating a case in which close friends or family members were involved.
Objection.
Did you take her text? This is your livelihood. I would never mess with that. As a warning from her that you shouldn't be investigating a case that involved close friends.
Objection.
I'll allow it.
Absolutely not. That was in response to don't say a word to anyone. And that was how I interpreted this is your livelihood. I would never mess with that.
A couple of minutes later, 3:07 on January 29th, you told your sister, quote, Julie and Chris were at the bar with the victim and girlfriend. Gotta interview them. Is that right?
Yes.
So you were telling Courtney, your sister, updates on what your investigation advancements were, correct?
Just that part.
Interview, why are you going to interview him?
Yes.
She wrote, you gotta be kidding me, correct?
Correct.
Did you?
All right, advance it another 6 minutes and 20 seconds or so.
Yes, please. Thank you.
we know these people.
Again, that's how I read that message.
You don't deny.
Okay.
Sir, we're at the bar. I gotta go interview him.
Objection.
Allow that, is that what you do, Trooper?
No, I would not do that, sir.
So it's not newsworthy. These were details, internal details about the investigation, weren't they?
Yes,
And you were sharing them with your sister, Courtney Proctor, correct?
correct.
And
Will you be using this again, Mr. Carley?
No, ma'am.
Please go ahead.
Thank you. For the record, that was, again, Respondents Exhibit 6, the video from June 12th of 2024. Playback began at approximately 1 hour, 50 minutes, and 43 seconds. It was played till approximately 1 hour, 54 minutes, and 40 seconds. And then it was skipped ahead to approximately 1 hour, 57 minutes, 9 seconds, and played to the end of that particular clip, 1 hour, 57 minutes, and 51 seconds. All right, Detective Lieutenant Dwyer, I want to move on to the allegation that you assigned letter D for the commission's benefit. Again, that was the allegation you categorized as D was that Trooper Proctor allegedly sent derogatory, defamatory, disparaging text messages to non-law enforcement personnel about homicide.
Allegedly sent.
Is that true?
Very allegedly. Uh-huh.
Is it fair to say that as to allegation category D, sir, Michael Proctor's communications were also on multiple text message chains, one with the same large group of friends, another with his sister, and a third with his spouse?
Yes.
Was Trooper Michael Proctor's testimony on this subject, chronologically speaking, again, first addressed at that trial under direct examination from the prosecutor?
Yes.
And then also fair to say, this next clip will pick back up at a point we paused earlier, where Trooper Proctor was describing the text message chain with multiple friends, some in-state, some out-of-state, and conversation turns to Ms. Reed and her appearance.
Correct.
Madam Commissioner, may I have clip 6, please? There's no skipping this. That goes. Counsel's reference.
Second response, same number, Shihadli.
Apologies. For counsel's reference, this is transcript exhibit 5, respondents exhibit 5, date stamp beginning on approximately page 108. Thank you.
Second response, same number, Shihadli.
And turning your attention to the next page, 2538, at the top, if you could just read a series of responses from yourself, correct?
Yes, sir.
No, sir.
Yeah, so these came from me. From all accounts, he didn't do anything wrong. She's a whack job, C-U-N-T.
Objection.
So don't spell it, you have to, so these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Cunt. Yes, she's a babe. Weird Fall River accent, though. No ass.
And sir, what is it that you were referring to there, or why would you text them?
These were, from all accounts, he didn't do anything wrong. He's talking about the homeowner, Mr. Albert. I had mentioned the compelling evidence against Ms. Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
Sir, at some point, if I could turn your attention to page 2540. And there's a photograph that's shared within this text communication, is that correct?
Yes, sir.
And does it indicate who shared that photograph? From the prior page, possible.
The number ending in 5051.
And who is depicted in that photograph that was shared within the group text?
It's Miss Reed being escorted out of the State Police Milton Barracks.
And these are all from February 1st of 2022, around that time frame, is that correct?
Yes.
Now, sir, if I could direct you to page 2543. And sir, if I could direct you to the top of the page and ask you to read through that page indicating who's speaking and what the content of those communications are.
Okay. The number ending in 4146. Question, is that chick a smoke? Again, 4146, question mark. I respond EH. I respond again, not bag, as chief would say. I also respond with, she's got a leaky poo knot, leaks poo.
And what, if anything, is that in reference to?
Again, to Ms. Reed's some medical conditions there. Again, unprofessional comments I should not have made.
It's one way of putting it.
I'm proud of.
As far as attitudes expressed within these text messages and other text messages, what, if any, impact did that have as far as your investigation was concerned regarding these?
These juvenile unprofessional comments have zero impact on the facts and the evidence and the integrity of this investigation. They said these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
Thank you, ma'am. For the record, the last clip 6 just played, was from Respondents Exhibit 4, a video from June 10th, 2024, beginning at approximately 6 hours, 0 minutes, and 15 seconds, and played until approximately 6 hours, 4 minutes, and 22 seconds. Detective Lieutenant Dwyer, is it fair to say that that concluded Michael Proctor's testimony as to allegation D, demeaning Ms. Reed to his friends for June 10th, and he did not testify on that subject again until June 12th?
Correct.
Just before I ask for clip 7, I'm just going to note the next clip, clip 7, will come from June 12th. And for counsel and the commission's benefit, the transcript, Exhibit 7, Respondents 199, beginning at approximately line 11. If I could have clip 7 when it's convenient for the commission, please. Thank you.
I'm sorry, that's clip 7?
Yes, ma'am. Thank you.
Then 5051 changes gears. And he writes, she hot at least? Correct?
Yes.
And what was your response to that?
From all accounts, he didn't do a thing wrong. She's a whack job cunt.
From all accounts, he didn't do a thing wrong. She's a whack job cunt. That's what you wrote, correct?
Correct.
It's still funny. It's funny every time.
Yes.
Into your objective and unbiased, thorough investigation, correct?
Correct.
But sir, you didn't have all accounts, did you?
What I meant by that was
Did you or did you not have all accounts in your investigation?
the accounts we had was Ms. Reed struck Mr. O'Keefe with her vehicle, discovered taillight pieces at the scene. Those are the accounts we had.
The accounts
And
you had, I'm sorry, go ahead.
I'm sorry, go ahead.
The accounts you had, Mr. Proctor, were from two people named McCabe and one named Albert, who happened to be the homeowner and a Boston cop. Those are the accounts from recipient witnesses that you had, correct?
There was another additional witness that we had investigators that interviewed, Ms. Roberts as well.
And from all accounts, he didn't do a thing wrong. That was your decision 16 hours into the investigation, correct?
Yes.
And the other decision that you made and the other determination you came to was my client, Karen Reed, was a whack job cunt, right?
Yes.
What else did you say in response to, she's hot at least? Or she hot at least, question mark?
So following that text, I responded, yeah, she's a babe. Weird Fall River accent, though. No ass.
Yeah, she's a babe. Who's the she?
Miss Reed.
Weird Fall River accent, though. You're talking about her, the way she talks.
The accent.
And no ass. Now you're talking about her body or physique, correct?
Yes.
You think that's appropriate?
Absolutely not.
Then Bird chimes in with a little comedy. Ah, not newsworthy then, correct?
Correct.
In other words, well, she didn't have an ass. Nothing to see here, correct?
Objection.
Sustained.
And then 5051 says, oh, she's skating, right?
Correct.
And what did you write after that?
My response was zero chance she skated.
And then what?
Oh no, it seemed like there was a pretty good chance she skated. To be honest,
Zero chance she skates. She's fucked.
it seems more like a 100% chance she skates. Probability is 1.
Right?
Correct.
You decided on the 29th of January, 17 hours into this investigation, you decided individually, Trooper Proctor, you're not only going to put it on the girl, you decided
Twice
to
at that.
make sure this is cut and dry, and the way you
So since she skated twice, is that actually more than 100% probability? How does that work? Is it possible to have a probability that's more than 1? We'll get back to you on that.
you're going to do it is to make sure that she's fucked. That's what you were saying.
Objection.
All right, so that's sustained. You can, the content's fine. You have to ask it different.
17 hours into this investigation, Trooper Proctor, you made the decision that you were going to put it on Miss Reed, didn't you? Put the case on Miss Reed. She was going to catch the case, correct?
No, absolutely not.
What did you mean then when you said she's fucked?
After the day's investigation with multiple troopers conducting multiple tasks and a debriefing at Canton PD amongst detectives in my office, we went through the overwhelming amount of evidence against Ms. Reed that she struck Mr. O'Keefe with her vehicle. That's what I meant by that comment.
What you meant by that comment, Trooper Proctor, was you were going to make sure because 5051 had said she's going to skate. She's skating. When you said zero chance she's
We're going to skate to one song only.
fucked, what you meant was I'm going to make sure.
Yeah.
I am going to make sure Ms. Reed doesn't skate. She's fucked. That's what you meant.
Objection.
Sustained.
And then Bird decides to chime in. Good. No ass bitch. Right?
Yes, that's what he wrote.
And how did you respond to Bird saying, good, no ass bitch?
I laughed.
Thought that was funny, didn't
It is a little funny in a courtroom setting. I'm sorry. It is I know, like, you think that's funny. I'm sorry. It is a little funny in a courtroom set. I don't know, man. I guess one of the definitions of comedy is when you defy the expectation, right? One of the things that makes a punchline, or can make a punchline, is the subversion of the expectation, right? And so it's like, yeah, hearing this kind of language in court, yeah, it's kind of funny. Because it's not, necessarily what you'd expect. You expect law to be prim and proper and all the rest of it. You throw out a random, It's a little funny. Alan, sorry, I don't know what to tell you. Maybe I have a strange sense of humor. I don't know what's going on.
Trooper Proctor? Thought that was funny?
It was unprofessional of me. That's something I shouldn't have done.
Well, I think we all know it was unprofessional. It was a lot of things. I'm asking you, did you think it was funny?
According to my response at the time, apparently.
Then you sent a picture, just to add to it, to pile on, of Miss Reed being arrested, correct?
I don't... I'm not sure if that came from me, sir.
Let's skip to 2543. Are you there, Trooper Proctor?
Yes.
The date is now February 2nd, 2022. A person by the name of Doc writes, is that chick a smoke? Correct?
Correct.
Who's the chick?
Miss Reed.
And you write E-H, right?
Yes.
And then you write nutbag, as Chief would say, correct?
Correct.
Who's Chief?
A friend of mine.
And then you write what?
She's got a leaky balloon knot.
Trooper Proctor, explain to the jurors what a balloon knot is.
Your, essentially, I guess your rectum area.
Your anus?
Yes.
That's what you were referring to about Miss Reed?
Yes.
And you were making fun of her because you believed at that time that it leaked? That's how you were treating Miss Reed? Yes or no?
Yes.
And then you followed that up just to make sure you cleared up any mistake.
If his defense lawyers have, okay, I mean, seriously, defense lawyer isn't really the proper term here. If his lawyers have any argument at any point that passes the laugh test, at this, I will be amazed. It didn't seem from their opening that they're going to go on like procedural technicality. It seems like they're going to go on, this punishment was too much though. Maybe he deserved a letter of caution. Maybe he deserved a letter. But to be fired? Harumph, I say. Harumph. That appears to be the strategy here by his lawyers. Good luck with that plan.
About what you meant with leaks poo, correct?
Right, so I'm going to strike that. You could get this in, but do it the right way, Mr. Jackson.
You followed that up with the phrase leaks poo, didn't you?
I did.
Again, another reference to Miss Reed's medical issues and medical conditions, correct?
Correct.
Specifically focused on her anus.
Oh, good day, sir. Good day. Harumph, I say, and so forth.
Thank you. For the record, this is just...
Yeah, basically, his lawyers are basically trying to argue from incredulity, as best as I can understand their strategy. Can you believe Michael Proctor got fired for this? I mean, does that seem reasonable to you? I mean, come on. Woof.
Played clip 7, came from Respondents Exhibit 6, beginning at 1 hour, 1 minute, and 29 seconds approximately, and was played until approximately 1 hour, 9 minutes, and 38 seconds. Detective Lieutenant Dwyer, further as to allegation D of demeaning messages sent about a suspect sent to non-law enforcement, is it fair to say that Michael Proctor's communications also included messages he exchanged with his sister?
Yes.
Specifically, on February 4th of 2022, did Michael Proctor send a message reading, quote, "Hopefully she kills herself"?
He did.
And according to his testimony...
That's not exactly super encouraging.
Whom was he referring in that message, hopefully she kills herself?
Karen Reed.
Yeah, but his lawyers during their opening said there's no evidence of bias. Okay.
And further as to allegation D of demeaning messages about a suspect sent to non-law enforcement, is it also fair to say Michael Proctor's communications also included messages he exchanged with his wife?
Yes.
Specifically on June 9th of 2022, did Michael Proctor send a text message reading, quote, "We're going to lock this whack job up"?
He did.
And according to Michael Proctor's testimony, to whom was he referring in that message?
Karen Reed.
All right, Detective Lieutenant, I want to return to the subject of your allegation E at a later point in your testimony. Right now, I want to ask you a series of questions and play a couple of clips with regard to the next allegation that was sustained according to your investigation, allegation F, namely that Michael Proctor sent derogatory, defamatory, and disparaging text messages to other law enforcement personnel about a suspect in a homicide investigation. Specifically, I'll be asking for the next clip, which is in sequence clip 8. Before I do, however, I'd just like to direct counsel and the commission's attention. The page reference for the transcript is Exhibit 5, bait stamped Respondents 125. That I have at the commission's convenience, clip 8, and this one unfortunately does have a jump in the middle of it.
Do you want to request it as we put it in charge?
There's a skip of about 7 minutes and 15 seconds in the middle of the tape. So this particular clip is just for efficiency and administrative economy here.
You'd like it to run for how long?
If you could please have it run at the beginning for the first 2 minutes and 1 second, and then skip ahead 17 minutes and 15 seconds.
Skip ahead 17
to 9:16. Play to the end.
1916 or 916?
9:16.
916. Okay.
May I approach him?
Yes.
Open another document, asking, do you recognize that?
Yes.
You recognize that?
Text messages between myself and Trooper DeChico.
And again, what is the first message sent, date and time, last message sent, date and time, and number of messages contained therein?
First message sent, date and time, April 28th, 2022 at 1:09 p.m. Last message sent, date and time, April 28th, 2022, 4:45 p.m.
And the number of messages, sir?
4.
And if you could read the contents of those messages contained there. Please indicate who's speaking.
So I started out, of course, it's undetermined. She was a whack job. Trooper DeChico responds, "Dear God, WTF, what the hell's inconclusive about the whole thing?"
And as far as your indication there, as far as she was a whack job, who are you referring to there?
Miss Reed.
Now, as far as the undetermined or what you're talking about, what is sort of the content or the context of this conversation?
That would be the manner of death was determined to be undetermined by the medical examiner's office.
And so I ask you again, as far as your reference there in the bottom of the first page, as far as she was a whack job, whom do you believe you're referring to there?
Again,
Ms. Reed or the medical attendant?
Miss Reed.
May I approach your
Yes.
May I approach the witness room?
Yes.
And you notice the documents. You those look up when you finish. Do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Another text thread between myself, Trooper DeChico, and Trooper Kukowski.
And Trooper Kaskowski is another trooper within your unit in the state police, is that correct?
Yes.
And again, if you could read from the first message sent, date and time, and the last message sent, date and time.
First message sent, date and time, 5/24/2022, 9:21 p.m. Last message sent, date and time, 8/24/2022, 4:56 p.m.
And as far as the number of messages indicated within this text chain between yourself, Trooper Kukowski, and Trooper Chico,
494.
fair to say the documents before you do not contain 494 text messages, correct?
Correct.
Just in reference to that first page 2635, first message sent, that's May 20, 2022, around 9:21 p.m., is that correct?
Yes.
And that's a message sent from Trooper Kaskowski, is that correct?
Correct.
And what is that?
Appears to be a picture of a toy Santa Claus.
Now, sir, if I could direct your attention to page 2644. If I could direct you to the bottom of the page, sir, and see the text from yourself at June 9, 2022 at 11:19 p.m.
Yes.
Very bottom of the page. You know, may I approach just to point it out?
Yes.
Yes, see it, sir. Okay.
If you could read what you wrote on June 9, 2022, around that time, sir.
Do you like women who shit themselves?
Again, sir, what is it that you're referring to there?
Again, a regrettable comment I made about Miss Reed's medical condition.
Now, if I could direct you to the following page, 2645. And again, if you could read from that page as far as who is, indicate to the jury who is speaking and what is being said on page 2645.
I'm speaking right now. The statement she made tonight at age 7 was mental. Thank Christ it was on BWC, which is body worn camera.
Mm-hmm. Mm-hmm.
Trooper Bukowski responds, "That's her." Smoke. Trooper Bukowski again, what'd she say? I respond, "Said the Albans beat the shit out of O'Keefe, left him for dead, and that's why her taillight was cracked. She's gross." Trooper DeChico, "Oh, fuck her, bitch."
Okay, so can I approach the retreating room?
Yes.
Sir, with reference to that last bit, as far as June 9th, 2022, what was going on that day in reference to this matter again?
Miss Reed was being processed at the mill barracks.
Thank you. If I may have just a moment, Your Honor.
Yes.
Can I approach?
Yes.
Another set of documents to recognize those.
I do.
What do you recognize those to be?
Another text thread with members from my office, troopers.
And who are the troopers that are listed within that?
Trooper Chris Moore, Trooper Jeff Bukowski, Lieutenant John Fanning, Trooper Dave DeChico, and Sergeant Yuri Buchanan.
And what is the first message sent, date and time?
That would be 5/26/2022 at 8:19 p.m. Last message sent, date and time, 8/26/2022, 5:36 p.m.
And what is listed as far as the number of messages within this chain?
651.
And fair to say the documents before you do not contain all 651 of those messages within this chain, is that correct?
Correct.
Now, sir, if I could direct your attention to page 2682. You see a message sent from Trooper DeChico on August 17th, 2022 at 9:42 p.m.
Yes.
And is that an image contained on the next page, which is 2683?
Yes, it is.
And what is the image of?
That is a picture of Mr. Yannetti, appears to be from quite some time ago.
Now turning your attention to the next page, 2684. And there's a response from you, August 17th, 2022 at 9:44 p.m. Is that correct?
Sorry, what the date and time again, please?
Page 2684, 8/17/2022, 9:44 p.m.
Yes.
You see there's like sort of three responses from you?
I have, yeah.
If you could just read the three responses from yourself, sir.
Okay, so these came from me. Funny, I'm going through his retarded client's phone. No nude so far. I hate that man. I truly hate him.
Now, with reference to the investigation at this point, when you're talking about his client's phone, who are you referring to?
Miss Reed.
Mr. Carley, I'll ask you to please question the lawyer about this particular clip right now, and then we'll take a break after.
Yes. If I may note for the record, clip 8 that was just played, was played from Respondent's Exhibit 4. And the playback began from that clip at approximately 6 hours, 29 minutes, and 19 seconds, and was played until approximately 6 hours, 31 minutes, and 20 seconds. Then it was skipped ahead to 6 hours, 38 minutes and 35 seconds approximately, and played until the end of the clip, which took place around 6 hours, 46 minutes and 7 seconds on that exhibit. Lieutenant Dwyer, is it fair to say...
Do you think Michael Proctor will take the stand in his own case here? You think he'll take the stand? I mean, strictly technically, of course, well, yeah, the state should be able to call him if they wanted to, which would be hilarious. This could get stupid. I think they said that this is the state's only witness. They submitted a lot of stuff in paper already, so the state submitted like 60-something exhibits, which have already been entered. So the official file, basically, of the case has already been submitted on the record and is already evidence. So I think this is their only witness. But whatever. Yeah. Just ideas, I guess. Oh, so I guess we'll see if Michael Proctor wants to take the stand in his own argument about why he shouldn't be fired. That could be fun. I'm not sure what the defense is going to do. It's like, yeah, we've got experts, we've got witnesses. Who are you going to call? Ghostbusters? I don't think they're going to help. Even Ghostbusters has standards, man. Oof.
That from with respect to your review and specifically allegation F, derogatory text messages sent about the suspect to other law enforcement personnel. That testimony that was just played effectively concluded Michael Proctor's testimony from June 10th.
Correct.
And then it did not pick up again until June 12th on cross-examination. Is that fair to say?
Yes, it is.
At this time, I would suggest suspending questioning of the Commission's suggestion.
Thank you, sir.
Thank you.
So the time is about 11:41 a.m. and we'll do a 15-minute recess.
Exciting. That'll take us back to live. Exciting. All right, guys. Well, the stupid is on pretty hardcore. Not that we would have expected anything less. The state is doing kind of exactly what you would expect to do, right? They're going to let him testify against himself, right? Words from your own mouth, man. It's always a great strategy. So the state just wants to play that beautiful bean footage, and basically this guy is basically here just to sit there so they can have a vehicle to do that. This guy is just, I mean, he's the head detective, but he's not really here. Or the head internal investigator, but he's not really here. He's not really here. He's just here to be a conduit so they can play the beautiful bean footage, which, fine. That's fine too. That works. And then they're going to, basically probably just play the footage until they get bored. And then they're going to rest their case, with the rest of their case having been provided in writing. The file relating to, the steps that were taken, all the written record, because that's the thing, right? The written record is the thing. Because, that's what's there. And the defense is going to call, I don't know who they're going to call. I don't know. They're gonna try. I mean, the only thing they can really do here, which doesn't really work, but they could try to call some people who could try to testify that this is an unusual sanction. Like, they could try to call some people inside the police department to try to show comparables and show that this is outside the norm for the comparables. Good luck. Or maybe they could try to call some people like from a national frame to try to do that. Good luck. Or I don't know what they're going to do. I don't really have any great ideas here. As putting myself in Michael Proctor's shoes, or his lawyer's shoes, I don't really have any great ideas. They're coming to, it's like, how do I, and the standard is like preponderance. So there's that too. How am I going to overcome all that? Excuse me. Yeah, show the videos from trial and then rest. I think that's basically where we're going. I think that's basically what we're doing. Yeah, everything else is just the written record of the, investigation and disciplinary actions and so forth and so on, and the videos are the thing, and basically that's it, and that's the end of the state's case. Done in one. You know, because they don't need anything else. It's like, yep, that's it. We're good. So, yep. You don't need to, you don't need to make a case more complicated than it needs to be. If you got all your other evidence in through paper, which, makes sense. It's official record, right? And it is the thing. It's the thing we're disputing over. So, like, there's no basis to exclude it because it's the very thing that the defense also needs to contest, right? Their entire argument basically boils down to, fundamentally, he was denied due process. Well, they can't prove that except with the record. So them fighting to try to keep it out doesn't even make sense because, like, they need the thing to prove their case in the first place. So it's business records. It's records kept in the ordinary course of business. So it's a hearsay exception, official record of a governmental agency, and it's also the core issue of the dispute. So of course it's admitted. It's kind of the thing we're arguing over. So with the entire written record, excuse me, with the entire written record being submitted, then just bring this guy in to, like, play the beautiful bean footage for the impact value and call it a day. This is a great prosecution. It's like his opening argument was short, and he's going to have one witness, a one witness case. I'm here for it. Keep it simple, stupid. Great. Excellent. Good job. No, they're not finished for today. They're on a break. They're on a little stretch break, which is not a bad idea for us. We'll take a little stretch break together. Get some stretch in from my workout yesterday. It's also a good opportunity for me to make more water and use the restroom. Although I'll probably wait for testimony to resume so you guys have something on TV so you're not bored. I'll try to wait if I need more water in the restroom. Is it union? I don't know if it's union lawyers or not. I'm not sure who he is on his side of the table. I don't know if it's union. I don't know if the union wants a piece of this or not. Yeah, I don't know. I mean, presumably he had his union lawyers, when they were disciplining him, but I don't know if the union still wants a piece of this. Excuse me. Aren't they obliged, the union? Not necessarily. Depends on the union rules, but not necessarily. The union serves itself, like any entity. So the union typically, although not always, depends on the rules, but the union typically takes cases that it believes benefits the union. And that depends a lot on who is in charge of the union. Some union, organizations are of the view of defend everything. Some union organizations are more selective in cases they take. Depends on resources, interest, and what will serve the union. Right? So, are they obligated? Not necessarily. Depends on the union, but I'm going to go with probably not obligated. Probably not required to at this point, if I had to bet. Yeah. The union generally retains the right to say you're on your own. Yeah, basically. Yeah. That is usually the case. The union usually retains the right to say fuck you. They may or may not say fuck you for any number of reasons. But usually they have the right to say fuck you. He's got at least 2 more hearings. Great. Oh, thank you. No, I don't think he has more hearings. I think he has more days within this hearing, but I think this is the end of the administrative route. Yeah, I think this is the end of his administrative appeals. After that, he can go to court if he wants. Good fucking luck. Yeah. You don't understand the appeal on what grounds? That's okay. I don't understand on what grounds either. I am no more intelligent than you on this question. What are his grounds of appeal? I don't know. So far, the grounds of appeal, based on the opening argument, the grounds of appeal seem to be, yeah, maybe they could discipline the guy, but what they did was really mean. It was really over the top, Your Honor. That seems to be their appeal. Okay, all right, good luck.
Yes, ma'am.
Okay, so let's go back to the record. Good afternoon. We're now back on the record. The time is 12:03 p.m. And I've informed the parties that we'll be taking a lunch break at 1 p.m. for 45 minutes. Mr. Carley?
Thank you, ma'am.
Thank you.
For the record and for the Commission and Council's benefit, I have one last clip to play on this topic before I move on to other subjects.
All right, guys, I'm going to take a little break, a little stretch break. I'll be back in 5. Talk amongst yourselves.
At Respondents 136 for Exhibit 5. And for the Commission and Council's benefit, this will be clip 9. Unfortunately, there is a skip in it, but I have the timestamps ready. For clip 9, if we could play for the first 3 minutes and 8 seconds. And then pause.
Super Proctor, in the summer of 2020.
Go ahead.
No need to go back.
I interrupted you. Did you go for 8 seconds? I'm so sorry.
3 minutes and 8 seconds. Play for the first 3 minutes and 8 seconds, and then move ahead to 8 minutes and 3 seconds, and play to the end. And that would be the last time I ask for a jump in the playback. Thank you.
Super Proctor, in the summer of 2022, August 17th specifically, you were sitting at your desk, presumably alone at your office, at about 10 p.m. at night, going through my client's personal cell phone, correct?
Yes, sir.
As a matter of fact, you were sitting there texting with your friends and colleagues at Massachusetts State Police about you going through her personal cell phone. Is that right?
Correct, sir.
And that included Trooper DeChico, is that right?
DeChico, yes, sir.
Trooper Fanning, Trooper Butnick, Trooper Moore, and Trooper Kaczkowski.
Kakowski.
Tell me that again?
Kakowski.
Kakowski.
Yes, sir.
All right, all the consonants are silent. Fair enough. Trooper Fanning and Trooper Butnick are your supervisors.
Yes.
And you were bragging to all 5 of them that you were going through Karen Reed's cell phone about 9:45 at night.
Objection.
I'll allow it.
Is that right?
No, I wasn't bragging, sir.
How did you refer to Ms. Reed in that text exchange where you informed them that you were going through her phone?
I used regrettable language. I said going through his retarded client's phone right now.
You were shown a photograph of my colleague, Mr. Unetti, correct?
Yes.
May I approach?
Yes.
Same document. Your Honor, I think the court has the copy that I was going to use.
I thought I gave him that too.
received a photograph. Actually, Your Honor, if I could, I would ask that this document be marked as next in order. Assuming the witness verifies its authenticity.
So go ahead.
Do you recognize this document?
I do, sir.
Same document that you were shown, copy of the same document that you were shown by Mr. Yannetti, correct?
Stilali.
I've done that twice. Mr. Lally.
Correct.
All right. Is that a true and accurate reflection of the text messages that you were exchanging with Chris Moore, Jeff Kakowski, John Fanning, Vito DiCicco, and Yuri Buchanan?
Yes.
I've asked that this be marked.
Okay, any objection?
Yes, Your Honor.
All right, I'll see you at 5 on the head back, please.
Okay, good. A little bit back. That's not perfect yet.
Trooper Proctor, Trooper DiCicco had sent you a photograph of my colleague, Mr. Yannetti, correct?
Yes.
Your Honor, because of a technical issue, I'm not going to display on the television. May I display this hard copy briefly? Sure. Thank you. You see that, gentleman?
I do, sir.
Is that the photograph that you received?
Yes.
Is that what you referred to on direct examination with Mr. Lally about receiving a photograph from of Mr. Yannetti?
Correct.
And then your response was what?
I hate that man. I truly hate that man.
Actually, your response was, I'm going through his retarded client's phone right now, correct?
Yes, after the picture, sir, yes.
Who's the retarded client?
I'm referring to Miss Reed, again, on professional language.
Thank you. I'm asking who you were referring to.
Miss Reed.
You've got an explanation. Who was it you were referring to as retarded?
Miss Reed.
Karen Reed, the woman sitting to my left.
Yes, sir.
The subject of your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator, the person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
I'm going to sustain that, Mr. Jackson.
After you referred to my client as retarded, then you decided to make a comment about Mr. Yannetti, her lawyer, correct?
Correct.
And what did you say about Mr. Yannetti again?
I hate that man. I truly hate that man.
I hate that man. I truly hate him, correct?
Correct.
You didn't say I dislike him, disagree with him. You said I hate him, correct?
Correct, sir.
That's a visceral response to someone who's just doing a job, correct?
Objection.
Sustained. You can ask it differently.
Sure. Let me ask it this way. Were you upset or annoyed or pissed off that Karen Reed had gotten representation, legal representation, to represent her?
No, not at all. That's her right.
Well, let me ask you this. In August of 2022, you said you absolutely hate it, correct?
If we use absolutely. Yeah, I didn't use absolutely, sir.
You used truly, correct?
Truly, yes.
How do you feel about it now? You're sitting right there.
I still have a chair for him now.
I'll let it stand.
What did you tell your colleagues that you were looking for as you sat at almost 10 p.m. at night on a Wednesday night, August 17th, 2022, looking through Karen Reed's phone?
I didn't tell them I was looking through anything. They knew I was going through Miss Reed's phone. I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches. But like I had mentioned earlier, I have stopped.
Except Trooper Proctor, none of that really professional sounding stuff ended up in your comments to your bosses, did it?
Again, it was a poor joke.
Yes or no?
It did not, no.
It did not.
No,
As a
sir.
matter of fact, what did you write after you talked about going through the, quote, retarded client's phone?
Objection.
I'll allow it.
No news so far.
No nudes so far, correct?
Correct.
When you said that to your bosses,
Yes, sir.
you were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
Let me ask you a question. Have you ever looked for naked photos of a male suspect that you were investigating?
I don't look for naked photos on anyone's phones.
But you said you were looking for nudes of Miss Reed.
Like I said, Mr. Jackson, it was an inappropriate joke.
Sir, this is a citizen. She's a woman. You were supposed to be objectively investigating. Does your text message to your colleagues at Massachusetts State Police reflect an objective investigation of a citizen?
Objection.
You can get part of that question and ask it again.
Do you believe that your text messages were reflective of an objective investigator?
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes have, in unprofessional language, have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity, it's that they have no place in a professional investigation because it shows bias, right?
Objection.
So I have to sustain that as asked. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
Is that right?
Rephrase the question, please.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out, but from the start of the investigation, we didn't know what we had.
And your, Trooper Proctor, your point in saying no nudes so far to your colleagues in Massachusetts State Police was to suggest that you were looking for nudes and you'd update them when you found them, correct?
Incorrect.
Thank you, Commissioner. For the record, that last clip 9, came from Respondents Exhibit 4, the video from June 10th of 2024, beginning at approximately 6 hours, 56 minutes, and 56 seconds. It was played until approximately 7 hours, 0 minutes, and 4 seconds. And then it was skipped ahead to approximately 7 hours, 4 minutes, and 59 seconds, and played again until approximately 7 hours, 11 minutes, and 35 seconds.
Thank you, Mr. Crowley.
Thank you. Detective Lieutenant Dwyer, as I indicated, I'm going to divert us from the video clips for the time being and ask you a series of questions about your investigation's findings and recommendations for 2 additional allegations. Namely, I want to ask you about allegation that you lettered E, that Michael Proctor accepted a reward, gift, or gratuity, and allegation G, that he searched for nude photographs of suspect Karen Reed. Just to remind the Commission, sir, is it correct to say your recommendation as to both such allegations after your review of the evidence in this case was both were not sustained because of lack of sufficient evidence to prove them? Is that correct?
That is correct.
All right, beginning with allegation E, sir. What was the basis for the claim you investigated about Michael Proctor allegedly accepting a reward, gift, or gratuity?
He testified that in a text exchange with his sister, she had texted him that a potential witness in the investigation wanted to get him a gift.
All right. And based on your review of Michael Proctor's testimony at the Karen Reed trial, the first Karen Reed trial in the summer of 2024, what, if any, response did he give to that suggestion in that particular exchange?
His response was to get Elizabeth one, and he wanted to say that Elizabeth is his wife.
All right. Based on your review of Mr. Proctor's testimony, any applicable messages, and any other evidence from any other source that you gathered on this subject, did you find any indication that Michael Proctor, his spouse, or the friend had ever taken any action to further the request for or to actually obtain any gift?
No.
Based on that review, did you find an indication that Michael Proctor or his spouse had ever communicated with the friend about the gift or the possibility of getting one?
No.
As part of your investigation, and this is a subject to which we will return, did you interview Michael Proctor in July of 2024?
I did.
Did you ask him about this subject in particular, specifically this exchange regarding Get Elizabeth One?
I did.
And based on his answers to you in that interview, can you summarize what he told you and what, if any, inferences you drew from that?
He told us that when he got that text and he responded with Get Elizabeth One, he wasn't meaning to get Elizabeth a gift. He was trying to reference the fact that while he was working late and long hours on this investigation, his wife was home taking care of his kids. He was merely trying to show that the recognition, that his wife had deserved the recognition and not him.
And just to, I think I asked this question, but just to put a fine point on it, sir, did you ever find any evidence in your investigation to suggest any follow-up effort on Michael Proctor or anyone else's part to obtain that gift?
No.
All right. And did you take from that support for Mr. Proctor's statements to you in the interview that this was not meant to be taken literally, that he was not soliciting a gift?
Correct.
All right. Now shifting gears, sir, to the other allegation that you stated or found was not sustained, allegation G, sir. What was the basis for the claim that you investigated about Michael Proctor allegedly searching for nude photographs of Karen Reed?
He had texted some co-workers in regards to searching Ms. Reed's cell phone, no nudes so far.
And that was the subject of the last couple of clips that were just played, where he was under questioning by the prosecutor and the defense counsel during that portion of the Karen Reed trial.
Correct.
All right. And did you ask Mr. Proctor about this particular subject during your July 2024 interview of him as well?
I did.
Based on your review of the trial testimony and what he told you in that interview and any other evidence that you received on this point, what, if anything, did you find? What inferences did you draw?
So from his testimony in his interview with us, he had stated that he was authorized to be searching in her phone for geographical data, text messages, and he related, and I know this to be true, at least anecdotally, that it is not uncommon to find personal or sensitive photos on a cell phone when you're not looking for them.
Mm-hmm.
He stated that that the text he sent was an inappropriate joke, referencing that anecdotally true fact, and he had in no way or effort searched for any photos, and I found that to be credible.
All right, sir. And you mentioned a couple of things I want to follow up on. You mentioned he was authorized to go through that phone. Your investigation indicated he was authorized to go through Ms. Reed's phone at that time based on the authority of a search warrant?
Correct.
Right. And then I want to ask you about your statement that anecdotally you know certain things about where...
That doesn't sound right based on my prior understanding. I don't think he had a search warrant at that point, but did he? I was under the impression he didn't have a search warrant at that point. Maybe I had a factual misunderstanding. Pressing on.
Where that kind of content can come from during the search of a cell phone. When you say anecdotally, is that based on your training and experience, sir?
It is, sir.
And did you previously work as a member of an SPDU working major crimes cases in a similar fashion to Trooper Proctor?
I did.
And in terms of training and experience as to where you might find or where you might inadvertently find nude images contained on a cell phone, that's based on your personal experience of searching phones pursuant to warrants of the kind that Mr. Proctor had obtained.
It is.
I want to ask you the next series of questions, sir, about allegations H, I, and J that you investigated. Fair to say, sir, those particular allegations, as you termed them in your report, H, I, and J, those are all related to one another?
They are.
And in general, what was the nature of allegations H, I, and J?
In July of 2022, Trooper Proctor, along with a Canton police officer, had traveled to the Cape area to work on an unrelated invest. While they were down there, on their return trip home, they stopped for dinner, where Trooper Proctor testified that he had a beer or two and then drove home.
And did you receive information from Mr. Proctor either during his public testimony at the trial or during your interview with him that he was operating his department-issued cruiser on that occasion?
Yes, he was.
Okay. And fair to say that during the criminal trial, Mr. Proctor was asked about text messages he exchanged between himself and Canton Police Officer Albert at that time?
Yes.
One of the messages that was exchanged on the subject was Officer Albert saying, it's bad, I was hungover for sure today.
Correct.
And Officer Albert acknowledged that he had left his badge in the state police cruiser that Trooper Proctor was assigned at that time.
Yes.
All right. And just to split them off for a moment, just to be absolutely clear on the record, H, I, and J. Allegation H concerns simply whether or not he consumed alcohol on duty. Is that a fair characterization of allegation H as you phrased it?
It is.
Allegation I, on the other hand, concerns whether Mr. Proctor operated his cruiser after consuming alcohol.
Correct.
All right. And then allegation J concerns whether or not he put in for and received overtime pay improperly. Is that correct?
Correct.
Fair to say during his public testimony, he did answer some questions on these particular subjects that were of significance to your investigation on these 3 points.
He did.
Could you summarize, please, sir, what information did Michael Proctor provide by means of his testimony under cross-examination on June 12th, 2024 on these particular related allegations?
He testified that he drank 1 or 2 beers and then got into his cruiser and drove home.
Did he indicate that that particular instance was all on July 19, 2022?
He did.
And he also answered some questions about the text messages on that occasion and the following day.
Yes.
Now, I'd like to ask you about the follow-up steps you took, sir, personally, during your investigation of H, I, and J. For the week encompassing July 19th and ending July 23rd, 2022, did you have occasion to obtain Michael Proctor's pay station entry time report?
I did.
Can you describe, sir, just in general, what report that is? What kind of document is that?
So the pay station is our attendance. It's how we get paid. Every week we put in the hours that we work, and that's what generates our pay.
The particular pay station time entry report for that week that I just asked you about, was that ultimately attached to your report as Exhibit 9?
Yes.
Could you turn to Exhibit 9 in the respondent's exhibits, please? Is Exhibit 9 in front of you now, sir?
It is.
All right, so that's Respondent's Exhibit 9. Does that also line up with the Exhibit 9 that you attached to your report?
Yes.
All right. And that is the, just to be absolutely clear, that's the pay station time entry report for the week encompassing July 19th of 2022.
It is.
All right. Did you also have occasion to obtain what is known as the Administrative Journal Duty Roster for the Norfolk State Police Detective Unit, including any entries for Michael Proctor for shifts or overtime he claimed on the date of July 19, 22?
I did.
And did you ultimately make that Exhibit 10 to your report?
I did.
And is that the same Exhibit 10 that's Respondent's Exhibit 10?
It is.
All right. And then last in this group, sir, for the date July 19th, 2022, did you also have occasion to obtain an automatic vehicle locator, or also known as AVL report, for Mr. Proctor's assigned cruiser at that time?
I did.
Did you ultimately make that Exhibit 11?
I did.
And if you could turn to Respondent's 11, is that the same Exhibit 11 that you attached to your report?
It is.
All right, sir. Having obtained these records, could you please summarize for the commission what they contain and what, if any, inferences you drew from them with respect to these related allegations, H, I, and J?
Sure. The SBDU DAJ showed that he was scheduled to work on the 19th. His pay station shows that he did work and he did get paid for his regular shift, which was 8:30 to 5. It also showed that
he did get paid for his regular shift
from 8:30 to 5. It also showed that he also got paid overtime from 5 till 10:30 at night. The AVL logs confirmed that he was working. He did work he started work at 8:30, and he did return home at the time that was consistent with what he put in for his overtime.
And when it came to the AVL logs, because those are linked to the department-issued cruiser he was assigned at the time, those AVL logs indicate that in terms of his operation, he was operating that department-issued cruiser on that occasion.
Correct.
Based on his investigative duties that day, sir, did your investigation reveal that the department had authorized him to disable the cruiser's AVL capability in order to protect the integrity of the investigation he was working on that occasion?
Integrity.
And fair
Integrity
to say,
of
found no
investigation.
violation of misconduct in that respect.
Correct.
During, again, the same interview I asked you about before, the July 2024 interview that you conducted with Michael Proctor, did you ask him about these related allegations during that interview?
I did.
What information relevant, if any, to your investigation did he provide to you during that interview?
Trooper Proctor, he reiterated that he had 1 or 2 beers at dinner on his way home. He stated that his work down the Cape,
1 or 2 beers.
It's
always 1 or 2, isn't it? How many beers did you have? I had 2.
I found that from Canton to the Cape, to include travel time and the work and the time that he spent on his work down there, including the stop for dinner, that the amount of time he put in for overtime was appropriate.
Could I ask you, please, to go to Respondents 18 in your report, please. Could you go to specifically Respondents, page 502, please? You see paragraph 27 there on 502?
I do.
All right, sir. Looking at toward the bottom of 27, paragraph 27 on Respondents 502, 6 lines up, in about the middle of the line, 6 lines up, do you see the sentence that begins, "While there has been nothing found"?
Yes.
Could you read just that one sentence, or excuse me, just those 2 consecutive sentences, starting with "while there has been nothing found"?
While there has been nothing found in this investigation to support the notion that Trooper Proctor was intoxicated, department members are not allowed to consume alcohol while working. His testimony, combined with his statement provided to investigators, confirmed that he consumed alcohol and then operated his department-issued cruiser on July 19th, 2022.
There you go.
As a result of your entire investigation, and specifically your findings and the evidence gathered on this point, did you recommend sustained findings for both allegations H and I, consumption of alcohol and operation of a department cruiser after having consumed alcohol?
Yes.
And based on, again, the same information, and in particular directing your attention to exhibits 9, 10, and 11, what facts did you gather relevant to allegation J, the suggestion of potential overtime abuse, or the allegation of potential overtime?
So like I previously said, looking at or considering the travel time from Canton to the Cape, the amount of work he did, and the amount of time that he spent at the restaurant, I found was appropriate. It's entirely reasonable for troopers while they're working to stop and have a meal. It would be inappropriate if it was an extended stay at a restaurant. But again, factoring in the travel time, the time that he was working down there, and his return home, I found that he did not spend any extended period of time eating. So I found it appropriate.
So this was not an inappropriate request for overtime pay based on the statements of the department?
Correct.
And as a result, you recommended a finding of exonerated with respect to this particular allegation, allegation J?
I did.
Thank you, sir. All right, sir, I want to take you through the next few exhibits attached to your report, if I could, please. I'll be referencing specifically exhibits 12 through 18 in the next group of questions. Several times just now I asked you about the interview, the July 2024 interview you conducted in this case of Mr. Proctor, is that right?
Yes.
Did you have occasion to issue what's known as a standard subject call-in letter to Michael Proctor to arrange for that interview through his counsel?
Yes.
And did you ultimately make that initial call-in letter attachment exhibit 12 to your report?
I did.
And if you could go to exhibit 12, respondents exhibit 12. Is that the same exhibit 12 that you attached to your report?
Yes.
All right. And was that call-in interview date rescheduled in the case from that date to July 19th of 2024?
It was.
At the request of Mr. Proctor's attorney?
Yes.
And did it actually ultimately end up taking place on the date requested by his counsel?
Yes.
And was a second subject call-in letter issued as a result of the rescheduled interview?
Yes.
And did you ultimately make that exhibit 13 to your report?
I did.
All right, and that's the same exhibit 13 that's before you as respondents 13?
Yes.
Did you provide to Michael Proctor prior to beginning that interview the standard department administrative rights notice and waiver forms for the purposes of conducting that interview on July 19th?
I did.
24th? Were Michael Proctor and his counsel given full opportunity to read and execute those forms prior to beginning the interview?
Yes.
And were those forms constituting a total of 3 pages ultimately made exhibit 14 to the report?
Yes.
And is that the same exhibit 14 that's respondents 14?
No.
All right, so what do you have there?
This is a email to Trooper Proctor advising him of his call-in letter.
All right. Could I inquire of the commission that it's possible there was a printing error with regard to the witnesses binder?
Yeah, you can approach it with a minute.
Okay. Thank you. Could I inquire of the commission with respect to, there appears to be a printing error with regard to exhibit 14, and I apologize to the commission. Is there a way to refer to the exhibit 14 in the commission's copy?
Yes, do you have exhibit 14? Hold on a second.
May I approach? All right, sir. My apologies for the confusion. Exhibit 14. The Exhibit 14 that's now before you as Respondents Exhibits 401, pages 401, 402, 403, and 404. Are those the administrative rights and waiver forms that were executed by Mr. Proctor and counsel on that occasion?
Yes.
My apologies for the confusion. The interview of Michael Proctor on that day, was that taken in the presence of counsel?
Yes.
And was he afforded, he being Mr. Proctor, afforded the opportunity to consult with his attorney as much as desired before answering questions?
He was.
Was the interview recorded?
Yes.
How was it recorded, sir?
On a digital handheld device.
And I'll note for the record that that's been submitted as Exhibit 15 to the Commission.
Yes, thank you.
Detective Lieutenant Dwyer, ultimately, just to round out this particular series of exhibits in this portion of your report and the respondents' exhibits, did you ultimately include what's known as a concise history, which is essentially a disciplinary history for Michael Proctor, and include that as Exhibit 16 to your report?
I did.
All right, and I'll note for the record that that was served as Exhibit 16, Respondent 16. So, just to be absolutely clear on the record, Exhibit 15 is the transcript of the testimony by Michael Proctor during that interview, and 17 is the audio. I apologize for any confusion. Sir, and I think we referenced it before, but just to be absolutely clear on the record, Respondent Exhibit 18 is your report that you all authored in this case.
It is.
All right, so moving ahead, if I could please, to the next set of exhibits. I have a series of questions on exhibits number 19 through 29, respondents 19 through 29. During the course of your investigation, were you permitted on the execution of the non-disclosure agreement that you mentioned earlier from the Federal District Court of Massachusetts to obtain and use for this disciplinary investigation copies of the trial exhibits from the Commonwealth versus Karen Reed prosecution containing the text message chains that have been referenced here today?
Yes.
All right. And if you could please refer to exhibits 19, 20, and 21. If you could just briefly take a look at 19, 20, and 21 as in the binder for you, and just tell me if those are correct representations of the trial exhibits that were obtained from the Norfolk Superior Court in this case.
Yes, sir.
Now, I'd like to ask you a couple of questions about exhibits 22 and 23. Could you turn to 22, please, sir? Respond to 22.
Yes, sir.
Could you just briefly describe for me, please, what is exhibit 22?
It is a training bulletin that's sent out to all members of the Mass State Police.
All right, and specifically, this particular training bulletin contained in Respondents 22 is Training Bulletin 2017-19?
Correct.
Does that title for that training bulletin indicate it was issued in the year 2017?
Yes.
All right, and the title of the particular training bulletin is Use of Communication Devices?
Correct.
All right, and just for completion here, is Exhibit 23 second issuance of that training bulletin with a 2018 date?
It is.
And is that the content of those essentially identical, sir?
They are.
All right. Are these documents examples of notifications put out by the department to all employees, alerting them to specific legal policy and other developments as they arise?
Yes.
The two bulletins here together, exhibits 22 and 23, do they inform sworn members of an occasion in which a superior court ordered the production of law enforcement officers' personal smartphones in order to extract discoverable information from them?
Yes.
And specifically discoverable statements by law enforcement contained on personal cell phones in connection with a criminal case?
Yes.
Do they further indicate that that was done because officers had been communicating and therefore making statements about an official investigation on their personal smartphones?
Yes, sir.
In other words, the department was bringing to its employees' attention, specifically directed to members involved in criminal investigations and prosecutions, the discoverability of statements by law enforcement in the form of communications on personal and electronic devices.
Correct.
If you could now refer, sir, to exhibits 24 and 26, 24 through 26, 24, 25, and 26. All right, sir. Are you at exhibit 24 to begin?
Yes, sir.
Is that a copy of Article 5 with an effective date of December 6th of 2023?
It is.
And Article 5 is one of the department's rules and regulations, specifically its rules of conduct applicable to all sworn members.
It is.
All right, sir. And with respect to exhibit 25, is that also known as Department Rules and Regulations, Article 6?
Yes.
All right, sir. And specifically with respect to Article... Apologies. Specifically with respect to Exhibit 25, Article 6, this is titled Regulations Establishing Disciplinary Procedures and Temporary Relief from Duty.
Correct.
And these are also applicable to all sworn members of the department as of the effective date of this policy, September 27, 2023.
Yes, sir.
And finally, sir, Exhibit 26, is that known as Schedule A, or Appendix A, stating the disciplinary guidelines for the department effective as of September 27, 2023?
It is.
And with respect to the specific charges and specifications that came about as a result of the findings of your investigation, can those be found on the internal charge sheet for Mr. Proctor's trial board and the accompanying charge summary?
Yes, sir.
Can you go to Exhibit 27, please, sir? So the respondents 673 and 674, is that correct?
Yes, sir.
Does that appear to be the charge sheet for Trooper Michael Proctor, then Trooper Michael Proctor, for IAS 2024-0014, in other words, your investigation, sir?
Yes.
Madam Commissioner? Yes. At this time, I'd like to ask Detective Lieutenant Dwyer a series of questions regarding Respondent's Exhibit 35, and specifically the 3 clips that I provided to the Commission. So I just wanted to ask for clips A, B, and C queued up if possible. Thank you.
Sorry, are you going to play them in their entirety?
They will be played in their entirety. There is no skipping.
Thank you. The defendant has kindly kept what of the time?
They total less than 5 minutes.
Okay.
If it's the commission's inclination, I'd suggest playing through those clips and then breaking for lunch if that's
It's up to
acceptable.
you. We could do one, then questioning the one that we do need to stop at 1 o'clock.
Thank you. I will be sure to end before 1 o'clock. Before we play clip A from Exhibit 35, Detective Lieutenant Dwyer, if I could just ask you, sir, following the termination of the appellant from the department, did you have occasion to learn of public interviews that he provided to news outlets that were broadcast in June of this year?
Yes.
Was one of them the ABC News program 2020?
Yes.
And did that air on June 17th?
I believe so.
Okay. With respect to this particular news interview that was broadcast at that time, Exhibit 35 for the record, this took place after your report was concluded, after the trial board was concluded, and after Mr. Proctor was terminated. Is that correct?
Correct.
There is no sense in which any of this, because it postdates those events, there's no sense in which any of this directly led to or was part of the disciplinary process that had started with your investigation. Is that correct?
Correct.
These are simply statements by the appellant made publicly after his termination was issued by the government.
Correct.
Was your attention, prior to your testimony here today, sir, was your attention directed to that interview and a series of particular statements made by the appellant during that interview?
It was.
And did you have occasion to review those portions of that interview prior to your testimony?
I did.
May I ask, please, that clip A be played?
The murder mystery just outside of Boston, sparking some explosive accusations against law enforcement.
Do you think Proctor will testify, Karen?
I don't believe so.
The lead investigator on this case, Michael Proctor, did not take the stand this time around. His highly offensive text messages about Karen Reed, which were obtained from his personal cell phone during a federal investigation, they rocked that first trial.
She's a whack job. Yeah, she's a babe. Weird Fall River accent though. No ass. No nude so far. She's gross.
During the retrial, the defense once again accuses him of running a biased investigation. You'll learn there's not a single part of this case, folks, not a single part, that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. And while the prosecution condemns Proctor's text messages, they stand firmly by the investigation.
There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted.
Within hours of that first trial ending, Michael Proctor was relieved of duty by the Massachusetts State Police. He was later fired. He sat down for an exclusive interview with us and addressed those text messages, some of which were sent to personal contacts outside of law enforcement.
Who are you writing to? My good buddies that have been friends since first grade. Kid hasn't had a homicide for 20 years. So they're naturally interested, just regrettable messages. But in all the content and the messages, what you don't see is a conspiracy.
What do you see?
I see someone who's caught up in the moment of investigating, a fellow police officer and just
someone caught up.
Things.
Can you see why people called you sexist and misogynist?
Yeah, absolutely. Yeah, I can 100% understand why.
Commissioner, at this time, if we could have clip B played, also from Exhibit 35.
I mean, I think one of the texts that you sent about Karen Reed is that you said hopefully she kills herself. You texted this to your sister. That seems incredibly unprofessional for a homicide investigator.
speaking about his suspect?
It was made in jest. You know, it's a figure of speech. Hopefully she kills herself like that. Not
As a figure of speech? Do you use that commonly?
Yes. Not commonly, but it's a figure of speech. I made it like jest. It wasn't like literally, I hope she kills herself.
At what point did you develop such strong negative feelings about Karen Reed that you would say things like, hopefully she kills herself, or calling her the C word?
Those feelings developed as the case went on.
I mean, can you see how people might think, he was caught in this instance speaking about a suspect in this way. Maybe it's happened in other cases as well.
I 100% understand why people would think that. But when you have, you know, a fellow police officer around my age, 2 kids of his own, it generates an emotion. And I expressed those emotions in a negative way, which I shouldn't have. I shouldn't even, you know, been texting my friends anything.
Do you want to put the last one?
Yes, please, if we could have one final clip. It's less than 30 seconds.
And the defense never misses an opportunity to mention the name Michael Proctor, the lead investigator on this case.
This case carries a malignancy, a cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. His name is Michael Proctor.
Nice.
It is not hard to conclude that Michael Proctor's words provided the jury with reasonable doubt in the first trial.
Among other things, yes.
That concludes the clips that I called special attention to the commission's special.
Yeah, trying to figure out how to get to reasonable doubt is not the hard part. Which way do you like to get there? Which is your favorite way? Yeah. Pick one. Yeah.
Commission's commission got to return exhibit 14 to thanks.
Beep. I don't know what we're doing now. We're just enjoying some colors and oh Lord. I think we're on lunch break now for 45 minutes, if I understood correctly. Because it's that time. They said they were going to go on lunch break at 1. So I think we're on lunch break now. Okay. Well, that's nice. All right. Well, summary. Yeah, the Proctor's kind of doomed. We knew that going in. I don't know what his defense is going to do. Because the state only has to show this by preponderance. And they have to prove they gave him due process within the meaning of the hearing, but it looks superficially correct. And his defense basically, his opening argument basically is, yes, Proctor did some bad things, and maybe he deserved a reprimand, but firing him was a bridge too far. That's what they want to do. So their only real hope of proving this would be to try to find comparables and argue that he was punished arbitrarily by the comparables. So they would need, well, first of all, finding comparables hopefully is going to be somewhat tricky, given what he did. So they would have to find, in order for them to win this argument, they basically have to find comparables and prove that the reasons they fired him were for pressure reasons rather than legitimate, he did bad things reasons. I don't have a lot of high hopes in their possibilities, you know? And he also did multiple things, and some of them were pretty egregious. And also, like, they're allowed to punish him more because they don't like him in particular. All right. This is just like the bad side of the equation when, you have a judge, for example, right? So a judge can give you mercy because they like you, and they can also decidedly not. Right? So as long as the judge is within the statutory range, as long as what they're doing is legal, then the only question you have left after that is whether the decision is basically so arbitrary or so egregious as to basically defy reason. Right? The judge's sanction, either like it's so low it defies reason, which occasionally happens, which is hilarious when it does, right? So occasionally you have the state appealing the penalty, right? They're not appealing the conviction, right? They're appealing the sanction, they're appealing the sentence. The state can do that, right? Because it's not a double jeopardy problem, right? It's not, because jeopardy is liability, right? That's what jeopardy is, liability, right? So the jury found you guilty, and then judge is like, I sentenced you to nothing, and the state's all sad. The state can appeal. Sometimes they do, and sometimes they win. The Court of Appeals is like, no, this is too low. This is some bullshit. Absolutely not. Fuck you, right? And of course, that goes the other way sometimes too. Sometimes the judge goes way off the reservation, and the Court of Appeals is like, no, this is way too harsh. This is so far outside the bounds. No, I don't think so. Fuck you. But kind of both ways, it's unusual. Right? Both ways is pretty unusual because the judge gets a lot of latitude in their sentence. And so it's like, even as long as they're picking anything that's even remotely plausible, right? Which can be, of course, dependent on your factors as they do. It can be based on your unique things as it does. So based on you and what you're bringing to the table, right? As long as they're within the Overton window, and it's a pretty wide one at that, they're not going to overturn it. So, like, not only do you have to show, like, that his sentence was outside of the norm for what he did, which, seems challenging enough at best, but basically it has to be so far outside the norm of what's normal that basically his punishment becomes arbitrary. And I don't have a lot of high hopes in that possibility. That does not strike me as and their opening argument didn't exactly instill me with confidence that they have it. They didn't exactly say, Your Honor, we have 10 comparable cases. We have 10 comparable cases, and in our case, we are going to, make these 10 cases of the record. We are going to show you how these 10 cases are all comparables, and we're going to show you that this is simply a bridge too far by the comparison of 10 other anchor cases. They didn't make that argument. Their argument basically amounted to, how about a written suspension, or how about a letter of caution? How would a letter of caution work? Does that work? Right? And it's like, no, right? I mean, maybe the commissioner could have done a letter of caution, but he didn't. So like, but now you're going before a reviewing person to say, oh, what that guy did was so outside the bounds. It basically is abhorrent. It basically shocks the conscience. It shocks the conscience kind of territory. It's so outside the bounds. Yeah, no. And, well, what he did was definitely special. And, he got attention to it. Sometimes that's your bad roll of the dice, right? It's just it's a bad roll of the dice. Like, a lot of cases just like go under the radar. A lot of cases are just the radar, but for whatever confluence of reasons, and in this case, we can understand exactly what that confluence of reasons is, but never mind. For whatever confluence of reasons, your case becomes the poster child case of the day, and then you just get to suck it. You get to suck it, right? So normally the cop just pulls everyone over for speeding and gives them the speeding ticket, but today is just your extra special day. Today's your extra special day, and for some reason your speeding ticket gains the media's attention, and now the prosecutor's after you. Yeah, it just sucks to be you now. That's unfortunate. Sorry about that. Whoops. Sucks to be you. So yeah, I don't really have any of those things to, deal with. Good times. Yeah. So this hearing is going to go nowhere, I would imagine. And the court is going to do the same thing. The court, if he tries to take this to court, the court's going to do the same thing this hearing officer is going to do. Basically, it's going to just become basically like, okay, did they give you the due process you're due? Which they almost certainly did. And assuming they did, was his sentence or his sanction so outside the bounds, so beyond the norm, so deviating from the standard as reflected by these anchor comparable cases, if they exist at all, that this screams for relief. Because the judicial branch is not really out to just contradict the executive branch for the hell of it, or they're at least not supposed to be, right? It's like we all like to stay in our lane. At least good judicial branch. Good judicial branch likes to stay in its lane. Good executive branch likes to stay in its lane. Good legislative branch likes to stay in its lane. And they kind of like to stay in their lane. So the judicial branch is not really out to get the executive branch in the first instance. They're like, you're the executive branch and you get to make decisions, and we're going to back your play as long as they're legal and have any semblance to reality whatsoever. And so, there's that. So he has no viable grounds of appeal that I can see, unless he's just got 10 rock solid. Unless he's got 10 rock solid, maybe 10's too much. If he's got 3, how about 3? Do you have 3 rock solid comparables? Do you have 3 rock solid comparables that you can show that this is just so far beyond the pale? No reasonable person, blah, 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 blah. Can you show that? No? Okay, then shut the hell up. So, good times. And that's where we're sitting right now. And the prosecution is kind of doing, well, prosecution is not really the right term. The state is doing what it does. It's like, yep, these are the reasons we fired him. We have to prove to you why we fired him. Here it is. Here's why we fired him. Oh. Yeah, why'd you fire him, state? Why were you so mean? Here are the reasons. Oh. Oh, okay. Yeah, all right. Okay, so Proctor, why do you think they shouldn't have done that? And I guess he's going to come back in October with his reasons about why they shouldn't have done that. Don't have a lot of hopes for him. So, yeah. Doesn't strike me as a very, very defensible position. Yeah, examples are allowed to be made, that too. Yeah, they are allowed to use you and make an example. Not like in an arbitrary way. They can't but they are allowed to make you an exemplar. It's like, yeah, we're using you as well, in fact, that's one of the fundamental bases of punishment theory. If we want to talk about the fundamental reasons for why we punish people, like the fundamental basis for why we imprison people, why we send them to jail, why we do fines, like why do we punish people? What fundamental theories of punishment 101. Okay, here are your fundamental theories of punishment 101. General deterrence. We're punishing you as a warning to others, right? The reason we're punishing you is so that people will see that you're punished and they will be like, I don't want that to happen to me, and so I won't do the thing. General deterrence. Specific deterrence. We're trying to stop you in particular, right? This is not about a message to people in particular. This is about a message to you. If we punish you, maybe you won't like it, and maybe you'll stop doing the thing in the future because we punished you. So maybe you won't like the thing and you stop being bad, so you'll stop being punished. Specific deterrence. Isolation. Well, this only really applies to jail or prison, but we are separating you from society. We're punishing you for the sake of separating you because you're dangerous, right? You are not fit to be around society for every possible combination of reasons. Our motivations to punish you is specifically to keep you away from everyone else. Isolation. Reciprocity. We're punishing you to balance the scales. You did a bad thing. This harms society, and we are punishing you to rebalance the scales. so that the scales will be even again. So that's reciprocity. Okay, what else is there? Oh yes, also there is rehabilitation. We are punishing you so that you'll get better. We are punishing you so that you will learn how to not suck as a person and a citizen, and maybe you'll learn some useful skills, and maybe, you'll learn, like, will make you better, like morally or something. And, we're trying to fix you and re-educate you. So rehabilitation. Is there anything else? Let's see. There's rehabilitation, isolation, reciprocity, general deterrence, specific deterrence. I think that's it. So yeah, basically, yes, we are punishing you as a warning to others is in fact one of the fundamental bases for why punishments exist. Welcome to my TED Talk. Yeah. This also is interesting, like on the death penalty, for example, because depending on how you measure it, like these goals are good. Like people say, well, the death penalty isn't a deterrent. And I always like to say, well, it's an outstanding specific deterrent. It's a fantastic specific deterrent. Yeah, we're trying to motivate you not to commit crimes. Yeah, you probably won't commit any more crimes. It's outstanding specific deterrence. It's also very good for isolation. Yeah, you're definitely separated from society because you're dead. So very good on isolation, very good on specific deterrence. Yeah, it does have some benefits. Not so good on rehabilitation. So it kind of fails for rehabilitation. But I suppose the idea is you're not rehabilitatable. So it fails on rehabilitation. But then again, life imprisonment also fails on rehabilitation. Because so if you compare death penalty to life imprisonment in these metrics, it's not that clean. Okay, so all right. In terms of specific deterrence, well, I mean, the death penalty is slightly better because you could commit more crimes while you're in prison against other prisoners or against prison guards. So specific deterrence, the death penalty wins out. General deterrence, is it any more of a general deterrence for the death penalty than, life imprisonment? Is there any advantage? Yeah, we'll call it a wash. We'll say it's even. Rehabilitation, it's even. We're not trying to rehabilitate you with life in prison, and we're also not trying to rehabilitate you with the death penalty. So it's even. Isolation is slightly better for the death penalty. You are more isolated by the death penalty than not. And what else is there? Let's see, we did specific deterrence, general deterrence, rehabilitation, isolation. And what's the last one again? Reciprocity. Yeah, reciprocity. Death penalty is slightly better on reciprocity. So the it's marginal though, but it is slightly better. So that is the case for the death penalty. You break even on rehabilitation. Let's say you break even on general deterrence, so we can avoid having the discussion. You're obviously better on specific deterrence. You're better on isolation, and you're better on reciprocity. So those are the reasons to have the death penalty, in short. Welcome to my TED Talk. And then, like, the biggest argument against the death penalty is the risk of error. But the risk of error is interesting because if the alternative is life imprisonment without the possibility of parole, the risk of error calculation is not clean. It's not clean. It's not necessarily clear between the death penalty and life imprisonment if you're concerned about convicting the innocent, which is, to be fair, a realistic concern, but if you're concerned, it's not necessarily clear in the first instance where you're better off if you're concerned about that. Because while life might afford you more time, the death penalty by its nature affords a more thorough review. Because death is different, as they say. And so the death penalty at every single stage is a more exacting review. So if you were actually innocent, I'm not sure it's necessarily clear if you'd be better if you're actually innocent and your principal concern is, your innocence being exposed before it's too late. I'm not actually sure between death penalty and life imprisonment where you're better off. I'm not sure where you're better off between the two. I think there's a case to be made. You might be better off with the death penalty, but it's an interesting calculation. What else can we talk about? That's an argument that life imprisonment cases should also receive that level of scrutiny. Perhaps. Perhaps. There's many ways to address this issue. Brand was paid $556,000. I don't know anything about his appointment or payment agreement. I don't know anything about that, so you can't intelligently comment about that. I would say that he put in work and he deserves to be paid regardless. I mean, so that'd be my view. He deserves to be paid for his job. So as we were sort of commenting earlier in text when we were chatting, things at the gym continue to go well. I kind of overdid it a little bit yesterday. I was like, oh, let me set PRs. And then I was like, oh, let me just put more weight on. And I kind of overdid it yesterday. So I set a new PR on deadlift, at least in recent memory. 10 years ago, I had higher PRs. But, in my last, couple of years, this is recent PR. And so I'm pleased about that. So I set new PRs. I've set new PRs recently on bench, deadlift, and squat. My biggest limitation now on deadlift and squat is my lower back. So that needs some strength. So I'm going to have to do more cable pull-throughs and more hyperextensions or something, because my lower back is the biggest limiting factor at the moment. So I need to work out that muscle more. I'm still trying to hit 300 bench by my birthday on January 13th. I'm currently at a estimated 1 rep max at 250. So I have to pick up 50 pounds of bench between now and the 13th of January, which is doable. But yeah, that's 4.5 months now. And I was doing machine plate press and machine plate incline press last time. So we're still working things out and making progress. So life is good. Life is good. In terms of today's workout, the app today is recommending principally accessory work. And the hardest lift, I think, is cable row or something. So I'll probably try to go to the gym and try to do the accessory work lifts. That'll be good. But that's the updates for those of you who care about such things. Progress is being made. My ultimate goal is a 405 bench, which ChatGPT is telling me for my age would put me in the top 1/10 of 1%. I probably didn't need to know that information, but we're going to try. Although my case is a little bit easier than it's estimating because I'm supplementing testosterone with a doctor's prescription. So because my testosterone is higher, that makes my odds significantly better. So, yeah. That's positive news. What do you guys want to talk about while we're chilling? Excuse me.
Hi, I'd like to.
Oh boy, the worst debater.
Should we watch this video from Warren Smith about this MSNBC debater? Let's watch this because this sounds mildly hilarious. This debater was so bad. For those of you who missed this was like legendarily horrible. I assume not all of you saw this. So there's a thing called Jubilee, and Jubilee it's like one person versus like 20 on some subject of debate, and this woman who was the one was like so incredibly like bad. It's actually mildly hilarious. It was like one person, I think it was like one person versus 20 black conservatives, I think was what it was. So she's not a Democrat by her own admission. She is a radical. Okay. And she's debating 20, like college age kids, I think, roughly, who are all black and all Republicans, or all conservative. And she made herself look like an idiot. Let's watch this thing because this is good shit.
In the world is back on MSNBC of all places.
No, nobody ever made a valid point.
And if you thought it couldn't get worse, well, you're wrong.
What was your goal? Why go into that space knowing it could go off the rails?
So now we can see her perspective and strategy.
Because ultimately we are in a desperate time of disinformation. Like, I call this the age of idiocy, right?
This is just incredibly ironic. This is the woman who claimed that statistics cannot be relied upon.
And we know that when it comes to the internet, when it comes to media, there really has just been a commitment to not telling whole truths. We know that when it comes to academia.
If you think academia is not progressive enough, we need to pump the brakes right there.
It's just not a truthful time, and I know that I'm OD truthful.
You're OD something, but it's not truth.
Which is why sometimes people have an issue. But when you are of this type of mindset.
That's the word. It's a mindset. It's not necessarily revealing truth. It's more just ODing on a mindset.
When you are a revolutionary, when you know that you have the facts.
The certainty that she knows she has the facts.
You are responsible to explain it over and over and over again. That is a quote from the great Thomas Sankara of Burkina Faso.
I have no idea who that is.
And I know that about myself and many of my peers. We understand that we have to put ourselves in these spaces sometimes and take the bruise and annoyance, knowing that we aren't speaking to just these individuals. We're speaking to an entire audience watching who may never have heard what we have to say, and they need to.
There's nothing that you said that I have not heard. None of your arguments were original. I heard all of that in graduate school.
Of everything you discussed, what was the most contentious disagreement? And then what was your most surprising point of agreement?
Get a load of this. The thing that was most contentious to her was the idea of responsibility for one's own actions.
So I would say the most contentious point of agreement was that across all of the claims, because you have to make 4 claims, then you're debating things that are undebatable, but that's another combo for another time.
Notice that these topics are undebatable. So what were you doing there?
They all seem to keep coming back to black people are the problem with black people.
The person who has the greatest chance of bringing me down is myself. That is a revolution. That's a crazy idea to her. I am responsible for myself.
There was simply no concept of cause and effect, of the continued oppressive behaviors and legislation.
Behavior is subjective. You should be able to point to specific legislation, though. And yet, I have not seen any examples.
Talking about the ways in which we are still continuing to see systemic racism experienced across the nation.
Notice she does it again. Indicators of it being experienced, which is purely subjective, which means that you don't need evidence.
And they just failed to regard that as anything of impact. And it didn't matter how many examples I gave. I would say the surprise point of agreement was actually more of a surprise for them than me, because the last person, you argue a claim that they have, and they had a claim that black people should leave the Democratic Party. And I let him talk, and I let him talk, and then I said, I agree. And he was like, But ultimately, I am of a mind that one of our biggest misses that we did after the civil rights movement was that we didn't form a third party.
So would this third party be a black-only party? What are you saying?
Was there any moment in that debate where you moved from
no, of course
where
not.
You were going into
not even
it
chance.
in a direction one way or the other?
What do you think the odds are that she changed her mind on anything? Less than 0, probably. Shout out to the sponsor of this video, Cove Pure. You might have heard Joe Rogan put it once. Why are they putting fluoride in our water? Just brush your damn teeth. And he's got a point. Some people really...
Did anything...
I moved further away from them.
Either further away? That's the only thing.
It was like this.
That's
like,
it, the whole
oh my gosh. Yeah, because...
and nobody made a point.
You know what? Actually, I'll tell you this.
Yeah.
It wasn't... No, nobody ever made a valid point.
The entire debate, no one made a valid point.
Not a valid point. I was going to say nobody made a point that you could say, oh, I understand why you are making that point, even if you disagree with it.
The MSNBC host seems genuinely shocked by this statement.
It was more so that I could understand how they feel.
Right.
Because they weren't making points.
Yeah.
They were stating feelings about, I feel this way because this happened to me.
You accuse the other side of doing the very thing that you subconsciously know you're doing, but you don't want to acknowledge it. You accuse the other person of doing it.
You know, I feel this way because I read a book, and so I feel this way.
It's an extremely manipulative behavior.
But
if you read a book and you found it to be informative, it's like, I feel this way because I read a book. Isn't that like the principal way of learning since they invented, the printing press? And to be quite fair, even before then, was by reading books or scrolls or, yeah. Was that like how people learned? Or like, Yeah. By reading or having it read to them, as the case may be. What are we doing now?
I went in there, and immediately when I got there, I realized, oh, I actually don't want to argue with these people. I love these people.
So you love them purely because of the color of their skin. Got it.
It's black people talking to other black people. So there's a intercommunal space that's happening that rarely gets to happen. It's happening in front of everybody. And I wanted in that moment to actually find a way to
What the hell is this thing on her collar? I mean, I've been looking at this for a while, but seriously, what is it? Does anyone know what this is on her shirt collar? Like the biggest lieutenant stripe ever? I'm assuming it's some sort of LGBTQ thing, but I honestly don't know. Does anyone know what this thing is on her collar? What the hell is this?
display discourse, but with civility.
If you haven't seen the video covering this debate, it's on the channel. She speaks down, she demeans, she interrupts the guy talking and says, you need to talk to me like I'm your mama.
Certain points, I didn't even show it, but at certain points, I led them all in a primal scream together.
Yes, you heard that right. She led them in a primal scream.
I led them all in a deep breath together, and I really tried my best to get across to them that this is about us figuring out how to align and find a way for us. That's why I'm here.
It's almost as though these hosts know that this did not look good for her, but even they do not seem to be able to get through to her.
So do you think it was productive, or did it descend into name calling?
Of course it descended into name calling, because I'm human, and I'm sassy, I'm spicy.
So she admits she descended into name calling moments after talking about how she was there to bring civility.
But
it seems that logic means nothing when you're speaking to someone like this.
Folks were saying, Amanda, you should have been arguing with intellectuals. No, we need to be talking with people who are not getting the critical thinking skills. They're not getting the facts. They're not getting the truth.
Oh, you didn't just talk about critical thinking skills, please.
When ultimately there needs to be an intimacy that we are getting back to. And so in this format, I did get a chance to be one-on-one with people. And at the end of the show, there were people that came up and said, thank you so much. I learned a lot.
I highly doubt that. For some reason, I really doubt that.
And he actually left the table different than he arrived. And so I think, yes, it was useful, because ultimately a debate is not about who you're debating, it's who's watching you debate. And the goal is not to change the other person's mind, but to defend your stance in such a way that the people watching say, yeah, I gotta go with that side.
I wish they had asked her, why do you think this went so viral? I have not seen anyone cover this debate and point out how good she did. I haven't seen anyone speak favorably of her performance. I don't even think these MSNBC hosts think she did well, really.
Yeah, that's about how well it went. Was like a trash fire. Pretty much. I want a sandwich. I want some sort of like Subway thing, or some sort of like Italian sub. That's what I want in my day. Just waiting for this thing to stream, come back. I could cook up pizza. I have frozen pizza. I kind of want a Subway sandwich of some kind. Someone give me money so I can buy lunch, please. Someone give me like $20 or something so I can get lunch. That'd be nice. Let's see what we can do today. Shepherd pie, that's good. Let's see what we got. Cheesesteaks. Probably a small, isn't it? I'm getting a small Philly. Get 2 small Phillies for $8. Maybe. Let's see what else we got today. No. No. Jersey Mike's. What do we got? You get a free option if I spend $15. Okay, so I can get like a free sandwich if I spend $15. Okay. I'm really hungry though. Philly steak with extra mushrooms. I haven't had a good Philly steak in a while, to be honest. Wait, can you do something other than the small? Buy one, get one? That'd be cool. Cheese sticks. Old school cheese stick. Philly cheese stick. Old school cheese stick looks good. Bacon 3 cheese stick. Wings. 30 wings for $37. Not a bad deal. What's the delivery time on this thing? 23 minutes? All right. I'm definitely hungry. Small chicken Philly. Well, if you get 2, it's probably the same as 1 big Philly. You're getting it for like $8. Okay. So you're basically, if you get 2 of them, you're getting basically 1 large for $8 instead of $15. Okay. So let's like just do 4 of them, and then I'll have 4 for $16, and they'll be like 2 large ones. This is logical. Is it just the chicken Philly, or is it like it's just the chicken Philly? That kind of sucks. So it's a chicken Philly, not a regular Philly. That's kind of bullshit. All right, but this one's actually cheaper. All right, so let's just get like the old school cheesesteak. Yeah, for $15. It's basically the same difference. No, not really. Twice as expensive. Let's just get the old school Philly, and we'll get 2 chicken Phillies. That's my compromise for the day. Okay. And then I want some sort of fry product. I can buy one, get one free fry. Has anyone noticed that fries are like very expensive now? There's some places like charging $5 for a side of fries. All right. Old school cheesesteak, small chicken fillet, and a fry. All right. I'll do that. All right, food is coming. Yay. I'm hungry. I'm gonna eat the shit out of it too. I'm very hungry. I also need to think about like what I'm cooking next. Because I ran out of cooked food. So I need to start planning what my next cooked meal is going to be. I could always make that breakfast casserole I like. You take basically a dozen eggs, and you take like 2 pounds of meat and cheese, and you mix it all together, and then you put it in a casserole dish and bake it. That works. Could do that. Throw in a can of Rotel maybe with the extra hot pepper. Be nice. Non-spicy? Fair. Maybe I'll start putting together some stuff at Walmart for delivery. Okay. Large white eggs, 12 count for $2.72. Sold. Okay, let's do a can of Rotel tomato. Do we'll do 10 ounces. 10 ounces isn't very much actually. I guess I could buy 2 cans and see if I need both cans. Probably will. Okay, let's see what we can do in terms of ground. What do we want to do? Ground pork? Ground pork is good. Especially if we can get like a hot pork is nice. Let's see. Ground sausage pork, 1 pound. Ground maple sausage. Ooh. Sage. We'll get 2 pounds of that. 2 pounds should be enough, right? Yeah. Do I need 3? And get 3. All right, let's get some shredded cheese. Let's see. Triple cheddar, 8 ounces. That sounds promising. Sharp cheddar, the triple cheddar. We get the triple cheddar, and I'll get. Can I do a pepper jack or something? That'd be sweet. Colby jack. I'll do a Colby jack. That'd be nice. Those 2 pounds. Nice. And 2 pounds of cheese, maybe 3 pounds of sausage, a dozen eggs, put it into a dish, bake at 450 for 45 minutes. Done. Easy. I get some bread. I could have some bread with it. That'd be good. I could have toast. Should I get bread so I can have toast? Let's get bread so I can have toast. If I get bread, it will become toast. That's how that works. All right, let's see. What kind of bread do I want? Honey wheat. Make myself a little sandwich with the egg thing. Ooh, Miss Bard's large bread. Ooh, white wheat. Ooh, exciting. I'll get that. I'll get the large bread. All right. Okay. And I can get delivery today of all those things. Nice. Yeah, just mix it all together in a bowl. It's just take all the ingredients, mix in a bowl with a little bit of salt, pepper, maybe a little oregano flake or something. Easy, right? Easy. I have like 2 casserole dishes, so I could make like 2 things of it. Yeah. All right, I will keep that in my cart for later. But I like this direction very much. Or I need to use the restroom again. I will return. I'll put this on just in case it comes back in my absence. It occurs to me I can also make this in the Instapot. Also, Walmart has something called bacon ends and pieces, 48 ounces. That's 48 ounces is, let's see, I can do math. Hold on. 32 is 2 pounds. And 48 would be 3 pounds, right? Okay, so it's 3 pounds of bacon ends and pieces. 16 times 3. Yeah. Okay, so it's 3 pounds bacon ends and pieces. Okay. So I can get 3 pounds of bacon ends and pieces, put that in the Instapot with cheese and eggs and stir it all up. And it'll be awesome. Okay. This plan is sounding increasingly promising. All right, so I don't need the sausage roll anymore because now I just have 3 pounds of bacon, which is even better. We're on the Rotel tomato. Yeah. Yeah, just like mix an egg basically until the pot becomes full. I don't even have to pressure cook it, just like put it basically on saute. Yeah, I could just like saute it and just like stir it until, it basically sets. It'd be a heart attack? Nah, it's a protein heavy dish. It'll be great. It'll be great. You're not joining me in my love of this plan. You think it's a heart attack? That doesn't sound good. I don't want to have a heart attack. Do I need to rethink this entire plan? And I thought I had a plan that made sense. It's very keto friendly. There's that. I could even cook the bacons, get it nice and crispy in the saute. That'd be nice. I could use the Instapot bowl just as a mixing bowl and then pour it in and bake it from there. That'll work. Oh, that's more bowls. Why? Yeah, crisp the bacon first. Yeah, exactly. So a little, put the bacon in, let the bacon grease, let it become nice and crispy, right? And then once it gets nice and crispy, then, add in like at least a can of the Rotel tomatoes and like a bag of the cheese, and then add in some eggs and stir and reevaluate. Yeah, that makes sense. Quiche? Yeah, it's kind of a quiche.
You have respondents 1267 and 1268 in front of you now?
Yes, sir.
During the course of the disciplinary proceedings in this case and following, have you had occasion to learn of certain responses given by Mr. Proctor regarding his views about the messages obtained from his personal phone?
Yes.
And are you aware of his answers given, for example, during your interview with him, among other places, to the effect that he believed he maintained an expectation of privacy with regard to all messages on his personal phone?
Correct.
Prior to your testimony here today, did you have occasion to learn of a document issued by the Norfolk County District Attorney's Office on this subject?
I did.
For the Commission's benefit, for all homicides and unexplained unattended deaths in a given jurisdiction in the Commonwealth, who or what entity has the legal authority under state law to direct the investigation?
The DA's office.
So in terms of homicide investigations, the legal authority in charge is the local district attorney and his or her office?
Correct.
directives from those offices to Massachusetts State Police personnel assigned to the homicide units within those offices are orders for those members to carry out. Is that not so?
Yes, sir.
All right. Now, showing you specifically or referring you specifically to Exhibit 36, you recognize the document as something you've seen prior to today.
I do.
All right, and it purports to be from the Office of the District Attorney for Norfolk County in the Commonwealth of Massachusetts.
Yes.
And it's issue 2 specifically, Massachusetts State Police assigned to the Norfolk District Attorney's detective unit.
Yes, sir.
And that would be equivalent to what we've referred to previously, the State Police Detective Unit, or SPDU, assigned to Norfolk County, where Michael Proctor worked in early 2024. Is that correct?
Yes.
Was specifically referring you to the date of this memorandum as included on Respondents 1267. It's dated March 19th, 2024. Is that correct?
It is.
And was there a date for compliance given within the document, sir? Referring you specifically to 1268.
Yes, March 25th, 2024.
And was Michael Proctor still assigned to that unit as of that date as well?
He was.
Now, directing your attention to the first paragraph of Exhibit 36, Respondent 36, does this directive from the Norfolk District Attorney's Office reference its obligations, meaning that office's or that agency's obligations, under a series of federal and state legal authorities?
Yes, it does.
And does that office state that it is, quote, inquiring of law enforcement witnesses as to potential exculpatory evidence that must be disclosed to the defense, unquote?
It does.
Does it further state, please search for and produce any and all exculpatory evidence that is within your control and custody as it relates to the pending criminal case against Karen Reed?
It does.
And does it further go on to specify, this includes any statements of law enforcement or witnesses contained within the department, issued or personal cell phone or other electronic device or platform?
It does.
Right, sir. I'm going to ask you with regard to this topic just a little further. You mentioned earlier in your testimony you have training and experience as part of a county, a state police detective unit. Is that not true?
It is true.
All right. And you're aware, sir, in your training and experience of special obligations held by all members of law enforcement above and beyond those of ordinary citizens. Is that true?
It is.
And one of those obligations for police officers, including investigators assigned to a local district attorney's office such as that, to obey the directives of that district attorney's office?
Yes.
And it also includes the general obligation as law enforcement witnesses to turn over statements about cases made by investigators, made by police officers under what is known as Massachusetts Rule of Criminal Procedure 14.
Yes.
And that is a special obligation of police officers and investigators in particular that extends above and beyond the ordinary rules and obligations incumbent on an ordinary citizen in our society.
It is.
My final series of questions, Detective Lieutenant, concern the last finding and recommendation of your report, so I'm now going to refer you back to Respondent 18, which is on page 491. I'll give you a moment to get there.
Just give me a minute.
Specifically directing your attention for this next question to page 505, Respondents 505. That's the last page.
I'm there. I'm there.
Thank you, sir. Detective Lieutenant, looking specifically at your page 15 of your report, Exhibit 18, which is also page stamped Respondents 505, Specifically, I want to ask you now about allegation K, the only one I haven't asked you about yet here today. This allegation K states, regarding the allegation that on dates between January 29, 2022 and August 17, 2022, Trooper Michael D. Proctor, number 3863, engaged in behavior that brought himself and the department into disrepute. You indicated thereafter the incident is supported by sufficient evidence to prove employee misconduct. Is that correct, sir?
Yes.
And it's marked then sustained for that particular allegation?
Yes.
All right, sir. Now, if I could ask you to go back a few pages in your report to paragraph 21. This is your conclusion section, sir. It would be on page respondents 499, starting on 499.
I'm there.
Starting with paragraph 21 there toward the bottom of 499, could you just please read the first three sentences, and only the first three sentences of that portion of your report?
Starting with yeah.
Paragraph 21. Oh, I apologize. 1 second, please. I have an error here, so apologies for the confusion. Paragraph 21, yes, beginning with Trooper Proctor at the top of paragraph 21, if you could read the first three sentences.
Trooper Proctor testified that he sent text messages to friends whom he described as people he grew up with and who lived in different parts of the country. Trooper Proctor sent multiple text messages to this friend group that contained sensitive information about the active homicide investigation. He also sent text messages to this friend group that contained inappropriate comments about Miss Reed's medical conditions, as well as other derogatory and defamatory statements about Miss Reed.
All right, sir. Is it fair to say that in addition to bringing himself and the department into disrepute, these specific messages, the ones referenced in paragraph 21 immediately thereafter, those specific messages are also evidence of violations of allegations A, B, C, and D, as you categorize them in this investigation, sir?
Correct.
And it's found and related here, sir, the text that Trooper Proctor sent specifically included the following, if I can ask you this. The victim's name, that is John O'Keefe.
Yes.
The manner in which the victim died, quote, she waffled him, and quote, I looked at his body at the hospital, he was banged up, and quote, she hit him with her car.
Correct.
Did it also include, those texts include information and demeaning sexist, misogynistic, and abusive statements about Miss Reed, including, quote, from all accounts he didn't do anything wrong, she's a whack job cunt, yeah, she's a babe with a weird Fall River accent though, no ass, unquote, nutbag as Chief would say, unquote, and she's got a leaky balloon knot, leaks poo, unquote.
Yes.
You also say that.
Yes.
Did it also include information related to the investigation to which he was assigned and what police actions would be taken in that case, including, quote, they arrived at the house together, got into an argument, she was driving left, unquote, quote, yeah, but there will be some serious charges brought on the girl, unquote, quote, zero chance she skated, unquote, and quote, she's fucked, unquote.
Yes.
Detective Lieutenant, is it also fair to say you obtained evidence that some of those messages were sent during the investigation's earliest stages, even some on the day it began, that is January 29th, 2022, before facts and information have been released to the public? Is that correct?
It is.
And as the authority in charge, the legal authority in charge of all homicide and unattended death investigations in their jurisdiction, what is the entity in this particular instance that had the legal authority to determine what information to put out publicly in connection with this investigation?
It would be the DA's office.
Mm-hmm.
All right, so moving you slightly further in that same paragraph, again, we're on paragraph 21, but now onto the next page, respondents 500. Did you note and include in this portion of your conclusion section a summary of Mr. Proctor's statements to you during your interview, including his explanation that he, quote, did not provide specifics, unquote?
Yes.
All right. You further stated, is it not true, sir, quote, while he may not have provided other specific case information to this friend group, he still provided information, including the cause of Mr. O'Keefe's injuries that had not been released publicly. Do I have that right?
You do.
And now I'd like to ask you about your findings and inferences regarding some of the comments that Mr. Proctor made about Ms. Reed. In your conclusion, is it not the case, sir, that you know the comment Michael Proctor sent about Ms. Reed being a, quote, whack job cunt, unquote, is an inappropriate and derogatory comment that shows Michael Proctor had a personal dislike of Ms. Reed?
Yes.
You acknowledge also in your conclusion section, sir, you acknowledge that Michael Proctor testified, quote, that his comments were partially due to the emotions getting the best of him, unquote. Is that correct?
Yes.
Even so, what are, in your training and experience as an assigned investigator to the Office of Professional Integrity and Accountability, what are the professional obligations of a sworn member in Michael Proctor's position when experiencing and confronting emotional difficulties concerning an active case investigation?
So it's understood that police officers are humans and natural feelings and emotions are going to develop. But as a police officer, it's important that any actions taken are based on reason and fact.
Referring you specifically to your words in your report, sir, did you include the following sentences and make sure I quote these correctly, sir? On this point, police officers have to act impartially and not based on emotion. However, police officers still experience emotions based on what they are exposed to. While this is understood, it is also understood that the emotions of a police officer, the emotions a police officer may feel about an individual are kept in check, and their actions are based on reason and fact.
Yes.
You also made some findings and inferences with respect to comments about Ms. Reed's physique, specifically with regard to the appellant's comments about Ms. Reed having, quote, a weird Fall River accent, though, and no ass. Were those appropriate, sir?
They were not.
Why not?
There were comments on her mannerism and her physical appearance.
In addition to being offensive comments about her physical appearance, are they also an indication or created the appearance that Michael Proctor, on behalf of the Department of State Police, was not an impartial investigator in this case? With respect to his comments, quote, she's got a leaky balloon knot, unquote, and, quote, leaks poo, unquote, were those found to be a commentary on Ms. Reed's medical condition or conditions?
Yes.
And in fact, Trooper Proctor so testified that those were comments on her medical conditions. Is that not so?
Yes.
Did Michael Proctor acknowledge in his interview with you that those comments were, quote, unprofessional and regrettable?
He did.
What else did you conclude or determine about those particular comments as indicated in your report, sir?
He was sharing medical information with people who were not privy to that information, and it was also an issue that was irrelevant to the criminal invest.
Is it fair to say, sir, that in addition to bringing himself and the department into disrepute, again, allegation K that I'm describing or questioning you about generally, these particular messages regarding Ms. Reed and her medical condition are also evidence of violations, evidence of violations of allegations D and F, as you categorize them?
Yes.
Returning to your conclusion, sir, now specifically directing your attention to paragraph 22 on page 500, respondents 500. Did you also find evidence to conclude that Michael Proctor had sent text messages to his sister that conveyed sensitive and previously unreleased information about the active homicide investigation?
Yes.
What specifically did you identify in that regard, sir?
The location of the crime scene and potential witnesses.
Reading from your report, sir, if you could follow along with me, the second sentence of paragraph 22, and just make sure I read it correctly. On the same day that SPDU-Norfolk initiated their investigation of the death, Michael Proctor sent text messages, Trooper Proctor sent text messages to his sister that included elements of the death scene, quote, just found a frozen to death on a front lawn in Canton this morning, unquote, and information about potential witnesses, quote, actually just interviewed Jen McCabe, said she knows you, unquote, quote, Julie and Chris were at the bar with the victim and girlfriend, gotta interview them, unquote.
Correct.
Did I read that correctly?
Yes.
Did you also identify evidence that Michael Proctor was subjectively and contemporaneously aware of the confidential nature of what he was communicating to his sister?
Yes.
What specifically did you identify in that regard, sir?
He texted his sister, don't say a word to anyone. This suggested that he knew the information he was sharing with her, he should not have shared.
Is it fair to say, sir, that in addition to bringing himself and the department into disrepute as to allegation K, these particular messages, the ones we've just been referring to, shared with Michael Proctor and his sister regarding the active homicide investigation, are evidence of violations of allegations A, B, and C, as you also categorize them, sir?
Yes.
Paragraph 24, please, sir. That would be page 5. Did you also find that Michael Proctor had made disparaging and discriminatory remarks about Ms. Reed to his sister as well?
Yes.
Can you tell us what specifically did you identify in that regard?
He texted her, hopefully she kills herself.
All right, sir. And in your report, do you also address something we've heard earlier here today, something he said to you during his interview with you, that he described it as a figure of speech?
Yes.
What, if anything, did you conclude in your report with regard to his explanation that that was just a figure of speech?
Even if he never had the intention for Ms. Reed to harm herself, it contributed to the parents that he was not impartial towards Ms. Reed.
Yep, a little bit.
Is it fair to say, sir, that in addition to bringing himself and the department into disrepute, his statement to his sister about hopefully she kills herself regarding Ms. Reed was also evidence of a violation of allegation D, as you categorized it?
Yes.
Paragraph 25, please, sir, same page. Did you also find that Michael Proctor had sent sensitive investigation information and disparaging remarks about Ms. Reed to his wife as well?
Yes.
What specifically did you identify in that regard?
He texted, we're going to lock this whack job up.
Is it fair to say, sir, that that particular text message, in addition to bringing himself and the department into disrepute, also was evidence of violations of allegations C and D, as you categorize them, sir?
Yes.
All right, sir. My final set of questions regarding your conclusions, paragraph 26, again, same page, 501. Did you also find that Michael Proctor had disparaged, discriminated against, and sent sexist and misogynistic remarks about Ms. Reed and her medical conditions in a series of messages sent to his coworkers and supervisors on yet another message chain?
Yes.
Specifically, is it fair to say that Michael Proctor referred on that chain to Ms. Reed as, quote, retarded?
Yes.
Quote, or not quote, excuse me, but to paraphrase, someone about whom one might search for nude images?
Yes.
And also a woman who shit herself?
Correct.
With respect to calling Ms. Reed retarded, what specifically did you conclude, sir?
It's a derogatory and an offensive term.
Wow. That must take a lot of brain power to make that conclusion.
Among other things.
You mean calling someone retarded isn't a compliment and a way of imparting a sign of respect? Whoa.
With respect to suggesting that Ms.
Interesting.
Reed
Thanks for that deep conclusion.
Whom one might search, or for whom one might search for nude images.
Next time you'll be telling me that flat ass is
Well, there was no evidence to suggest that he actually did that. That also contributed to the appearance that he was not impartial towards Ms. Reed.
And with respect to the suggestion that Ms. Reed was a woman who shit herself, as he phrased it, what did you conclude specifically, sir?
Again, that was commentary on a medical condition that was irrelevant to the invest.
Is it fair to say, sir, that in addition to bringing himself and the department into disrepute, these particular messages on that...
These are the most leading questions ever.
To department colleagues...
I guess no one cares, but I don't even know what the rules on leading are in this hearing.
Yes.
Maybe it's not a problem. Who knows?
Detective Lieutenant Dwyer, in your review of the case evidence prepared not only for today, but before the internal trial court proceedings in this case, you had a chance to compare specific testimony that Mr. Proctor gave about the particular text messages he sent, as well as his characterization of those messages. Is that a fair statement, sir?
Yes.
With respect to the following, I'm going to ask you a series of questions about this, just so we have the characterization correct and the references correct, sir. With respect to the original text message, the original content of calling Miss Reed a, quote, whack job cunt and a babe with no ass, Trooper Proctor testified that those comments were, in particular, unprofessional and regrettable, something he was not proud of, and something he stated I should not have wrote in a private or any type of setting.
Correct.
Correct? With respect to the original statements he made, nutbag, as Chief would say, she's got a leaky balloon knot and leaks poo, did Trooper Proctor testify, these are about Miss Reed's medical conditions, again, unprofessional comment I should not have made and I'm not proud of?
Correct.
Also, with regard to those same comments, did he also call them juvenile and unprofessional?
He did.
With respect to his original statement, we're going to lock this whack job up, did he categorize or characterize that as unprofessional messages I should not have sent?
He did.
With respect to the original statement, if you like women who shit themselves, did Mr. Proctor describe that as a regrettable comment about Miss Reed's medical condition?
Yes.
With respect to his statement, funny, I'm going through his retarded client's phone, no nude so far, did he describe that as a distasteful joke in his testimony?
He did.
With respect to the original statements, again, babe, weird Fall River accent, and no ass, he testified that they were, quote, absolutely not, unquote, appropriate?
He did.
With respect to the original statement, she's fucked, and then a laugh, did he describe that as unprofessional, but indicated that he thought it was funny at the time?
Yes.
And specifically, the part that he found funny at the time was a comment by someone else on the text message chain indicating Miss Reed was, it said, good, no ass bitch.
Yes.
With respect to when he was questioned about the text messages overall, content of his text messages overall, did he stand by his testimony that he was showing strong moral principles? Did Mr. Proctor testify, quote, absolutely not, unquote, the texts were, quote, juvenile and regrettable?
Yes.
With respect to his original statement calling Miss Reed a cunt, did he state that that was, quote, in poor taste and, quote, inappropriate and juvenile, unquote?
He did.
And finally, with respect to the calling Miss Reed a retard, did he also describe that as, quote, another disgusting comment, unquote?
Yes.
And those are statements and characterizations he made about his own comments under oath. Is that correct?
Yes.
I have only one more clip to play, Commissioner McConney. Could I have clip 10?
Is this the end of the direct? Did they do the whole direct? I mean, they did submit a lot of evidence in writing, so maybe that's all that they need for the direct. Maybe we'll get some cross-examination today. That'll be entertaining. I look forward to this cross-examination. It should be really great.
During the course of your investigation, your figures of speech include the following. She's a bitch.
Objection.
Is that right?
Yes.
A whack job, correct?
Yes.
A retard, right?
Yes.
Her balloon knot leaks, right?
Yes.
No ass, correct?
Yes.
She's fucked, according to you, right?
Yes.
Ass leaker. That was the word you used, a figure of speech, right?
Correct.
A girl who shits herself, right?
Correct.
And then fuck her, correct?
Correct.
Would you agree, Trooper Proctor, that you have dehumanized Karen Reed during the course of your investigation with comments and words like this?
Objection.
I'll give you this one, Mr. Jackson.
Would you agree with that?
I would say based off that language, yes.
respondent has no further questions for this witness at this time.
Thank you. I'm going to pause the recording and I will meet with the council briefly.
Mr. Proctor, you can chase all the water you want, but the answers are not going to be found in that bottle. Unless it's cyanide. The bottle might be found. If it's cyanide, you might find the answer. Or, what's that other one that sometimes people drink? I should know the answer to this. Oh, am I going to be able to come up with this off the top of my head? Oh, I can't quite get there. What's it called? No, it's like... No, it's like... Well, sometimes people do like rat poison. There's that, but I'm not sure that's what I'm thinking of. Oh, my food is here. I will contemplate while I see if I can come up with what I'm looking for. Antifreeze? I'm not sure if people drink antifreeze, but they might. That would work. This is over for the day? Nah, they're doing cross-examination at some point.
So now we're back on the record. The time is now 2:20 p.m. and thank you.
Hemlock? I don't know if anyone does
So
hemlock anymore.
basically,
That's old school.
Since the state police is finished with its direct examination, we will have the appellant begin its cross. We'll do a recess till 2:45, and then we'll come back and resume. And we're going to stop at 4:30,
Okay.
as you understand. Thank you. Actually, I have to say that all again. I got to put it on the record.
Let's say it again.
So just to repeat, you've already typed it, that we spoke with the attorneys and that Mr. Carley has finished his direct of Lieutenant Detective Wire, and the appellant will begin its cross at 2:45. Thank you very much.
I'm now asking Grok to see if it will tell me what I'm looking for.
I didn't put this down.
Like it has a 2-word name, like potassium something or something like that. I just can't quite remember what I'm looking for. See if Grok tells me what I want to know. Ethylene glycol? Well, that's antifreeze. Okay. Methanol, no. Sodium nitrate. That's what I'm working. That was what I was looking for. That was the one. Thanks, Grok. Sodium nitrate was what I was looking for. Thanks, Grok. That was the one I was looking for. Great. Excellent. Moving on. Fries less toxic. You miss Spinny Fan? As do we all. Yeah, Spinny Fan is the best. Spinny Fan is only fan, you know it, man. Will that guy take that Odin in court? I'm pretty sure that was cyanide or arsenic. I know the one you're talking about. The guy who took that out of the capsule, like the minute he was convicted, the jury said guilty, he took something and like died. I'm pretty sure it was cyanide. Yeah. I remember the incident you're talking about. I think nitrogen asphyxiation is probably the way to go, though. If you can find a source of nitrogen, which shouldn't be that hard, I think it would be able to get at like a chemical supply stop or something. You just need gaseous nitrogen. Yeah, I think it's probably the best method. I'm glad I can offer these tips here. Plus, you don't have to be concerned about the nitrogen escaping into the atmosphere because, of course, the atmosphere is already 78% nitrogen. So you don't have to take like any particular measures to prevent it from poisoning people because once it hits the atmosphere at large, it's relatively safe. Yep. Happy to help you with these discussions. Let's move on to something more pleasant. Move into a more pleasant discussion. Fries are tastier, though. Recommend those. Is it constitutional for Trump to send troops to Chicago? Broadly, yes. In the specific, maybe not, but broadly, yes. If you're concerned about like posse comitatus has exceptions built into it, or built into other parts of the statutes, which isn't a constitutional issue, it's a statutory issue. But posse comitatus basically says you can't use the military for you can't use the military for police actions except when you can. And then, consult other elements of the statute. Obviously, posse comitatus doesn't apply to D.C. because D.C. is federal in the first place. No. One moment, please. I got someone knocking at my door. All right, guys, I need to take a break. I'll talk to you later.
Mr. Moynihan, you may proceed.
Thank you, Madam Commissioner. Good afternoon, DLT Dwyer.
Good afternoon, sir.
Sir, how long have you been with the state police?
Almost 21 years.
And currently you're in internal affairs, otherwise known as OPIA, correct? And can you explain what your function is in OPIA?
I'm an investigator.
Okay, what does that mean?
For internal affairs investigations, any potential violations of policy or rules and regulations.
So you investigate other members of the department for potential violations?
Yes.
Okay. And you've been there for 4 years in that department?
Yes.
Okay. How many investigations would you say you've done in the 4 years?
A couple dozen, maybe.
Okay. 25, 30?
Maybe that many.
Okay. And this investigation was assigned to you on March 4th, correct?
Correct.
All right. And that was assigned to you by Lieutenant Colonel Brian Connors?
Lieutenant Colonel Connors had requested the invest. I was assigned by Colonel Shoemaker.
Okay. And could you turn to, we have our exhibits in front of you now, appellant's exhibits. Could you turn to Exhibit 1, please? I'm sorry, we're looking at I'm sorry, I'm responding to Exhibit 1. I'm sorry, sir.
Yes, sir.
All right. So Respondent's Exhibit 1 was dated March 4th of 24, correct?
Yes.
And it's from Lieutenant Colonel Brian P. Connors, correct?
Correct.
And he was the commanding officer of the Division of Investigative Services, correct?
Correct.
All right. And that memo was sent to Lieutenant Colonel Dan Richard?
Yes.
And what was his role?
So I misspoke. Colonel Richard is one that assigned me the investigation.
Okay. But it was instituted by Lieutenant Connors, correct?
Correct.
All right. Now, I'm sorry, we're going to switch gears here because I'm going to be talking to you about exhibits from both parties, but could we go to appellant's exhibit number 57?
Did you say 57?
57.
Yes, sir.
Okay. So that in front of you?
Yes, sir.
What is that in front of you, sir?
It's the Rules and Regulations, Article 4.
All right. Of the Department of State Police, correct?
Yes, sir.
And there are many rules and regulations of the Department of State Police, correct?
Yes, there are.
And there are many policies and procedures of the State Police, correct?
Yes, there are.
And you have in front of you Article 4?
I do.
And it's dated, and these change from time to time, correct?
They do.
And the date of this is September 27 of 23?
Yes, it is.
Okay. And Article 4.0 is entitled what?
Title and rank, payroll, promotions.
All right. And so, in effect, this rule and regulation, Article 4, sets out the ranks of every member of the state police, correct?
It does.
Beginning with the top order of rank, correct?
It does.
And 4.1 reads, the order of titles and ranks in the Massachusetts State Police shall be as follows, : first bullet is colonel/superintendent, correct?
Correct.
As of February of 24, who was the colonel/superintendent?
February of 24, Colonel Jack Mon.
Right. And the next bullet down, and I assume this is second in command, is lieutenant colonel/deputy superintendent, correct?
Correct.
And who was that as of February of 24?
Lieutenant Colonel John Pinkham.
Okay. And then the next item down is third bullet down is lieutenant colonel, correct?
Correct.
And is there more than one lieutenant colonel in the state police?
There are.
How many are there?
I believe there are 5.
All right. And so the order of rank, we have one colonel, correct? We have, I think you have to answer for the record.
Yes, yes.
One colonel.
Correct.
One deputy. correct? Second in command.
Correct.
And then we have, did you say 5 lieutenant
There are
colonels?
5, yes.
All right. And the lieutenant colonel of, strike that, Lieutenant Colonel Connors was the commander of what division?
Division of Investigative Services.
Okay, so is it that each division has a lieutenant colonel in charge?
Yes.
Okay. And then below that, we have major, correct?
Yes.
And then on down the line, detective captain, captain, detective lieutenant, on down, correct?
Yes.
And you're a detective lieutenant, correct?
I am, sir.
All right. And so this Article 4 sets out the rank of all the senior officers of the department.
For all the ranks, yes.
Okay. Now, Lieutenant Connors was in the Division of Investigative Services, correct?
Yes, sir.
And so, and again, this is going to be a little cumbersome with the 2 books in front of you, but could you turn to Appellant's Exhibit 1? And could I ask, Madam Commissioner, if we could display Exhibit 1?
We're going to play the
Appellant's Exhibit 1,
Appellants.
yes.
Exhibit 1, the video.
Exhibit, no, it's not a video, it's just an exhibit.
I'm sorry, say this again?
Just Exhibit 1. I thought you had them all.
Can you approach?
Yes.
Both of you?
And we can do it if we can.
Commissioner, do you want to sign the record or what? On the record? Thank you. I can't hear you if you want to sign.
We're off. We're off. Okay.
All right, so we don't have the capability to display it. but-
Sir.
I'm sorry.
We're back on the record. The time is now 2:53 p.m. Mr. Montana, you may continue.
Thank you. So apparently it can't be displayed DLT, but could you go to Exhibit 1, please? Collins Exhibit 1.
I'm there.
And so this is entitled what?
The Massachusetts State Police Division of Investigative Services.
All right, and is this a chart of all divisions of the state police?
It appears to be, yes.
Okay. And on the second page after the emblem, the first page is entitled Massachusetts State Police Division of Investigative Services, correct?
Correct.
And the first name at the top of that chart is who?
Lieutenant Colonel Brian P. Connors.
Okay. And then below him, there are 4 names. They're not Major Leonard Coppenrath, Detective Captain Gerald Collins, Major Michael Farley, and Detective Captain Eric Benson, correct?
Correct.
And what are their roles within the Division of Investigative Services?
So each major and detective duo, if you will, they each oversee a certain set of units.
Okay. And on the left side of the chart, there are numerous units and divisions listed, correct?
Yes, sir.
And on the left side of the chart, the Norfolk SBDU is one of the units or divisions listed, correct?
Yes, sir.
What is the Norfolk SBDU?
The Norfolk State Police Detective Unit.
Okay. Norfolk County DA's Office Detective Unit, all right. And so, just following along on the chart then, if you look back up, Detective Captain Gerald Collins would be the detective captain for the Norfolk SBDU?
Yes, sir.
And Major Leonard Coppenrath would be the major in charge of the Norfolk County SBDU, correct?
Correct.
And then above them, they would answer to Lieutenant Colonel Brian Connors, correct?
Yes, sir.
All right. Thank you. Now, have you, prior to investigating Michael Proctor, did you ever investigate anyone for comments, personal comments on their personal cell phone?
I have not.
And could we go to your report, Exhibit 18? That would be Respondent's Exhibit 18. What's the date of your report, sir?
July 29th, 2024.
Okay. And so, in the first paragraph, you indicate that the investigation was initiated by Lieutenant Connors, correct?
Correct.
And it was based on information received from the Norfolk County District Attorney's Office regarding Trooper Michael D. Proctor's participation in an ongoing criminal investigation, correct?
Yes, sir.
And that investigation was Comwell versus Reed, correct?
Yes.
That is not to suggest that there was a criminal investigation into Michael Proctor, correct?
Correct.
All right. It was the investigation of the Karen Reed case, correct? Right. And you go on to say that in paragraph 2, the Norfolk County DA had advised the department that they had been notified by the U.S. Attorney's Office that there was a federal investigation that involved Trooper Proctor, correct?
Yes.
Again, not of Trooper Proctor, just he was involved in.
Correct.
Right. And as part of that investigation, the contents of Trooper Proctor's personal cell phone were obtained, correct?
Yes.
All right. And so on March 4th, you were assigned this investigation, correct?
I was.
And are you now aware that the basis of this federal investigation was a claim by the defense of a conspiracy and planting evidence?
I am now, but I was not at the time.
At the time, right. And you're aware also, sir, you're not, that the federal investigation was terminated in February of 2024?
So I heard that it was ended, but I don't know the facts about that.
Okay. You're now aware of that?
Yes.
No? And Michael Proctor never received a target letter for that investigation, correct?
Not that I'm aware of.
Okay. And Michael Proctor was never charged with any crime as a result of that, was he?
Not that I'm aware of, no.
And he's never been charged with any crime under any circumstances, has he?
No.
And no one in the state police received a target letter from the U.S. Attorney's Office, correct?
Not that I'm aware of, no.
And are you now aware that the reason that this entire case came to light was because Michael Proctor was subpoenaed to testify at the grand jury on February 1st of 24?
Again, at the time I was not aware, but I am now.
You are
yes.
now, that's right. And he was subpoenaed as a witness, correct?
I don't know what his role was at the time.
Are you aware now that he was
now I am, yes.
only as a witness?
Yes, sir.
Not as a subject, not as a target, correct?
Correct.
All right. And are you now aware, and you became aware at some point in the past, I presume, that Michael Proctor learned for the first time on February 1st that the U.S. Attorney had somehow surreptitiously obtained his text messages from his personal cell phone, correct?
Yes.
And then he learned for the first time that they had those text messages on his personal cell phone, correct?
Correct.
And are you now aware that do you have any idea of the basis for them obtaining those messages?
I wouldn't speculate on that, sir.
Now, March 4th was the day you were assigned the case, correct?
Correct.
And on March 4th, there was a meeting at General Headquarters, correct?
Yes, sir.
And you attended that meeting, did you not?
I did.
And who else was at that meeting?
It was myself, Colonel Mon, Lieutenant Colonel Pinkham, Lieutenant Colonel Richard, Lieutenant Colonel Connors, Attorney Staples, Detective Lieutenant Goslin, and I believe that was it.
Okay. So you had, I just want to go through that again. Colonel Wan was at the meeting, correct, on March 4th?
Yes,
And this was held at the headquarters in Framingham?
it was.
And was it up in the legal department, or where was it held?
It was in Colonel Mon's office.
Colonel Wan's office. Okay, so Colonel Wan was present.
Yes,
Jennifer Staples was present.
yes,
She chief legal counsel.
she is.
Siobhan Kelly was present.
I can't recall. I think she may have come later on. I can't recall.
She's
for
deputy
sure.
counsel.
She is, yes.
And Detective Lieutenant Goslin was present.
Yes.
What is his role? What was his role at the time?
So at the time, myself and Detective Goslin were some of this meeting. We were working the case together.
Okay. And was Colonel Daniel Richard there?
Yes,
And Lieutenant Colonel Connors was there, correct?
yes.
And Captain Benson was there, correct?
He may have been there, yes.
And so you had one colonel present.
Yes.
You had two lieutenant colonels present, correct? Lieutenant Colonel Richard and Lieutenant Colonel Connors.
In Colonel Pinkham.
So you had a colonel, a deputy, two lieutenant colonels, correct?
Yes,
And you had one captain, Benson.
yes,
You had two detective lieutenants, yourself and DLT Goslin.
correct,
And two attorneys,
correct.
all present at a meeting with the Norfolk County representatives of the Norfolk County DA's office, correct?
I don't think there were any reps from the DA's office there.
Okay, not at that time.
No.
All right. And so the topic of discussion was what?
The fact that the DA's office had disclosed to the department the existence of these text messages.
So, I'm sorry, say that again?
That the DA's office had disclosed to the department of the existence of these text messages.
Okay. And was it necessary for you to sign a non-disclosure agreement on March 4th?
It was.
Okay. And so in your report, you say only that derogatory and defamatory messages were discussed, correct?
Correct.
And you say that only an oral summary of the text messages was discussed, correct?
Correct. I don't believe that the content of the text messages was discussed, as far as I know. Only the fact that these text messages had been found, but not the actual content of them.
So this meeting took place after the DA's office had disclosed the text messages to the department, correct?
Correct.
And that had happened in late February, in early February?
I'm not sure when the DA's office told the department.
So who was the speaker in the room on February 8th? I'm sorry, on March 4th.
There wasn't one speaker, sir.
Okay, but who was the one holding the meeting?
Well, Colonel Mon was a ranking member, so it was his meeting, but there was not one speaker in the meeting.
Okay, and everyone in the meeting had to sign non-disclosure agreements, correct?
Correct.
And so all those people in the room, and you're telling us that no one asked about the specifics of the text messages?
I don't know what conversations they had prior to got there, or what questions that they had for the DA's office.
And so the purpose of signing a non-disclosure agreement would be so that people couldn't disclose the content of those text messages, right?
The purpose of the NDA was so we could not disclose the fact that we knew that these text messages had existed.
So your testimony is that an NDA, as we're calling it, was required just so you couldn't tell others that there were derogatory and defamatory messages.
Correct.
That's as far as you know.
Correct.
It's fair to say that others in the room may have known a lot more than you.
I wouldn't know that, sir.
Okay. But it's a possibility.
It's a possibility, sure.
But in any event, non-disclosure agreements were signed that day.
They were.
Or previous to that day.
No.
By others, maybe.
I would assume. I know that I signed the NDA that day.
As far as you're concerned, you signed the NDA only because you knew there were derogatory and defamatory messages.
Correct.
And do you know if that NDA, as we're calling it, was ever produced to Michael Proctor or myself?
I do not know.
But you signed one.
I did.
And everyone at the meeting signed one, to the best of your knowledge.
As far as I know, yes.
Now, could you look at our Exhibit 4? I'm sorry, hold on one second if you would, DLT. Yeah, Exhibit 4.
For the appellant's Exhibit 4?
Yes, about the top, yes.
I'm here, sir.
Okay. So that Exhibit 4 is an email, correct?
It is.
And it's from Siobhan Kelly, correct?
The top line from the from to looks like it's from Jennifer Staples.
I'm sorry, we'll go to the top, yes. The top two from, I'm sorry, the top email is from Jennifer Staples, correct?
Yes.
And she's chief legal counsel for the department.
She is.
And this email is sent to Brian Connors.
Correct.
And we've already established Brian Connors was the lieutenant colonel, right, third in command.
Yes, sir.
And it's dated March 6th at 1:14 p.m., correct?
It is.
And it says a big capital FYI, correct?
It does.
That's the only content of the email, correct?
Yes, sir.
And below that, there's a second email, right?
There is.
And it appears as though that email below was forwarded to Lieutenant Colonel Connors on March 6th.
Yes, sir.
And who was that email from in the bottom?
Siobhan Kelly.
And who is Siobhan Kelly?
She's the deputy counsel
For the department.
for the department.
And the date of that email is when?
March 4th, 2024.
All right, at 3:41 p.m.?
Yes.
And who is Attorney Kelly sending this email to?
To Colonel Mon and Colonel Pinkham, and she CC'd Attorney Staples.
Okay. And what's the subject?
The subject is proposed statement.
Okay. Do you know what that means?
I can surmise what it means, yes.
Okay. What do you surmise it means?
That they were drafting a statement for release, I would imagine.
Okay.
I'm sorry, should I be drafting a statement?
They were for release.
Okay.
But I don't know that to be true.
Yeah, okay, fair enough. So, and it reads Colonel and Deputy, correct?
Yes, sir.
Jen and I drafted the below statement on the Reed matter. Please let me know your thoughts, correct?
Yes.
And then the statement reads, on March 1st, 2024, the Department of State Police was provided by the Norfolk County DA's District Attorney's Office a substantive summary of the United States Attorney's Office's disclosures in the matter of Commonwealth versus Reed. Did I read that correctly?
You did, sir.
And that's March 1st, correct?
Correct.
To date, the department has not been provided with any information from the United States Attorney's Office regarding the findings of their investigation. Did I read that correct?
You did.
So she is telling the colonel and the deputy, Colonel Mon, Deputy Pinkham, that the DA's office provided a substantive summary of the disclosures from the United States Attorney's Office, correct?
Yes, sir.
And based on that, as it reads down on the bottom, the department initiated an internal affairs investigation into Trooper Michael Proctor, a member of the Norfolk County State Police Detectives Unit, correct?
Yes.
And then it says, in consultation with the Norfolk County DA's office, Trooper Proctor was transferred out of the detectives unit pending the outcome of this internal investigation. Did I read that correctly?
You did.
Do you know if that ever happened?
I don't believe it did.
Now, are you now aware that the department actually learned of the text messages before March 1st of 24?
What's the objection, Mr. Cole?
Students facts, not evidence.
I'll have a question. You may answer.
So again, sir, I am not sure when the department became aware, other than what that email said.
Okay. Could you turn to Appellant's Exhibit 5, please?
I'm there, sir.
All right, and I think because it's an email chain, we'll go to the last page first. And actually, the last page is from somebody, if you could, let's go to the last page.
The base number of that?
I'm sorry, it's APP 0052. May I proceed, Madam Commissioner? Are you ready?
I am, sir.
Guilty. So the email, the email at the top is dated January 19th, Deputy Legal Counsel again, correct?
Yes, sir.
And it's to somebody named Gretchen Lundgren and also to Jennifer Staples, correct?
Yes, sir.
And copied on it is an attorney, Michael DiStefano, correct?
Yes.
And this is, it reads, Hi Gretchen and Mike, do Trooper Proctor and Sergeant Buchanan have a date yet for the grand jury? Thank you. Did I read that correctly?
You did.
And So it's fair to say that the department was aware that there was a federal investigation and that Buchanan and Mike Proctor were subpoenaed to be witnesses there, correct?
It would appear that way, yes.
And now jumping ahead to the previous page, APP 0051, if you could look at the bottom, email from Jennifer Staples. You see that?
I do, yes.
And so that's from Jennifer Staples, dated Friday, February 2nd, 2024 at 12:25 p.m., Friday afternoon, correct?
Correct.
To Gretchen Lundgren, copied to Michael DiStefano. Hi Gretchen, happy Friday. Are you and Mike available today or Monday for a quick call regarding Trooper Proctor? Let me know, thanks. Did I read that correctly?
You did.
And then moving above, there is an email from Gretchen Lundgren back to Jennifer Staples confirming that they could meet on that Friday, correct?
Yes.
And then going forward to APP 0050, there is an email from Michael DiStefano. Do you see that?
I do.
On Friday, February 2nd at 4:17.35 p.m. Do you see that?
Yes.
To Jen Staples. Hi Jen, thanks for the call today. Do you have some availability to speak with me on Monday, February 5th? Thanks, Mike. And then if you go to the top, there's an email from Jen Staples to Mike DiStefano. Absolutely, I just have a 2 o'clock. What works for you? Do you see that?
I do.
And going to the previous page, APP 0049, from DiStefano to Staples again, February 2nd at 4:20 p.m. regarding call. And then we have to turn back to APP 0050. How about 11 a.m.? Thanks and have a great weekend.
Yes,
see
sir.
that? And then moving above that, there's an email from Jennifer Staples to Michael DiStefano on February 5th at 2:21 p.m., correct?
Yes, sir.
Hi, Mike. I have briefed the colonel and deputy about our call. Do you have time later this afternoon or tomorrow morning for another quick call? Let me know. Thanks. Jennifer Staples, correct?
Correct.
Are you now aware that Michael Proctor and his attorney self-reported the discovery of these text messages on his personal phone to Attorney Staples on February 2nd of 2024?
I'm aware as we sit here today, yes, but not at the time.
Attorney Moynihan, in looking at the exhibits, on page base number, on page 50, you look at the bottom, Gretchen Lundgren's email is redacted.
What was her role in this meeting?
I'm sorry, Gretchen Lundgren?
Yes, what was her role?
She was Sergeant Buchanan's attorney.
All right, thank you. I just want to get that on the record. Thank you. Please go ahead. Sorry.
Thank you. Now, DLT, are you aware of the fact that there was a meeting held on February 8th at the department, at headquarters?
Only as we sit here today, yes.
You know?
Yes.
Right. And present at that meeting were Trooper Michael Proctor, correct?
I believe so, yes.
Attorney DiStefano, Siobhan Kelly.
Yes,
Sorry, I didn't get an answer to that question.
So I'm.
DiStefano, sorry.
Sorry.
Okay.
The pending question was Attorney DiStefano, and I have an answer on it.
So
I'm sorry.
who was at that meeting?
So I am not aware of who was at that meeting.
Okay. Are you aware now, did you learn it sometime in the past, that Trooper Proctor reported to DLT Tully the content of these text messages?
Yes.
And he did that on February 1st and on February 2nd, correct?
I'm not sure of the date, but I do know that he did.
And are you now aware that And who is DLT Tully, by the way, in the scheme of this?
DLT Tully was the unit commander of SPD Norfolk.
He was Mike Proctor's boss?
Correct.
One of his bosses, correct? And so, in terms of bosses for Mike Proctor, at the time we had DLT Tully, correct?
Yes.
And what was John Fanning's title?
He was the lieutenant.
Okay. And who was above John Fanning?
DLT Tully.
Okay, and then who was above Tully?
I believe that would have been Detective Captain Collins.
Okay. And those were all superior officers to Trooper Proctor, correct?
Yes, sir.
That he would have to answer to?
Yes, sir.
And they would have all been part of the Karen Reed investigation, correct?
I would assume they were, yes.
And are you aware now that DLT Tully, after Michael Proctor reported these text messages to Tully as early as February 1st, that Tully then reported these text messages to Major Leonard Copenrath?
I'm aware.
What's the objection? Yes, please.
So did you miss me? I see we've hit a break again. Defense is reaching? Oh, I've been missing all the cross. That's true. I've missed the entire cross so far. Has it been glorious? Has it been epic? How's the cross-examination going? Is it going super well? Is it everything that you hoped for? Should we go back and watch it together? I missed the entire cross so far. Has defense been doing a really good job? Have they exposed some issues that somehow I wasn't able to contemplate? You know, it's not like that I don't get surprised sometimes. You know, I can't necessarily foresee everything. You know, so sometimes I get surprised. You know, because it's like, you know, especially because you're not, of course, like in it, right? And so when you're viewing things from outside, sometimes you can't see what's in it because you're not there, right? So I do get surprised sometimes. Is this one of those cases? Have I been surprised? Is the defense doing super duper well? Did they come up with a theory that has surpassed my expectations or my dreams? Is it going super well? Wah, 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 summarizes it? Yeah, that sounds about right. Yeah, that sounds about right. Oh, was the defense trying to claim that because they reported the messages, that makes it okay? Well, I mean, I suppose that is a factor in mitigation, to be fair. I'll give him that. It is a factor in mitigation. But, you know, there's a lot of other things going on. All right, let's listen to some of this bullshit.
And so you did tell us that you're aware that Michael spoke to Tully, correct?
Correct.
And Leonard Copenrath was the major of the unit, correct?
Correct.
And he would have been Tully's boss
Yes, sir.
I'm gonna have to ask you to repeat that question.
I'm sorry.
I'm gonna ask you to repeat the question to the recording.
Of course, to my further credit, even attorneys that are in it get
You're
surprised
aware that,
sometimes.
Glenda Coffey-
Although that hopefully happens less, but it does happen sometimes. Usually when that happens because the client lied to you or something like that, but it does happen. Yeah, usually at that point it's the client's fault.
And this meeting on February 8th, you were not present at that, correct?
I was not.
So you don't know who was there?
I don't.
Thank you, Lone Star Living. I'm feeling good. I'm feeling good. The workouts are treating me well. I overdid it yesterday, though. Totes overdid it yesterday.
Did you ever speak to Major Coppenrath?
But, you know, we're making progress, and we're going to get back into it, baby.
Matter.
Woo!
And just to go up the chain.
And any time that hair medication wants to kick in,
Lieutenant.
you know, minoxidil and whatever else is I'm taking, anytime that stuff wants to start kicking in and give me my hair back, will also be just fine. Thank you very much.
Were you aware?
My doctor said 3 months. I'm not sure it's been one yet. We have a while to go.
Briefed by the DA's office in late February of the text messages.
I don't know when he was, but I'm aware that he was briefed, yes.
And you were aware that he was given specific details.
I am aware of that.
And so March 4th of 24 comes.
I feel a lot better too, incidentally.
With all the people we discussed.
Especially since I started taking that new antidepressive.
Begins on March 4th.
PAX, I think, Paxil. Is that an antidepressive? Since I started taking that like 2 months ago, I've really been in a lot better spirits. The antidepressive is working great.
25. That would be
Excellent.
Exhibit 25.
Yeah. The dark thoughts don't come as much. It's nice.
Yes, sir.
And so we've seen already that a notice of the investigation was delivered to Michael Proctor, correct?
Yes.
So as of March 4th, he's on investigation.
Correct.
And you're familiar with Respondent's Exhibit 25, which is Article 6 of the Rules and Regulations of the Department?
Yes, sir.
And for the Commission, it's R0658. And what is Article 6?
So it's the regulations that establish the disciplinary procedures and temporary relief from duty.
All right. And so it covers temporary relief from duty, correct?
Yes.
It covers duty status hearings, correct?
Yes.
And then it covers other disciplinary matters such as charges and disposition, correct?
Yes, sir.
And letters of counseling, correct?
Yes.
And also hearings on charges, the department prosecutor, and trial boards, correct?
Yes.
So there's a lot in here, is there not?
There is.
6.8, deputy superintendent's action. 6.9, judgments and discipline, correct?
Yes, sir.
And on page R0665, this is promulgated by John Mon, Colonel Superintendent, correct, in September 27 to 23, was revised.
Yes, sir.
Is it fair to say another version pretty similar to this existed before September 23?
I would assume so, yes.
And so, if you could look at Article 6, it empowers the colonel in 6.1 to relieve a trooper from duty, correct?
Yes, sir.
And Michael Proctor was not relieved of duty on March 4th of 24, was he?
He was not.
So that was the colonel's decision?
Yes, sir.
Okay. And could you look at 6.2 on R0659?
There.
So 6.2 reads duty status hearing, correct?
It does.
And it tells us 6.2.1, a division commander, with the approval of the colonel superintendent, may convene a duty status hearing relative to the member's duty status if, item 1, the member is the subject of a criminal investigation, is arrested or indicted, or if a criminal complaint or warrant is issued against the member, semicolon. Or 2, the member is the subject of an internal investigation. And I'll stop there.
That is correct.
And so a duty status hearing can be convened to change a trooper's status upon the opening of an internal investigation, correct?
Correct.
And the colonel has that discretion.
He does.
And so on March 4th, Mike Proctor was notified of this internal investigation about these text messages, correct?
Correct.
He was not relieved of duty.
He was not.
And he was not the subject of a duty status hearing.
He was not.
And he was not suspended without pay.
Correct.
Instead, he remained on full duty, correct?
He did.
Contrary to that email that we saw earlier, he was not transferred out of the DA's office, correct?
He was not.
And so what was Michael Proctor's title as of February through July 1st of 24?
Trooper.
Detective?
Yes, he was assigned to that SPDU, yes.
Okay. And so it's fair to say, is it not, sir, that he remained on full duty, being investigating homicides from February 1st until July 1st?
I don't know what his role was there, but he stayed with the unit.
Okay. And could you go to Appellant's Exhibit 6?
Exhibit 6, you said?
Appellant 6. It's APP 0012.
Okay, sir.
And do you have that in front of you?
I do.
And is this an email?
It is.
And it's from a David Procopio. Who's David Procopio?
He worked in the media section.
Media relations?
Yes, sir.
Okay. So this is an email from him to Elaine Driscoll. Who is Elaine Driscoll?
I don't know, sir.
And also to, it says EPS. Do you know what EPS is?
I don't.
And it's also to Siobhan Kelly, who's Deputy Legal Counsel, correct?
Yes.
And it's dated March 13th, 2024 at 5:13 p.m.?
It is.
And the subject of it is statement for review, correct?
It is, yes.
And it says, good afternoon, does this sound okay? The MSP has opened an internal investigation into an alleged violation of department policy by Trooper Michael Proctor. Trooper Proctor remains on full duty. Dave Procopio, Director, Media Communications, Mass State Police. Did I read that correctly?
You did.
So Michael Proctor remained on full duty as a detective in the homicide division. The colonel could have suspended him without pay or relieved him of duty, correct?
He could have, yes.
But the state police found it necessary to notify the media that an investigation had been opened.
That's how it appears, yes, sir.
Does that happen very often, that the department notifies the media about an internal investigation?
I wouldn't be.
There's another way to ask Mr. Conley. Objection. Another question.
I wouldn't be able to speak to that, sir.
Well, you've investigated 25, 30 cases, right? How many of those have been, when the investigation has started, how many of those 25 or 30 have been displayed to the media upon the opening of the investigation?
I wouldn't be able to put a number on it, sir, but it has happened.
Other than this case?
Yes, sir.
Once?
Again, I wouldn't be able to put a number on it. It's not something that I'm involved in, and I don't pay attention to that.
Okay.
Are you upset about not being able to get the answers you want? Aww. Now you know how we all feel. Not fun when you're on the wrong side of it, or is it?
All right, and so DLT, could we go to Respondents Exhibit 18, which is your report again?
Yes, sir.
This guy's going to go to federal court. The First Circuit Court of Appeals is going to have to write a bullshit opinion about this someday. God damn.
And so this is Respondents Exhibit 18, looking at page 2, which is APPRO, I think it's 491, 492.
In there.
And so paragraph 4, which you discussed on direct exam, you have that in front of you?
I do.
And this concerned your words, in addition to the information provided concerning text messages sent by Trooper Proctor, there were concerns raised as a result of the federal investigation that Trooper Proctor had personal relationship with witnesses involved in the investigation, correct?
Yes.
An inquiry was conducted by the department to determine if any substantial relationship existed between Trooper Proctor and witnesses related to the investigation, correct?
Correct.
So this investigation was separate from yours?
Yes, it was.
Why did the department choose to have separate investigations, do you know?
I couldn't speak to that, sir.
And so you learned of and who conducted this investigation?
So it was an inquiry, I believe, and it was at the time Captain Benson and Captain Barrios.
And those, Captain Benson was in the chain of command for Division of Investigative Services, correct?
He was, yes.
And was Captain Barrios also in that chain of command?
No, he was not.
Okay. And are you aware that Michael Proctor voluntarily went in for an interview with those two gentlemen?
I'm aware that he was interviewed, yes.
And he wasn't ordered to go in?
I don't know how it came to be.
Okay,
sir.
fair enough. Well, in any event, you are aware of the outcome of the investigation, correct?
Yes, sir.
Because you tell us that the inquiry showed that while Trooper Proctor had a relationship with some of the witnesses, those relationships were not substantial in nature, correct?
Correct.
And you go on to tell us that the inquiry found that the relationships were consistent with how Trooper Proctor represented them in the federal investigation, and it was also consistent with how Trooper Proctor portrayed them in his testimony in the criminal trial against Ms. Reed, correct?
Correct.
And there was a separate case number assigned, correct?
Yes.
And this separate investigation was requested by the Norfolk County DA's office, was it not?
I don't believe that to be true, sir.
Who cares?
And have you ever seen a completed report on that?
I have not.
And are you aware that that investigation was conducted in March of '24?
Yes, I believe that to be true.
So the nature and the scope of that invest by Benson and Barrios was related to the allegation of inappropriate personal relationships.
Correct.
Okay. And related to any bias he may have.
Correct.
And there was no finding of inappropriate relationships or bias by those two gentlemen, was there?
No, there were not.
So despite this wild allegation of a grand conspiracy, they found there was not, correct?
Objection. Mr. Wyman, you can word that differently.
Well, there was a theory presented by the defense in the Reed case that there was a conspiracy, correct?
I don't think I can speak to that, sir. That was information I learned well after the investigation.
There you go. Fair enough.
But there was no finding of a conspiracy by Benson and Barrios, was there?
No, there was not.
So it's fair to say, is it not, DLT, that any relationship that he had, that Mike Proctor had with any witnesses, did not affect the integrity of his investigation?
Ooh, I don't know about that.
And the trial for the Karen Reed #1 started April 29th of '24.
I believe that to be true, yes.
And so the Benson Barrios investigation was done 3-4 weeks before the beginning of that trial, correct?
Yes, sir.
And did you attend the trial?
I did not.
You watched it on live stream?
I did.
With uncivil law?
And so you listened to Michael Proctor's testimony?
I did.
And then you saved the videos for this case?
I did.
And that's what we've been watching all morning?
Yes, sir.
And you created a summary of his testimony, correct?
I did.
And that was one of the department's exhibits here today, Exhibit 8, correct?
Yes.
And so you had all of the text messages that we watched on video summarized in a neat fashion in Exhibit 8, correct?
Yes. As one does. What are you trying to accuse us of?
Those texts were presented initially by the DA, correct, in the trial?
Yes, sir.
And then they were highlighted, were they not, by Attorney Jackson?
They were.
In a very theatrical way?
Your words, sir.
Okay. And Michael Proctor admitted that the texts were unprofessional, correct?
He did.
Immature,
Yes.
juvenile,
Yes.
and offensive.
Yes.
Texts on a personal cell phone.
Correct.
He didn't deny his texts.
He did not.
Have you ever seen the full thread of text messages, the hundreds of thousands of text messages?
I have not, no.
Is it fair to say, DLT, that it was not Michael Proctor's intention for his personal thoughts on his personal phone to be published to the world?
Correct, yes.
And the text to his friends were sent late in the day on January 29th of 22, correct?
Yes.
And fair to say that they were sent after a full day of investigation into the Reed case?
I would assume it was a full day. Again, I wasn't present for the invest.
Are you aware he was assigned at about 6 a.m.?
I don't know when he was assigned the case.
Okay. Fair to say there were numerous law enforcement officers involved in the investigation during that day?
I wasn't there, sir. I can assume that there were, though.
And you've told us in your investigation, in your report even, you said that every text should not be taken in a literal sense. Did you say that?
To a family member, yes.
Is the defense going to try to tell me something I don't know at any point? That'd be nice.
And you're aware that this Karen Reed case, right from the outset, was extremely high profile, correct?
Yes, it was.
If you could go to Exhibit 10, Appellant's Exhibit 10, please.
Is the defense at any point going to, one, tell me something I don't know, or two, tell me something I care about?
I'm there, sir.
Do you have any relevant information to offer me in any way?
And you're aware that Michael Proctor testified on June 10th and June 12th, as you told us earlier, correct?
Yes, sir.
And you're aware there was quite a bit of media pressure on this case, correct, and on the department?
Yes, sir.
And you're aware that there was also political pressure?
I wouldn't be able to answer to that, sir.
All right. Can we look at Exhibit 10, please? And so, were you aware that on June 14th, Governor Healy made public comments and opinions about Michael Proctor and about his text messages?
Only after seeing this article at the trial board.
Okay, well, let's take a look at the article. On page APP 0073, it discusses Trooper Proctor's testimony, does it not, on June 14th?
It does.
And Governor Healy said, it's terrible. I mean, anybody looks at that, it's completely unprofessional. So she's commenting publicly on a criminal trial at the time, correct?
She is.
And she's publicly commenting on Michael Proctor's text messages, correct?
Correct.
And could you look at Appellant's Exhibit 11, please, which is APP 0076.
Why are we here in this hearing?
I'm there, sir.
I mean, I know the technical answer to that question, but what's the practical answer to that question?
Go back, I believe.
Why are we here?
I'm sorry, the bottom, it works backwards on an email. The first email is for...
Do I need to be here for this?
See that?
I do.
Who is Timothy McGurk?
He works in our media relations section.
Did he take the place of David Procopio?
I'm not sure how it worked out, but he's there now.
Okay. And the date of this email is Saturday, June 15th at 4:11 p.m., correct?
Correct.
So this would have been after Michael Proctor's testimony, correct?
Yes.
And this is an email from Mr. McGurk to Colonel Mon, Deputy Pinkham, correct?
Yes.
And copied on the email is Jen Staples, Brian Connors, Siobhan Kelly, Mark Wheeler. Who's Mark Wheeler?
At the time, Mark Wheeler was the chief of staff to Colonel Mon.
Okay. Doug Levine, copied. Who's Doug Levine?
Doug Levine works, I believe, in our legal section.
And then,
In the legal section.
and then also a Sean Quirk. Who's Sean Quirk?
Sean Quirk worked in the media relations section at the time. Media relations.
And so this is copied to all those people, correct?
Correct.
And it's on a Saturday afternoon, and the subject is for review and approval, Boston Herald Inquiry, correct?
Yes.
And it reads, good afternoon, Colonel, Lieutenant Colonel, and team. Please, below, please find a proposed response to the Boston Herald on an inquiry media relations received late yesterday. If this group can provide feedback before 8 p.m. this evening, I'd like to send our proposal to EOPS for approval as soon as possible. Thanks for prioritizing this in advance. Tim, did I read that correctly?
You did.
What is EOPS?
EOPS is the state agency or the state organization that oversees the state police.
And below that, there are a series of questions from a reporter from apparently the Boston Herald, correct?
Yes.
4 questions.
Yes, sir.
And the proposed response below that from Mr. McGurk is, Joe, thanks for your inquiry. Colonel Mon is aware of the proceedings and the reaction of many. Here is a statement which you can attribute to him. And it reads, while the Massachusetts State Police remains committed to respecting the integrity of the ongoing criminal trial and our own internal affairs investigation, I share the outrage and acknowledge the concerns surrounding the contemptible and disparaging text messages that emerged at the trial. Any form of police misconduct undermines the public trust we earn and depend on to effectively accomplish our mission. Despite the example of honest, hardworking women and men in our ranks, my leaders understand that more must be done to uphold the higher standards of professionalism. / Colonel John Mon, correct?
Correct.
And then below that, here is some background that may be helpful to you in your reporting to answer some of the questions, correct?
Yes.
All right. And so that's a proposed statement, and then at the top of APP 00876, there is an email back from John Mon, correct?
Yes.
John Mon is Colonel Mon, correct?
Yes.
And he sends that back to Timothy McGurk and Deputy Pinkham, correct?
He did.
And copied on that is Jennifer Staples, Brian Connors, Siobhan Kelly, Mark Wheeler, Doug Levine, and Sean Quirk, correct?
Correct.
And the subject is for review and approval, Boston Herald Inquiry. So Colonel Mon makes one change, correct?
So I don't know if that was meant as a change. I can see that he quoted a line in there.
He says, quote, as leaders, we understand that more, correct?
Yes.
All right, so it appears from that it's been sent to Colonel Mon for his review, and he's read it, correct?
Yes.
And so after Michael Proctor's testimony, it's fair to say that the governor had publicly commented, right?
She did.
Media outlets were calling the department about this, correct?
Yes.
And then on July 1st, there was a mistrial declared, correct?
Yes.
Mistrial in the trial of Karen Reed.
That's correct.
And could you go to Appellant's Exhibit 18, please, APP 0103.
I'm there, sir.
So this is an email as well, correct?
It is.
Dated July 2nd, 24?
Yes.
7 a.m. in the morning, right?
Correct.
From Timothy McGurk, he's in media relations, correct?
He is.
And it's to MSPDL Communications Working Group EPS. Do you know who that is?
I do not.
But Mr. McGurk says, very busy day for media relations. We really appreciate the collaboration with our colleagues in legal, whose guidance helped us secure lots of good coverage last night. TM, correct?
Yes.
And then Colonel Wan's statement on the mistrial in the Commonwealth versus Reed case, it appears to have been provided to about a dozen news outlets, correct?
It
Email?
does, yes.
And that's a press release that Colonel Wan made on July 1st, the previous day, correct?
Yes.
And so below that, there is a State House News Service email as well that's attached to this, correct?
There is.
And that's, it says, Campbell defends state police, mum on colonel pick, by Chris Lazinski, correct?
Yes.
And it reads, the state's top prosecutor does not want to weigh in on whether the next head of the Massachusetts State Police should come from outside the department, racked by a series of scandals. Did I read that correct?
You did.
Attorney General Andrea Campbell criticized the conduct of Trooper Michael Proctor, the lead investigator in the Karen Reed murder case, who sent crude text messages about Reed's appearance and potential guilt. Did I read that correct?
You did.
A.G. Campbell goes on to say the conduct by that state trooper in that case is absolutely unacceptable. The commentary was vile. It was just horrific, to say the least. Campbell said in an interview on WCBB's On the Record that aired Sunday. State police have the obligation, of course, to continue to build trust, to maintain that trust. He clearly has broken that by his conduct before and during his prosecution. At the end of the day, there's a process within the state police to evaluate and to hold him accountable. And he should absolutely be held accountable. Did I read that correctly?
You did.
So is it fair to say that the day after Michael Proctor is relieved of duty, the Attorney General of Massachusetts is publicly commenting on this?
It appears that way, sir.
Now, could you go to Appellant's Exhibit 14?
What was it?
Appellant's Exhibit 14.
14.
I'm sorry, 15 first.
I'm there, sir.
All right. What is this Exhibit 15?
This is the letter, a to-from letter composed from Detective Captain Gerald Collins. The subject is Trooper Michael Proctor, relief of duty.
Okay. And it's, now July 1st was the date of the mistrial in the Reed case, correct?
Yes.
And this relief of duty, it's called a to-from, right? A memo,
it is,
internal
yes.
memo. And it's from Detective Captain Gerald P. Collins, correct?
Yes.
To Leonard Copenrath, the major of the Division of Investigative Services, correct?
Yes, sir.
And also to Lieutenant Colonel Brian Connors, who opened the investigation 3 months earlier, correct?
Yes, sir.
Dated July 1st, same day as the mistrial. And it says that on Monday, July 1st, at approximately 19:25 hours, that would be military 7:25 p.m., correct?
Correct.
I, Detective Captain Gerald P. Collins, relieved Trooper Michael Proctor of duty and advised him that he was on administrative leave with pay pending a duty status hearing. Did I read that correctly?
You did.
So is it fair to say, DLT, that within hours after the mistrial in the Reed case, Mike Proctor gets relieved of duty?
Yes, sir.
And we already went through the fact that this could have happened back in March, correct, under the articles?
Yes, sir.
Now, if you could turn back to Exhibit 14, Appellant's Exhibit 14, APP 0085. Tell me when you're ready.
Okay. I'm ready, sir.
Very good. What is this, sir?
This is it looks like a press release titled Colonel Wan's Statement Following the Mistrial in Commonwealth versus Karen Reed.
Okay. And it's from Colonel Wan, correct?
Yes, sir.
And this is dated July 1st, correct?
I don't see a date on it. Unless I'm missing it, I don't see a date.
Well, you testified about this in the trial board, do you recall?
I remember talking about this document. I don't remember the date that it was, though, sir.
All right, well, let's read it, that will answer the question about the date.
Yes, sir.
The first paragraph, first of all, it's from Colonel Mott, correct?
Correct.
All right. And it's a public statement, a press release?
Yes, sir.
And the first paragraph is referring to the O'Keefe family and the tragedy that they have undergone, correct?
Yes.
And then in the second paragraph, it says, upon learning today's result, does that suggest to you that it's July 1st?
It does.
Upon learning today's result, the department took immediate action to relieve Trooper Michael Proctor of duty and formally transfer him out of the Norfolk County District Attorney's Office, State Police Detectives Unit. This follows our previous decision to open an internal affairs investigation after information about serious misconduct emerged in testimony at the trial. This investigation is ongoing. Did I read that correctly?
You did.
And so Colonel Mon is telling the media that he has relieved Michael Proctor of duty after learning of the mistrial, correct?
Correct.
So July 1st, 24 becomes a very important date for Michael Proctor, does it not?
Yes, sir.
Objection.
Mr. Carlin?
This is cross-exam.
Sir, I guess Mr. Carlin. Mr. Carlin?
Of what possible relevance is Detective Lieutenant Dwyer's speculation about whether or not that was an important day to Michael Proctor? Of what possible relevance to the existing proceedings?
These are good questions.
That's a rephrase your question, Mr. Lieutenant.
Michael Proctor was relieved of duty on July 1st, correct?
Correct.
The mistrial and the retrial was July 1st, correct?
Correct.
And so, July 1st, when a trooper gets relieved of duty, becomes a very important date for him, does it not? Objection.
Again, Mr. Moynihan, it's the same question.
May we approach?
You may approach.
Richard in chat wants to discuss my ongoing lawsuit representing my client in the Western District. We have two sets of defense attorneys. One just filed a straight answer. The other filed an answer with counterclaims, which I have moved to dismiss and moved to strike. They obviously could file to dismiss at some later time, post-discovery. I don't really know, nor do I really care why they haven't moved to dismiss at this time. They can move to dismiss at a later time, and I'll deal with it then. Whatever. Makes no difference to me. We can do it now. We can do it later. We cannot do it at all. I don't really care. Whatever makes you guys happy. Apparently, both sides want to proceed with discovery for at least the moment. It's like, okay, we can do that too. That's fine. I shouldn't talk about the case. Well, I'm talking about things that are on the public record, Richard. So, whatever. I mean, I'm talking about things that are on the public record. I've just literally described what's on the docket. It's not exactly a secret. Also, it's not really my case. It's my client's case, and that's not the same thing. Yeah, it's not exactly a secret, Richard. You can go look it up. It's on the docket. Like, well, yeah, I filed, and one side filed an answer, and one side filed an answer with counterclaims. I filed a response to strike and dismiss. This is just on the record. It's like, it's not a secret, man. They haven't moved to dismiss under 12b6 yet. Maybe they'll move to dismiss later. Maybe they won't. Who cares? Either way, it's fine by me. Yeah. Yeah, I mean, it's like, yeah, I'm just describing literally what's on the public docket. It's like, here's what's on the docket. The judge has ordered the parties to try to negotiate a a schedule. We are in the process of negotiating a schedule. If that's exciting inside information, which you could probably deduce from the fact the judge ordered it. So we're currently negotiating a scheduling. Is that exciting inside information? Ooh. Yeah. Yeah. It's like, yeah. Saying I knew better than the judge about my defective motions? Well, you're talking about an old thing, right? You're talking about that. And also, I can read the rule. So the judge had the prerogative, but it was, I didn't care. I mean, it didn't matter to me. So yeah, like I filed a motion to, what was it? I filed a motion to amend, I think. Yeah, I filed a motion to amend, and the judge struck it down because I didn't, or the clerk did, whichever one, because of failure to confer, which isn't mandatory under the rule. But the judge or clerk decided to impose the rule. I'm like, fine, no problem. We can do this a different way. I don't know what we're arguing about anymore. What are we discussing? I don't get it. The things are proceeding basically the way I would have anticipated. Yeah, I don't know. I feel reasonably positive about our position. I can't say how the other parties do or do not feel about the strength of their position, but I feel reasonably strong about our position. I do anticipate that in the event that they move to dismiss, I do anticipate they will be probably partially successful, but I've already anticipated that. So, we'll deal with it one step at a time. I mean, well, I guess I should state it softer. It's not that I've anticipated they will succeed. It's that I've anticipated that the probabilities could favor them, right? So you're doing like a calculation in your mind about what the probabilities of like the judge assessing things one way or another were success in parts. And like, so I have, of course, as one does, spotted weaknesses in my own position because I'm not an idiot. And I've anticipated at least some of my responses to some of their responses, right? Because you game this out like as much as you can in chess. And it's like, okay, here's where I think I'm weak. Here's where I would attack myself. Here's how I'd respond to that, and so forth and so on, as one does. What are we discussing again? I'm confused. Yeah. Yeah.
Could we go to Appellant's Exhibit 16?
Of course. The real kicker, of course, is in such things. The real kicker in such things is sometimes you are surprised by where you think you're weak, the opponent thinks you're strong, and where you think you're strong, the opponent thinks you're weak. So my assessment of where I think I might be weak may or may not correspond in any respect to where my opponent thinks I'm weak. And so we'll respond to that as things develop, as one does. Like a competent attorney, right? I was like, well, here's where I think I'm weak. Here's how I can rebuild it. Here's where I'm anticipating, and so forth. And so, I don't even know what we're talking about anymore. This is all dumb. This is incredibly dumb discussion.
It would be APP 0090.
No, sir.
And so, were you aware that after the department relieved Michael Proctor of duty that the governor was again weighing in publicly on the decision?
Again, not when this article came out, but yes, I became aware of this article.
And so looking at this article, APP 0090, Governor Healy said in the press that the state police, quote, made the right decision, end quote, made the right decision by relieving Michael Proctor of duty.
Yeah, transactional immunity?
Yes.
Yep, exactly.
then-
You're talking about the Adelson case or whatever? Yeah, transactional use. Transactional immunity. Yeah. The immunity comes in two different well, no. She doesn't have transactional immunity. You're wrong. She doesn't have transactional immunity. She has use and derivative use immunity. Yeah, I'm almost positive. If you're talking about the Donald Adelson case, if you're talking about the wife who's testified, I'm 99% positive the wife does not have transactional immunity. I am 99% positive she has use and derivative use immunity. So she could be tried at some point in the future if they can develop evidence against her independent of her testimony. Yeah. So that's the difference. Yeah. Use and derivative use immunity just prevents them from using anything she says or anything derived from what she says. But if they can find evidence independent of that, they can still prosecute her at a later time. As opposed to transactional immunity, where they wouldn't be able to prosecute her no matter what they discovered. So yeah, I'm 99% sure that they gave her use and derivative use immunity. So yep, that's where we're at. Yep, but I'm here to help. And Google said, I think Google's wrong. Yeah, I think Google's wrong. I don't think they gave her transactional. I believe they gave her use and derivative use. I could double check, but I don't think they gave her transactional. Yeah.
At the article on page APP 0091, Governor Healy, again, this is on July 2nd, the day after the relief of duty, Governor Healy stated publicly, the Colonel made the right decision. I fully support the decision by MSP on this. As you know, it's under internal investigation, and that process will have to go forward. This was the right move to remove him. This is a process. We have to wait for that process to go forward. Did I read that correctly?
You did.
Now, is it fair to say, sir, that the state police wanted to move quickly with the disciplinary process of Michael Proctor?
Objection. I'm sorry. What the agency wanted is not an appropriate question to be asking what the agency wanted. What does that even mean?
Can you just rephrase that, Mr. Moynihan?
Were you told that the Mass State Police wanted to move quickly with this investigation?
I was not.
Were you aware that, July 1st was a holiday week, correct?
Yes, sir.
And were you aware that the state police wanted to convene the duty status hearing within a day or two after his relief of duty for the holiday?
I wouldn't know that, sir. I'm not involved in that process.
Were you aware that that week Michael Proctor was in California?
I had learned that afterwards, yes.
Were you aware that I was away that week as well?
I did not know that.
Are you aware that the duty status hearing was held on July 8th?
I believe that to be the date, yes, sir.
Could you go to Appellant's Exhibit 17? Which is APP 0106.
Yes, 17, you said, sir?
17. And is this a notice of the duty status hearing?
Yes, sir, it appears to be.
And what's the date on that?
July 2nd, 2024.
And what's the date of the scheduled duty status hearing on that?
July 8th, 2024.
And are you aware that Michael Proctor had to appear virtually?
I learned that after, yes.
Now, could you look at Appellant's Exhibit 55? It's APP 0365.
Okay, sir.
What is this, DLT?
Appears to be the department's policies and procedures index.
Cover sheet and then an index of all the policies and procedures?
Yes, sir.
And you're familiar with all the Mass State Police policies and procedures, correct?
Yes, sir.
And is it fair to say there's over 800 pages, and with rules and regulations, about 1,000 pages with policies and rules?
So I don't know the number, but that wouldn't surprise me if that was the number.
You know, could you look at Appellant's Exhibit 19, APP 0106?
Yes, sir.
You have that in front of you, right?
I do.
And is that an email from you?
It is.
Dated Monday, July 1st, 4/22/35, correct?
On Exhibit 19?
Yes. APP 0106.
The email I have here is dated June 26th. Oh, I'm sorry, the one at the top is the July 1st, but the forwarded message is July 26th.
Right.
On June
Did you see
26th.
that?
Yes,
APP
yes.
0106.
Yep.
Okay. And so that's an email from you, correct?
It is.
To Keith Egan?
To Colonel Shoemaker. Oh, I'm sorry.
I'm
So,
sorry, yeah,
so there's
top,
so there's
very
two
top.
email headers on there. Yes, the top one is to Keith Egan. Yes.
Okay, let's go with your method. Down the bottom first, what email is that?
That is June 26, 2024, and that is to Colonel Shoemaker and CC'd to Detective Lieutenant John Gosling.
Okay. And who is Robert Shoemaker?
Robert Shoemaker became the division commander for Division of Standards and Training.
All right. And so thinking...
Standards and Training.
So thinking back to our chart that we talked about earlier, that he would be one of the 5 lieutenant colonels?
Correct.
And what is the Division of Standards and Training?
So in that division, my unit is housed along with the training side of the house, which would be the academy, as well as a number of other units.
Is it fair to say that DST, Division of Standards and Training, is the unit of disciplinary procedures?
So that function falls under that division, but there are many functions in the division. Yes.
One of the functions of DST is OP, correct?
Correct.
And Lieutenant Colonel Shoemaker is a designee of the colonel, correct?
He would, for lack of a better term, yes. Yes.
So in lack of a better term, he'd be one of your bosses in OP, correct?
Yes.
And so wouldn't Keith Egan?
Yes.
And Keith Egan, what is his title?
Major.
And he was a major back in July?
Yes.
And so the first email on APP 0106 is from you to Robert Shoemaker, and John Goslin is copied, correct?
Correct.
And what's the subject of this?
IAS 24-0014 potential violations.
And you authored some potential violations, correct?
Correct.
For Michael Proctor's case?
Yes.
And so you mentioned on APP 0107, what is that?
That is the letter that I drafted that highlighted the possible violations.
And you mentioned possible violations, correct?
Correct.
And you mentioned in paragraph 2 of your the information that Trooper Proctor sent included information about the decedent, as well as information about potential suspects. this could be a potential violation of rules and regulation 5.23, correct?
Correct.
Now, could you look at the respondent's exhibit 24? This would be R0642643.
Yes, sir.
Do you have that in front of you?
Yes, sir.
And this is what you previously discussed on direct, and that's Article 5 of the Rules and Regulations of the State Police, correct?
Correct.
Now, you mentioned in your June 26th to from that potentially there's violation of 5.2.3, correct?
Correct.
5.23. And 5.23 is dissemination of information, correct?
Correct.
Now, Mike Proctor was never charged with that, was he?
I don't know what the specific charges were. It's not something that I'm involved in.
Okay. And down below in paragraph 3, you mention at the end of 3 about some of the text messages. This could be a potential violation of policy and procedure admin 47, bias-based policing, and admin 18, unlawful harassment / sexual harassment, correct?
Correct.
Do you know if he was ever charged with that?
Again, sir, I'm not sure what charges were because I was not involved in that.
That wasn't your call.
It was not.
And is it fair to say that as of this time, you're confronted with a case of text messages on a personal cell phone, correct?
Correct.
And so is it fair to say that you were spitballing to try to figure out what the violation might be?
Correct.
And is that because there is no Mass State Police policy concerning personal content on personal cell phones?
No, sir.
No, there isn't a policy.
No, that's not the reason why I
But is it fair to say there is not a policy of the state police concerning personal text messages on a personal cell phone?
That is correct.
And so, just going along chronologically, the duty status hearing was held on July 1st, correct?
Yes.
And if we could look at Exhibit 17. Which I believe is the personnel. And and if you could go to APP 0101, look at that.
Okay, sir.
And what is that?
It is a personnel order with Trooper Proctor's duty status.
So on that date, Michael Proctor was suspended without pay, correct?
Correct.
And is there any effect to one's health insurance when that happens?
There is.
What's the objection, Mr. Carlin?
Elements?
I'll another question. If you know, you may answer.
I believe there is, yes.
What is that?
I believe that it ceases.
Now, could you turn to Appellant's Exhibit 22, which is APP 0117? Do you have that?
Yes, sir.
Okay. And this is an email, again, from Timothy McGurk, correct?
Yes.
And he's the media relations person, correct?
Correct.
And this is subject, update on Trooper Proctor's duty status hearing. It's dated, the date of this email is Monday, July 8th, 2024 at 2:03 p.m., correct?
Correct.
And so Mr. McGurk is releasing a press release concerning the duty status hearing the same day it's held, correct?
Yes.
And he says, good afternoon, below is the latest information regarding Trooper Michael Proctor's duty status hearing. Thank you, Tim McGurk. And then he goes on to tell us about the duty status hearing. Midway down the page, he says, as previously announced, the department relieved Trooper Proctor of duty on July 1st, making him ineligible to work. Above that, on background, it reads that today the Massachusetts State Police convened a duty status hearing regarding Trooper Michael Proctor. In any duty status hearing, a board of 3 commissioned officers gather sufficient facts to reach a fair determination about whether the individual should remain on full duty, be placed on restricted duty, be suspended with pay, or be suspended without pay. During the hearing, the department could present evidence or witnesses. The trooper, who has the right to be represented by counsel, can cross-examine the department's witnesses and present evidence or witnesses of their own. Did I read that correctly?
You did.
And then he says, in Trooper Proctor's case, in bold print, the board recommended suspension without pay. Colonel Vaughn accepted the board's recommendation, making it effective immediately, correct?
Correct.
Now, is it fair to say that you met with me immediately after the duty status hearing on July 8th to discuss an interview?
He said duty.
Is it still the position that you were not told by anyone to hurry this case along?
I was not.
Have you ever met me before or after duty status hearing to immediately convene an interview?
Duty.
In any other case?
I can't recall if I did, sir.
Is it fair to say that it's highly unusual to want to schedule the interview immediately on the day of the duty status hearing?
It is not a normal practice.
Is it? Now, this was an internal investigation, correct?
Correct.
It was requested, internal meaning Lieutenant Connors requested, correct?
Yes, sir.
External would mean some civilian complained about something?
Yes, sir.
All right. So this was internal. And could you go, please, sir, to Exhibit 53?
For the appellant or the respondent?
I'm sorry, yes, appellant. 0340.
Hello, you.
Yes, sir.
All right. And so, looking at APP 0340, what do we have in front of us here?
This is the policy that governs internal department investigations.
Okay, admin 14?
Correct.
Okay. And it discusses policy on page 1, correct?
Yes.
And gives us some definitions, correct?
It does.
And then on page 2, which is APP 0341, it discusses the rights of the accused employee, correct?
It does.
In this case, it would be Trooper Proctor, correct?
Yes.
So it reads, an accused employee shall, receive a copy of the complaint, including the name of the complainant, if known, prior to any employee interrogation, correct?
Correct.
Be afforded full constitutional and other legal protections, correct?
Yes.
And be afforded the appropriate protections under the applicable collective bargaining agreements, correct?
Yes, sir.
And so Trooper Proctor, under the Admin 14, should have been afforded full constitutional protections, right?
Yes, sir.
And he should have been afforded full protection under the collective bargaining agreement, correct?
Yes, sir.
And could you go to the next, to Exhibit 52, please, which is APP 0336.
Yes, sir.
You there?
Yes, sir.
And what is this, sir?
This is Admin 15. It's the policy that oversees the Office of Professional Integrity and Accountability. The policy that oversees the Office of Professional Integrity and Accountability Investigations.
So this is kind of like the Bible for opia, correct? So to speak.
It's the policy that governs how it works, yes.
All right, governs your unit.
Correct.
And so it's titled Office of Professional Integrity and Accountability Investigations, correct?
Yes.
And the first part of it reads policy. The Office of Professional Integrity and Accountability, OPIA, in other words, investigates allegations of serious misconduct by employees of the department, or as ordered by the Office of the Superintendent or the Division of Standards and Training, correct?
Correct.
And so this policy also defines serious misconduct in the middle of the page, correct?
It does.
And serious misconduct is defined as serious misconduct includes, but is not limited to, acts of, 1, corruption, 2, criminal conduct, 3, use of excessive force, 4, civil rights violations, correct?
Correct.
Was Michael Proctor alleged to have been corrupt? Was he charged with corruption?
He was not.
Was he charged with criminal conduct?
He was not.
Was he charged with excessive force?
He was not.
Was he charged with civil rights violations?
He was not.
And on page 2 of this, which is APP 0337, it tells us about the procedure for opiate cases, correct?
It does.
And step 1, open an opiate case file, correct?
Yes.
2, notify the affected employee in writing. And
Correct.
it gives us a number of things you have to tell them, correct?
Yes.
Number 4, conduct the investigation in a timely manner, correct?
Yes, sir.
Number 5, prepare a report on the investigation for DST. Again, what is DST?
It's the Division of Standards and Training.
Okay. So that would be Lieutenant Colonel Shoemaker at the time?
Correct.
With supporting facts for each allegation and a classification of the complaint, correct?
Yes.
And then it tells us that you have 4 options: unfounded, exonerated, not sustained, or sustained, correct?
Correct.
And it tells us in paragraph 6, in accordance with Mass General Laws, Chapter 6E, Section 8, Part B, DST shall act as the designee of the colonel, correct?
Correct.
So in other words, Lieutenant Colonel Shoemaker, pursuant to this policy and General Law 6E, shall act as the designee of Colonel Mott, correct?
When it comes to matters of personal investigations, yes.
Correct. Now, when you conduct an investigation, do you normally conduct interviews of witnesses first or the subject first?
If there are witnesses to interview, they will go first.
And then after if there are witnesses to interview, you interview the subject after the witnesses during the course of your investigation.
No one fucking cares about any of these questions. Nothing matters.
Do you recall?
Why are we asking these
Do
things?
you recall in this case asking my?
I don't like the mouth flapping noises. This is all I'm hearing. Wah 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 wah. This is how you do a hearing. You talk to this guy, and then you talk to this other guy, and do this thing, and look at this thing, and talk to this other guy, and
Myself or Michael to be interviewed on the date of the duty status hearing?
I don't believe I did, sir.
Okay. Prior to that date, I mean?
Can you ask
Prior
that?
to July 1st.
No,
I'm sorry, prior to July 8th.
Prior to, can you ask the question again?
I'm sorry. July 8th was the duty status hearing, correct? We agree with that?
Correct, yes.
Do you recall speaking to me before that date about having him be interviewed on that date?
I don't recall, but it's entirely possible that I did.
Okay. But again, nobody instructed you to hurry this investigation along.
Correct.
Madam Commissioner, could I request that we maybe stop at this point? I'm sort of at a juncture here with respect to exhibits and such.
I mean, the time is now 4:19, so I think that's a good place to stop.
Thank you.
All right.
Wow, this has been really enlightening. This has been incredibly exciting. Okay, so Trooper Proctor's fucked. We knew that coming in today, and we know that coming out today. Trooper Proctor remains fucked. But I'm sure it's going to be okay. So tomorrow, they're going to have more cross-exam with this guy. I'm sure tomorrow's cross-exam will be just as enlightening as today's. Possibly some sort of redirect. I don't know if I'm going to cover tomorrow's. I honestly don't know, because I don't know if I can be bothered. And then sometime in October, Trooper Proctor is going to be able to call his witnesses to the stand, which I'm sure is going to be also just super enlightening and informative. We all know that the defense doesn't have anything, right? You understand that, right? I don't have to sit here and tell this to you, right? We all know that Proctor's team doesn't have anything to work with, right? We know that from the questions they're asking, right? You understand this, right? I don't have to explain this to you, right? If they had anything, they'd be asking actual questions. What they're asking now is some bullshit. They're asking bullshit because they don't have any actual questions. This is as good as it gets. You understand that, right? You understand this is it, right? This is the end of the rodeo, right? Just want to make sure you understand that. And I have every confidence that the remainder of their cross-examination questions, as well as any witnesses they call, will be equally enlightening in every possible sense, if not less enlightening. It's not going to get any better. You know, if I'm the hearing officer, at least it's like, well, at least I'm getting paid. That's nice. I have no idea how it's going to turn out, except for the fact I totally do. Well, I'll pretend like I don't because I'm getting paid. Oh, man. So my thought on the Adelson case? Oh, she's guilty. Yeah, she's super guilty. Yeah, I figured that out from the opening argument. Yeah, she's totes guilty. Yeah, I figured that out immediately. She is incredibly guilty. Yeah, Donald Adelson is super duper guilty. Her name were on the checks, man. Her names were on the checks. Plus, she hand wrote out like questions and answer for a potential witness with lies, right? Here's the testimony I want you to give. She put it in her handwriting. Plus, with the like Vietnam emergency, one-way trip thing. She's so incredibly guilty. Yeah, Donald Adelson is super duper incredibly guilty. Yeah, she's toast. So we can look forward to her going to jail forever. That's exciting. Yeah, she's incredibly. Yeah, with Wendy's testimony, I haven't seen Wendy's testimony. Oh, Wendy's the wife, right? Yeah, whatever. Yeah, I mean, Wendy has already testified in like the other trials too. She's already testified in like 3 or 4 other trials. So I'm sure Wendy's provision of things was equally illuminating. Yeah, no, she's completely toast. Donald Adelson is toast. This is what, the 5th conviction they're going to get out of this case now? Everyone gets convicted. Everyone gets convicted. It's easy. It's easy, right? I mean, it's super easy because she's being charged with conspiracy to commit murder for hire, right? So like all you really have to do is prove 2 things. You have to prove the agreement towards the end, which is the hiring for, the murder. You have to prove the agreement, and you have to prove the affirmative acts there too. Well, the affirmative acts there too are easy. Someone is dead, right? Someone pulled the trigger. That would be a concrete step performed by one of the conspirators. It doesn't get much more concrete than that. Someone pulled the trigger. There's your concrete step in furtherance of the conspiracy. So now all you have to do is prove the agreement, that she agreed to be part of the conspiracy. and you're there. You got text messages, you got emails, you got testimony, you got the Vietnam thing, you got the checks. You're there. You're there without breaking a sweat. You were there instantly. It's like, yeah, instantly. And the defense's grand opening was, the defense's grand opening was burden of proof, which is never a great sign, right? It is the last refuge of the defense. It's always the last thing in their bag. When all else fails, you always have burden of proof. But when it's what you're going with, it's not necessarily great. It's not great. It's not. So the prosecution's like, we have emails and we have text messages and we have checks written by her, and we have a proposed witness statement, that's full of lies in her handwriting, and we have the Vietnam thing, and we have so forth and so on, and all the rest of it. And the defense is like, yeah, but remain skeptical and like keep an open mind. I'm like, oh, she's toast. She's incredibly toast. It's over. It's all over but the crying. It's like, I know instantly. It's all over. Yeah. So I could tell from the openings it was toast. Also, the defense opening was also particularly great, and I particularly enjoyed it because the defense spent a not inconsequential part of their opening saying things like, the prosecution is right about many things. The prosecution is right about many of the details of the conspiracy. Prosecution's got this, man. They know a lot of things, man. They're really good. They can prove it. Not so much can as have, incidentally. Not so much can prove it as have proven it, because the many convictions already. But they're totally good. But just not this part though. This part they're just off their rocker. Sure they are. So yeah. Dawn Anderson is going down. She's going down hard. So I'll catch up with you in 2 weeks when she's convicted, I guess. Because that's the end of that story. Defense's opening was not. Yeah, when you spend a good third to 40% of your opening praising the prosecution, it's not necessarily the greatest. Oh, and then they also spent a really inordinate amount of time saying how great the victim was in their own opening. This is like a bizarre plan. They spent a very significant amount of time saying how great the victim was. Beloved teacher, beloved professor, teach lots of peoples at the school, well beloved by his colleagues. He teaches courses outside of the school. Everyone loves him. He's a great father, does everything around it he can possibly to do around his children. Even when he's not with custody, he talks to them, on Skype, just to try to get as much time with them as he can. It's just a great father, dotes on them, works hard, respected, loved. He's the greatest guy who's ever lived. So yeah, the prosecution is right and the victim was wonderful. These are really great things that you want to say in your defense opening. Let me tell you what. Woof. Yeah, that was a lot. Yeah, he was a really great father, really great teacher, beloved by everyone, honest, good man, respectable, good in his craft. The defense lawyer actually said, I didn't know him, but I wish I had. What? Yeah, he sounds like the greatest. I never knew him, says the defense lawyer, but I really wish I had. He sounds like a good colleague, man. What? Yeah, great colleague, well respected. Students love him. Professors at his other schools love him. Teaches courses. He's really respected in his trade. Loves his kids. Wants to spend as much time with them as possible. Always diligent. Always takes care of them. When he's not in custody, he talks to them on video chat so he can spend more time with them. Loves them very much. Also, the prosecution's really got this story. The prosecution's really got this down, man. Wow, they're right about so many things. They're right about who did the murder, who did the shooting, the people with the car. They're right about the car. They're right about, you know, this guy who paid him and this other guy. Man, the state is really good, man. They know so many things, and they're right about so many things. They just are really great. They've done such a great job. Their investigation was wonderful. They've really pieced this together, man. Woof. This is awesome. Also, just really, what I really want you to do is just really pay attention to the evidence. That's all I want. What I really want you to do is maintain a skeptical mind and maintain skepticism. And I just really want you to carefully look at the evidence and keep an open mind. Thank you. That was the defense's opening. That was their opening. It went that well. It was great. It was fantastic. So yeah, the prosecutor's like, here's the evidence we have, right? We have the checks, we have the text messages, we have the emails, we have the other co-conspirators. You know, we have her on a flight, we have her with the handwritten message, the handwritten testimony to get the other witness to lie. We have, you know, we have her, this is all we have all these things. This is how we know she did the bad thing. Defense is like, keep an open mind though. You'll see. Yeah, she's toast. She's super toast. She's rye. I'm whatever. Yeah. So Donald Adelson is super duper toast. The only thing that she has going for her is her own mind, right? The only thing that she has going for her, at least in her own victim complex, is her belief that because she very deliberately, apparently, tried to separate herself from the trigger, she's less bad, right? Because she is not like, they compartmentalize themselves, right? They compartmentalize themselves, you know? So like, I only talk to you, you only talk to them, they only talk to so-and-so, right? So to try to compartment, I mean, they tried to make an effort to cover the tracks. They actually did a half decent job at it too, right? You know, it's like, we're going to use a Prius, which is a completely innocuous car. You know, we're going to use a revolver so it doesn't leave any, you know, ammo behind. We're going to turn off our cell phones so they can't. I mean, these guys tried. You know, they put some effort into it. They put some effort into it. And the only thing Donald Allison has going for is like, I didn't know, which is kind of true, but also not really. It's like, you didn't know because you didn't want to know. And that's what we call willful blindness, right? You didn't want to know because you didn't want to like talk to the gunman. You wanted to talk to the guy who talked to the guy who talked to the gunman. Yeah, well, welcome to conspiracies, right? Congratulations on joining the conspiracy. You knew enough about what was going on. You may not have wanted to know the details, but you knew enough about what was going on. You chose to join the conspiracy, and, you know, sucks to be you. So guess what? You're now guilty of first-degree murder. But I didn't pull the trigger. Yeah, you don't have to. Everyone's guilty of first-degree murder. It's great. Everyone's guilty of first-degree murder. They're all guilty. It's fantastic. Donald Allison is toast. She will die in prison. It's very sad. Yeah. The judge is doing a good job of avoiding an appeal. Yeah, yeah, no. I don't think so. Yeah, I don't worry about it. You have cases where conspirators get more than the killers? Sometimes, yeah. Sometimes the conspirators get more than the killers, depending on details, depending on who flips first. Sure. It's been known to happen. Yeah, it's been known to happen. I think I remember at least one case where the killer didn't get the death penalty, but the co-conspirator did, which is really rough. I know that's probably happened a couple times. The person who actually pulled the trigger didn't get death, but the person who hired them did. Nice, right? Yeah. So yeah, it definitely can happen depending who flips on who first. There is definitely a race in conspirators. The The game theory paradox is very real. There's very much an incentive. Who's gonna flip first? Person who flips first tends to get the prize. Yep, absolutely. Yep. So we will see how it all goes. It should be fun. All right, guys, I'm going to sign off for now, take a break. I'm going to try to hit the gym a little bit, and we'll see how it goes. I love you all. Till later. I hope all is well. Yeah, get swole. I'll try. Talk to you later. Bye-bye.